Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
We'll bring the jury.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Is that correct?
Oh, for Trump's sake. I didn't ask you to interrupt me.
Good morning, good morning, good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thanks for joining us here this morning. Happy Tuesday to you. It is a beautiful day, too. It is absolutely a beautiful day. All right. Where's our... Okay, I think we're all set. All right, I don't know. How did I just barely find the next witness's compilation of reactions to the reactions to Shannon Burgess creating a new degree that she didn't have even? How did I just find that this morning? You guys are supposed to tell me. That was epic. Great job. Next witness, that was absolutely wonderful. Great compilation. All right. Good morning. Red says, I know somebody told me, and I promise you I looked, but I could not find it. Red, I'm sorry. If you did your job and then I failed on my end, but
is that correct?
It's correct. Let me tell you what I did yesterday. I bought more cables. I know a lot of this, it might come as a surprise to a few of you, but I bought the little white dongle cable right here. That should be this long, that goes between my phone and the roadcaster. I have 4 of them somewhere, and I cannot find them anywhere. It's hard to take calls when I don't have the cable that connects the phone to the audio machine. So I bought 2 more, anticipating that as soon as they arrive, I will find the other 4. But just so you know, I am, before you are concerned about me, I am the honorary vice president of all things cables and dongles for the world. That is a position I currently hold. And so that it's okay. It's not an addiction. I'm fine, I promise. And I bought some batteries. I have 4 GoPros. I thought I had 3, but I found a 4th GoPro. So I bought more batteries for more GoPros. And yesterday I took everything I needed for my little project this weekend up in Virginia, and I laid it out on the living room floor and spread it out. And then I tried to figure out, I thought it was all going to fit in a backpack. No, it fits in a large 80-gallon tote is what it fits in. I don't know how I'm going to carry this around, and it's going to be fun. Anyway, welcome, Battery Daddy. Oh my goodness, I've got all the batteries for this camera. This is a Sony a6600, which I love. Beautiful, beautiful camera. I'm not going to use this lens, but I'll use a different lens this weekend. I've got 4 batteries for that charging. I have 3 memory. Well, this little box is $700 worth of memory cards for that camera. I didn't know I had that many either. That I might have an addiction on. I buy too many memory cards. But man, they're good. They're high speed and huge. So I've got everything. I'm ready. Okay. Red, we might do catch up on this one. But not starting till after this week. So if it goes long enough, it's a long enough trial, that's one we might jump to catch up. Let's see. Can you please send me a notification when a note or verdict comes in for the case? Sunshine Mitch. Here's what I'll do. I will try. I will send out what's called a post, a notification on YouTube, and somebody needs to remind me so I don't forget. It will be a post on my YouTube to say this verdict. That's if it happens this morning. If it happens this afternoon, we'll do a new live stream. So as long as you have the subscribe button checked, which I know you do because you're talking in chat, that's a pre-requirement. And and you've rung the bell to say all, and you have notification turned on YouTube, you should, fingers crossed here, you should get it. Anyway, Mr. RA forgets about memory cards. Got it. That's basically how it is. Yes, I'm so ready. I'm so ready. I have to be ready because all the time is up. I spent Sunday afternoon, I reprogrammed all my radios for all the frequencies we're going to use for communication, for safety, and the technical guys behind the scenes up there, because I'm providing radios for that. So we reprogrammed all those so everything will talk nicely with each other. And I need to say that the Greeners won the internet today. I forgot, Greeners. I'm sorry. Congratulations, Greeners. You were first in chat yet again. Habitual offender. I think he likes it, honestly. It's like some people who like to touch an electric fence. This is Greeners when it comes to being first in chat. Greeners, unfortunately, the law is what the law is, and whether you like it or not, I have to punish you with internet ownership. You're responsible for everything IP-related worldwide, at least the problems connected to it. They're yours. You can't like sell the internet and like make $1 billion. You can't do that, but everything else is all yours. Congratulations. I hope you're getting paid for this movie. No, it's volunteer. I love it. I love to volunteer. And seriously, I don't talk about this a lot because I think that gets rid of some of the benefit of volunteering. But I find so much enjoyment in life in volunteering in different capacities. It makes my life complete, right? There's like a big pie, a big circle. There would be a chunk out of it if I wasn't just choosing to help people in some way. So I'm not going to like try to toot my own horn, but I'm a big fan of doing that. It just, if life sucks right now, like a big part of your life is like, this is not fun, whether it's a trudging through school or a job that's not very pleasant, or you've got some health concerns and things like that. Find a little way to give to somebody else, and you'd be amazed how much it improves everything. Anyway, so this is one of those things I'm doing to balance my life, and I love doing it. I got another one tonight. I'm going to help a lady who's maybe starting a YouTube cooking channel. I can't say her name because I didn't get her permission, but we're doing a consultation on cameras and lighting and everything. And so I'm trying to find out what she has. Like, how ready are you? What do you have set up? She's like, well, I built my house with a commercial kitchen just for this purpose. I'm like, great. We're set. So the rest, we can move cameras and lights everywhere. You've got the commercial kitchen. We're ready to go. Anyway, all right. We need to do birthdays. We've got just a little bit, and by a little bit, but just a couple minutes. You remember last time we were a little bit late. So if we can do birthdays quickly this morning, that would be great. And while they're getting the birthday list ready, let me recognize a couple people who've already done awesome things this morning. First of all, Kim R. gifted a membership. Thank you very much. Kelly H. gifted a membership. Thank you, Kelly. Both of you are wonderful. Lacey, member for 10 months. Yeah. OG Sean White says, need an AI song about Scott's addiction to cables. Sean, I like this idea. I think we can run with that. Jackie C., member for 6 months, says, ooh, I got a new courthouse color. It's yellow and it looks beautiful. Jackie, thank you very much. Fire Girl, handmade by Wendy, member for 4 months. Congratulations, and congratulations on your YouTube as well. That is just awesome. Fire Girl says, thank you for all you do, RA. You have created an awesome community. I love it here. I just found you guys. You guys existed already. I just found y'all. Thank you. Let's see. It's not Mrs. RA. It's one of her friends, though. Let's see. I'm a multi-dollar heir. You don't need no money. Let's see. Tisha says, RA, I needed this today. My job's the absolute worst at this point in my life. Tisha, I am sorry. I'm really sorry. I can tell you I feel your pain. Let me tell you, well, I've had jobs I just didn't like, but as far as just work taking every minute of my day, there was a point in my life when I had 5 kids, I think, because the last one wasn't born yet. Maybe it was 4. I was going to school full time. I was working a full-time job, and 3 part-time jobs. And it was all at the same time. And oh my goodness, sleep didn't happen for like a year. It was terrible. All I can say is find a goal and work towards it. Keep making a little progress towards that goal each time. There is light at the end of the tunnel. It does get better. Look for those opportunities, and hopefully that you'll be able to look back and say, wow, remember that crappy time, and laugh about it and say, yeah, that sucked, but things are going so much better. So fingers crossed for you, and we'll keep you in our thoughts and prayers. Tisha. All right. We've got a couple people to celebrate birthdays today, so please join with me. This is one way to make your day a little bit better. Sing to somebody. We're singing to Dottie O, Mr. Bonin, Garrett, and Dorothy, all celebrating the birthdays today. So please, everyone, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbors, warm up with me if you will. La 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 la. That'll do. All right, here we go. Happy birthday to you. Happy birthday to you. Happy birthday, Dottie O, Mr. Bonin, Garrett, and Dorothy. Happy birthday to you. Here come the high kicks. While the high kicks are going, we're going to get set for court here. To everyone who's celebrating today, happy birthday. There are many wonderful days. Today is your special day. There are a million places you could have been and a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully we can turn some of that joy back to you, make your day a little more special. Begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, and Bob Evans. Here we go. Katie says, I want the drum solo, Judge. Hold off for a minute. Hold off. We've got 1 minute before she comes in. Tisha, thank you very much. I'm glad we can make your day a little brighter in some ways. All the emoji pickles right there. Old Kiwi chick, did I miss you? Happy birthday to you. Happy birthday to you. Happy birthday, old Kiwi chick. And the big tire, happy birthday to you. There we go, now drum solo. Now drum solo to finish things off. Beautiful, beautiful. All right, Judge, you can come in now. You can come in now. We're done. We will sit down. We'll be respectful in your courtroom and everything. Where are we at today? Let me tell you where we're at, actually. We are super source. Box source 4 is going to be 2 and cut. We have 6 hours on the deliberation clock so far. 6 hours, which is a lot considering that 4 hours ago in deliberation time, the jury announced that they were hopelessly deadlocked. We'll see if they made any progress whatsoever. But before they start deliberating, they are going to be called in and welcomed and said, get to work. I doubt they're going to have a note first thing. Like when the judge first calls them in, they shouldn't have a note with them because they should have delivered that last night if they did. That would be a problem if they came in and like, we have a note. Like, what was this yesterday? But I do anticipate that this morning we'll get either another note saying, no, Judge, it's for real, we're deadlocked, or we have at least partial verdict. In doing that, while we wait for court to begin, we do have some other places to go. Like we're going to go to, say, for instance, Judge McNally's court, which is always a good time. We're going to go hang out with Judge Dad a little bit. Probably not going to go drop in on Cedric Simpson today. He's doing landlord-tenant matters, which are just sad. It's somebody who's really down on their luck financially, for whatever reason. Sometimes self-inflicted, sometimes nothing. They could it could have been a health incident or a car wreck or something that caused them to be in that way, dire straits, and they're basically getting kicked out of their house, and that is just, it's depressing. I have a hard time watching that and finding any joy when the court has to do something legally that puts a bigger burden on somebody who's the least capable of carrying it. All right, can they say self-defense on 3 and manslaughter on 1? Yes, they could. They could say self-defense on 4. They could say self-defense on 2 and assault on 1 and murder on 1. They really they have the full gamut of options available to them, as they heard in great detail Thursday and Monday in the world's not the world's longest. It just seemed like the world's longest jury instructions. Can we follow Alan Jackson's next case? Beth, it's my understanding that case is out of California, which is where Alan Jackson is based. As much as I would love to follow it, California is brutal at getting access. So unless we have some heavy hitters that go in and pave the way, as far as the access goes, it's very, very difficult to get in there. Jury can do anything. They're all powerful. Yes, they could even come back with the law is bad. He's not guilty. What's that? Juror nullification? They have all sorts of options, including not coming to a conclusion, which is sad because their job is to reach a verdict. But if they are unable to reach a verdict and still hold true to their convictions as to the facts of the case and the guilt and innocence of the defendant, then the hung verdict would be correct. A hung jury would be correct. It's not a hung verdict. And then we get somebody else in there to see if they can do it. Did I turn off Super Chats? I didn't know you could even do that. I don't know why I would want to. I had a couple people say they've had trouble with Super Chats. Let's see. It shows it's on. We haven't been demonetized yet, so you guys use your best behavior. We'll try to keep that one the same. Kurt, good morning to you. Hope you're doing great. Lee, member for 29 months. Welcome to the gallery, Lee. 29. One of our great court watchers and longtime supporters of the channel. Thank you. All right. We have Kelly. I got the chats. I got the chats right here. Kelly, thank you. Sean White. Yeah, you guys are free. Feel free to everyone to test it if you'd like. I'm not gonna tell you can't. Thank you for your generosity, though. Just kidding. Thank you. I think a couple people have had some problem on some platforms with super chats because we had that yesterday as well. Big Tire says, okay, wife says big sleep is in your special day. No birthday song for you. Big Tire, I'm sorry. Happy birthday, though. What makes a chat a super chat? I don't know. This sounds like a dad joke in the mix. Tell us the answer. Kim R, thank you, with the Dolphins. Good to have the Dolphins back. I'm glad YouTube fixed that for everybody. I realized they were trying to eliminate trolls, I think. People that came into an established channel and pretended to be somebody who existed in the channel, and they aren't. But we can sniff those out pretty good. Sean White says this is for points. Buttercup, or actually Bite Me, says Buttercup sends hugs and sugars. XOXO. Thank you, Rebecca. Appreciate your generosity. Give Buttercup a treat and a pat for us. Did RA live stream the judge reading the jury note? Oh, I was supposed to. Hang on. I'm ready to do that. And by ready, I mean I'm not ready. So hold on just 1 second. I've got the parts and pieces. We just need to fire up DaVinci Resolve Studio, which is some of the world's greatest software, by the way. Love it. Kelly H says to stay ahead of greeners. It's neck and neck, Kelly. Thank you very much. Appreciate it. Uncivil Law says, never mind. I was connected through a VPN, so it disabled the option for. Oh, interesting. VPN cuts off the super chat. I wonder why. What it is about VPNs? I guess YouTube wants to see where the money's coming from. Let's see. Somebody had a right here. I know this isn't likely legal in these jury trials, but before a hung jury is declared, would it ever be considered to randomly replace jurors with alternates and see if a verdict can be achieved? Kurt, I know there have been cases where juries have replaced, or a judge has replaced juror members during deliberation. But it's my understanding there has to be a reason. You can't just like shake the magic 8 ball until something turns up, right? So you would have to have like someone's refusing to deliberate, or somebody is breaking the rules, as announced that I went by the crime scene and you know, this is what
Mercy presiding. Good morning, Your Honor.
Good morning. Good morning. Good morning, everyone. You may be seated. Thank you. We are here today to continue on with the trial of State of Connecticut versus Raul, Valle. I would ask counsel to please first place their appearances on the record for purposes of today's proceedings.
Good morning, Your Honor. Mark Joseph for the State of Connecticut.
Good morning, Your Honor. Tatiana Messina for the State of Connecticut.
Good morning, Your Honor.
exoskeleton.
Thank you very much. First, a matter to put on the record at this point in time, and then we'll call the jury in. So, counsel, as you are aware, the court received a note yesterday evening at approximately 4:45 while taking the bench to dismiss the jurors for the day. Due to the lateness regarding the hour of the day and the closure of our court facilities at 5 p.m., the court decided to address the note on the record this morning. Counsel has had the opportunity to review the note, and it will be marked as a court exhibit for ID purposes only, as it does contain the deliberative process of the jurors. The note does, however, indicate that the jury remains deadlocked as to count 1, and also cannot reach a verdict at this time as to counts 2, 3, and 4.
Wow.
It is the court's intent to instruct the jury to continue its deliberations. I did have an opportunity to informally meet with counsel in chambers this morning. It is my understanding that both the state and the defense are in agreement with instructing the jury to continue on with its deliberations, with a short instruction to the jury regarding that continued process, without at this time giving a Chip Smith charge or accepting any verdicts that may or may not have been reached.
Chip Smith is like an Allen charge.
The state is in agreement with that, Your Honor.
That's correct.
All right. So with that, I do intend to instruct the jury to continue their deliberations. I will call them in. I also had an alternate juror, just for purposes of the record, indicate that the alternate juror had a medical appointment this afternoon. As you are aware, I have not discharged the alternate jurors. That alternate juror asked to be able to leave for his appointment and or be dismissed. I know that I met with counsel informally in chambers as well relative to that issue, and it was the decision based upon conferring with counsel to allow that particular alternate juror to leave for his medical appointment, but to keep the alternate juror on board with respect to his role as an alternate juror in this case. So the jury clerk is relaying that information to that particular juror. All right, does counsel wish to be heard on that?
Nothing from the state, Your Honor.
Very good. So at this time, I would ask clerk to please bring in our jury.
All right. So there, she says she's not going to give. I'll tell you more about Chip Smith in a little bit. Chip Smith is a case. Chip Smith was a defendant charged in State v. Smith back in 1881. We'll talk about that in just a little bit. This talks about hung juries. Hung juries. Wow. They're hung on all 4 charges. And guess what? The judge did the right thing this time when the note came in. First, the note came in last night, right as they were about to leave. And the note... Sorry, it's so loud here.
All right, I would at this time ask counsel to please stipulate to the return of our jury.
State will stipulate to the presence of the jury.
Good morning, ladies and gentlemen of the jury. Thank you for returning for us today. So I do want to acknowledge that I did receive a note from you late yesterday afternoon, early evening, as I was taking the bench to dismiss you for the evening. It does appear from your note that you indicate that you are deadlocked as to count 1, so you remain deadlocked as to count 1, and also deadlocked as to certain charges at counts 2, 3, and 4. It does, however, appear to the court that you are deliberating as your duty requires. By the court's estimate, you have been deliberating a little less than 5 hours at this point in time.
They took
I
an
would
hour
simply
off.
suggest that you continue with your deliberations. Again, you should review the evidence and the position of each juror to determine if any evidence has been overlooked or any juror's position misunderstood with respect to either the evidence or the law. I remind you that you may have portions of any testimony read back to you if you deem it essential for your deliberations. You have all the full exhibits with you in the court deliberations room. Kindly explain your views and listen to the views of others. That goes for everyone. Ultimately, of course, you will make up your own mind and decide this case upon the basis of your own individual judgment and conscience. So at this time, I am going to redirect you to the jury room to continue on with your deliberations relative to this case. Thank you.
So that was not the Chip Smith charge or the Allen charge or the dynamite charge or the TUI. I forget. Every state, Kurt's right, every state has their own little case law example of this. But let me read to you a little bit from the state of Connecticut Judicial Branch.
Whether if you wish to be heard on the court's instruction to the jury.
No, Your Honor.
No, Your Honor. All right, at this time, the court will move into recess. Thank you.
All right, court's in recess.
Okay, so while they remain in recess, I'm going to start the timer because the jury is now back deliberating. I know I've got an extra hour on there. I count their lunchtime. I think they eat it together, and they might talk about it as well. So we'll see what happens. Let me go back and get just, let's see. Looking for the charge from yesterday. Or the note from yesterday. It was 2 hours in, right? Well, tell me I saved it on this one. I don't have to pull it. Might have to pull it again. I recorded a blank screen during that time. That's great. Send someone with more experience. The note from yesterday included the jury deliberative process information saying that we were hung 11-1. The note last night also included the count. But the judge says it's clear. Oh, that's WD-40. Thank you, bud. What do you need it for? You found it? Was it inside? Okay. Can put it back in the cupboard. Found the WD-40. The note included something that indicated they were still deliberating. And it's possible that note could have had a different count. Say if it was, say, 10-2. that would show that the deliberation is taking place and minds are being changed. I don't know what else it could show other than saying that we have... No, they're still hung on one. They had to have a different count. It has to be 10-2. What else would show that they deliberated? Other than that, they might have said, we're trying. That's it. Okay, Chip Smith charge. Chip Smith derives from State versus Smith in 1881. James Chip Smith was a 21-year-old who had been drinking, firing his gun, and causing a general disturbance of the peace on December 23rd, just pre-Christmas excitement in 1880. Smith's father went to the home of Daniel J. Hayes, the chief of police from the city of Ansonia, and asked him to arrest his son. Good. Dad says, hey, can arrest my son. He's being a general disturbance, drinking and fired his gun. Chief Hayes searched for Smith and found him in a downtown street. A struggle ensued, and Smith shot Hayes in the abdomen. Hayes lived for some time after being shot, and he looked up his killer himself before succumbing to his injuries. He locked up his killer. Oh, he locked him up. He's like, I've been shot, but I'm not dead yet. Locks him up. Then he dies. James Chip Smith was convicted of Hayes' murder. In an opinion reviewing Smith's convictions, this means it was an appeal, the Connecticut Supreme Court set forth language concerning the duty of jurors when deliberating. This language became known as the Chip Smith charge, and the trial courts repeatedly gave the instruction to jurors when they reported that they were deadlocked. Over the years, the Chip Smith charge became an established part of Connecticut jurisprudence. However, the instruction was often challenged as being coercive, we talked about that yesterday, and implying that a juror in the minority should give in to the majority for the sake of unanimity. In State versus O'Neill, in 2002, the instruction was challenged once again, and our old Chip Smith charge was given a new dressing. In State versus O'Neill, the defendant was on trial for murder. After some deliberation, the jurors reported to the court that they were unable to agree. The trial court delivered a Chip Smith instruction to the deadlock jury. Later that same day, the jury returned a guilty verdict. On appeal, the defendant argued the Chip Smith charge improperly pressured minority view jurors to abandon their position in favor of the position of the majority view jurors, unfairly increasing the likelihood that the defendant would be convinced. In its decision, the Connecticut Supreme Court upheld O'Neill's conviction and the use of the Chip Smith charge. However, the Supreme Court set forth a modified version of the charge to be used by trial courts in future cases. Henceforth, judges must remind jurors that they should vote their consciences and not acquiesce in the conclusion of their fellow jurors merely for the sake of arriving at a unanimous verdict. The version of the Chip Smith charge adopted for use today strikes a balance between encouraging a unanimous verdict and protecting a defendant's right to a fair trial. So Chip Smith, when they say that, think dynamite. Can they really ask a juror to change their opinion to go with the majority? No, they cannot. Unless they believe it. They can ask a juror to reconsider the evidence and see if there's something you missed that would change your mind. But they can't say, hey, look, 11 people got it right. You're probably just wrong on this one. You need to go with them. You can't do that. That's coercive. An Alan Rodriguez charge. I thought it was like Tui Rodriguez. Lots of different names. Who is Tui? Who does Tui? Alex Rodriguez. Isn't he a baseball player? What's going on with juries lately? Blatantly obvious guilty defendants are getting off via mistrials by hung juries. Well, Holly Dance, I imagine some people on the jury might say, what is wrong with juries today? Blatantly innocent people are being charged, are being convicted. So it's all a matter of perspective, I guess. I think the process itself is still good. Tui was Massachusetts. I think Tui was. I read the summary of Chip Smith. I'm not going to go back to 1881. First of all, law documents from 1881 read a little bit differently than current stuff. It's a little harder to follow. Unless useless knowledge we're acquiring, the dynamite charge changes names for each state, pretty much. Allen charge is, I think, the most uniform name that's given. It's an Allen charge by another name. It's always an Allen charge. Just call it an Allen charge. That would be too simple. This, Kurt, you know this. This is why all the states have their own bar exam, because they all do things a little bit differently in the law. And you're very familiar with Texas and Virginia. I believe you're licensed in both. But there are some states that have even the process in courts just a little bit different, even though it all follows the same pattern. And, the trial by jury and everything else, it's all the same, but it's just a little bit tweaked. Just enough to make it confusing if you were to cross a state line and try to work in a different court. Probably something you could figure out. I mean, it's all figure-outable. I agree. Once I was a young jurist in a hung jury, no air conditioning, so hot, so much debate, I gave in. I regret that to this. Oh, man, crazy cat. That's wild. Jurors have all the evidence. Being a juror would be extremely hard on the job itself, but more over personal life, I suppose. I could not do it. The TUI charge typically tells jurors to consider the opinions of their fellow jurors, recognize that another jury is unlikely to be more competent. I like that part. They're like, you are the best people to make this decision and to make a good faith effort to reach a verdict. I think I agree, Amber, that on the TUI version, it does sort of empower the jury and say, look, you are our people. You're the ones that the founders intended to have been chosen for this very task. So it's one of those, you can do this, but do it right. Is a hung jury a win for the defense? It depends, Elizabeth. I'd say if Brian Koberger had gone to trial and had been a hung jury, I'd say that would be a win for the defense. There are some cases where it appears that the defense is just looking to delay and stall and delay the inevitable. Obviously, the more time that passes between a crime and the trial, maybe people have forgotten a little bit. Maybe the furor and the keyed up tensions and the upset, people will have calmed a little bit. So when jury selection happens again the next time, you might get a more favorable jury. It's not usually a win for the prosecution. So I'd say defense would take it more readily than prosecution. But then with the defense, you just have to do it all over again, and you don't know what you're going to get next. It's a crapshoot. Don't think it's a win at all. It costs the defendant more money, so I don't think it's a win. Allen charge in Florida. Hey, Mrs. Aria is going to read to us. Oh, she's reading to the kids. Let's see. I believe juries should be majority rules. That would prevent coercion, but would be tricky if a verdict was 7-5, for example. Warrior Queen. There are some states that allow on some charges a less than unanimous verdict being sufficient. I'm trying to remember. I think Florida is one of those. I think it has to do with even death penalty. Was it on the sentencing phase in a death penalty case? Isn't it majority in Florida? Is that? Am I remembering that wrong? Civil cases have lower. Florida's one of them. Yes, that's right. Okay. My memory often fails me, but for once it held up. All right, we're going to go, while we continue watching and waiting, we're going to jump down to Judge Dad, who is getting good work done here in Michigan. So let's jump in right there. It's going to be an abrupt jump, but here we go.
Wait, just please wait.
Uh-oh. Please wait. Apparently we came in too soon.
I can't read this Brownstown Township PD to verify. Okay, I don't know what. What do you got? Go ahead. What do you want to make a record in?
All I was going to say was, despite what you said on the record last week, if I may have misheard it or if I may be wrong, regardless, the judge did order that she leave within 2 days. All I ask is that we have time to verify who's it's for. If he's saying it's not his, I don't know why the judge would order that she leaves within 2 days. All he wants is his stuff there, he's free to do a civil standby. I would just ask you to rescind that order for the complainant's sake. It just seems like retaliation and intimidation at that point to try to ask the judge to get her out.
I'm not ordering her to get out. I don't know what you want me to do. Here's what I have. No contact with Sagda Shawa.
Kim, thank you very much.
Heather, what is going on this? Can you enlighten me? I'm not going to have the victim have to leave right now. There's nothing on these papers that says the victim had to leave within 2 days. I believe you. That's what you're telling me, right?
She had said, so last Tuesday was July 1st, and she had said that she had to be out by July 3rd, by 12 noon.
Did she, sir, can you just let me, thanks.
And Judge, that is correct. What she had said, that's what Judge Heston had ordered, and for her to vacate by July 3rd by noon, and for the Brownstown PD to verify before defendant returned to the address.
Judge Heston's pretty careful. I don't think she would order the complaining witness to leave within 2 days if she wasn't convinced the complaining witness was not the leaseholder and or had no other reason to be there other than the fact. Look, I'm going to modify the order. Victim can remain in property until July 15th. Defendant allowed one visit to obtain Brownstown Police Department to obtain personal belongings. So you can't go back there without the police. You're going to have to ask them to meet you. Maybe Mr. Carmen can help you out. And you guys can pick a time. You can go in and get your own personal belongings, but that's it. In the meantime, the victim can stay, but she's going to have to be here next week. And I'm going to highlight this for her, victim to be here next Tuesday. Did I cover everything?
I believe so.
Anything else, Mr. Carmen?
Okay, Your Honor, my client told me that there was a previous civil standby. The police did not allow him in to get his stuff. His clothes were handed to him. So for clarity, we are asking that the court order another civil standby so he can.
What do you need to go back and get? This is silly. What do you need to go back and get?
I need my bed, my TV. I have to prove that I bought that from my receipts, my transaction.
I'm not getting into adjudicating personal property over this right now.
Utilities and everything is in my name now. That property over there. The only thing that is not in my name is the lease. Nothing over there that is in her name. She don't pay a bill there. I pay the bills.
You're the defendant. She's not. She's the victim. You're the defendant. I don't know what else to tell you. I don't know what else to tell you. I'm not going to adjudicate this. You can deal with Judge Heston on that. This is a mess. But I can tell you this. I'm not going to get into standing here or sitting here and saying, you get the bed, you get the end table, you get the nightstand. I don't know who owns these things. So you've already had your civil standby, right? Right?
I did, but I was.
Well, then you guys can bring it up in front of Judge Heston next week.
Whatever she handed the police, that's what I got. There was some clothes that I still didn't even get, shoes that I didn't even get.
Right, it doesn't sound like his civil standby, like his rights were, carried out.
My stuff was handed from her to the police. I was not allowed inside the property to get my stuff to see what was missing. There was some clothes missing, some shoes missing, some colognes missing. I was standing outside and she was handing the police my items and they was handing me my stuff.
I'll get the victim here next week. I really get the victim here next week. I'm not going to have another civil standby right now. Okay? If there's clothes that you thought were in there, you should have said something to the police then.
I did.
This is childish. July 15th, everybody be here. Thank you. I want her here. Kristen Nicole Wyson.
Judge, also, I'm sorry, Judge, the attorney for James Thomas is also back.
Okay, I'm going to take that one next here. This is easy. Kristen Nicole Wyson, 23T-723-538. Good morning, ma'am. Your name?
Good morning, Kristen Wyson.
Michael A. Carmen, P73824.
So we're just adjourning this. How long do you need, Mr. Carmen?
2 weeks should be more than enough.
July 22 at what time, Heather?
We can do July 22nd at 10:15.
Okay, 10:15 a.m. All right, ma'am, you can go down the hall and get your notice. Anything else, Mr. Carmen? Thank you. James Joseph Thomas, 24W726-283. And can I have Angel Rodriguez seated at the table here, please?
Mr. Driscoll's really close to us.
This has to go in the Andrew Siak file. John, that has to go in his first file. Has somebody pulled the warrant on Andrew Siak yet?
Yes, it did. It went to the MIDC attorney.
Okay.
Because it was in warrant status.
Yes, right here.
Okay, thanks. All right. Where's Ms. Fanning at?
I'm here, Your Honor.
Good morning. This is People Against James Joseph Thomas, 24W726-283-FY. Good morning, Ms. Fanning. Your name?
Good morning, Your Honor. If it pleases the court, Attorney Andrea Fanning, P42853, appearing on behalf and with my client, Mr. James Thomas.
You always have that smile going, Ms. Fanning. You got to advise all the other lawyers and judges to be like that. Mr. Thomas, your name? Mr. Thomas, your name? Can you hear me?
I don't think he can hear you.
Your Honor, what I would tell the court is that I was just recently appointed on this case. I am scheduled to have a jail visit with my client today. I've asked the prosecutor to forward to me the discovery in this case. So
I don't have any problem, but I still need him to tell me his name here. What's going on?
I can hear you now, James Joseph Thomas.
All right, so your lawyer wants an adjournment for a week. You have the right to a probable cause conference within 14 days. If I grant a request, and she needs me to grant a request because she needs time to prepare, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, sir.
Do you waive that right?
Yes.
Anybody force you to give up that right?
No.
Waivers accepted. We'll set a PCC for the 15th and the exam on the 22nd. Give me the times, Heather, please. And you're going back to Judge Heston on these, Ms. Fanning.
Okay, thank you.
On the 15th, the PCC will be at 10:30.
Okay.
Okay.
And on the 22nd, the exam will be at 11:30.
Thank you so
Ms.
much.
Fanning, anything else?
That would be great. Thank you. And Mr. Thomas, I will be seeing you today. Thank you so much.
Have a good day. Thank you.
You as well. Have a great day.
You too.
Bye-bye. Bye-bye.
Angel Rodriguez, 25T645861. A and B. Your name?
Very yellow shirt.
So you're going to plead as charged to expired plate. They're going to dismiss the no insurance. True?
Yes, sir.
Is that what you want to do?
Yes, sir.
In the charge expired plate, responsible or not responsible? Please accept it. No insurance. Excuse me. No insurance is dismissed. 135. Cash your rent of the hall. How long?
Can I pay that Tuesday?
Yep.
I pay by week.
I'll let you pay it by the 25th.
Yes,
Okay? That's next one. Or wait a minute. Yeah, wait a minute. What's today?
It's the 8th, Judge.
The 8th. I'll let you pay by the 18th. Okay? That's a week from Friday.
That sounds good.
Good luck.
Thank you, boss.
Kevin Robert Vernier.
Thank you, boss.
25F244075. Could I
He's
have
out where you're
Joseph
wearing
Morgan
stripes.
up here? Michael Dana up here. Your name, sir?
Kevin Vernier.
You're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible to that? Plea is accepted.
Got all the papers just rifling through on the desk.
150.
Thank you.
150, original charge dismissed. Any questions?
No.
Oh, no, I gotta make it 170. 170, you're all set. Cashier into the hall to your right, good luck. Joseph Matthew Morgan, come on up here, 25F244132. Are we ready on, do you have that SEAC file yet done?
Ooh,
Heather?
shorts. I like the shorts.
We gave it to the attorney judge.
Go ahead.
Your name?
Joseph Morgan.
You're gonna plead to impeding, right? Responsible or not responsible to that?
Responsible.
All right, I'll accept the plea. $150. You can go right down the end of the hall. Any questions?
I was on my way to the Elks to get them when I got pulled over. So that's all. I'm the exalted ruler there. I know you remember, so thank you.
Yeah, no problem. I got to stop in there one day.
You do?
I know, I need to. I've
Got
been
some
there.
cool things going on, Judge.
I know, I see those things on email. I'll try to stop in.
Please do.
Have a great day.
Okay, so is there any other paperwork?
Nope, you just pay the 150 and it's not going on your record.
Okay, thank you.
Have a great day.
You do the same.
Michael George Dana, 25F244230.
This court
Your
makes
name?
bank.
Michael George Dana.
All right, so you're going to plead to impeding, right?
Yes.
Responsible or not responsible?
Responsible.
Why was everybody driving around the road closed signs? Can you tell me?
Katrina, that is
I can
awesome.
tell you why I did. But,
Why?
well, first there was a sign there saying not come in with, they changed that to put a sign saying not to enter. I mean, they had barricades up, but the barricades are set west of New Hall Road. The construction is all east of New Hall Road. There was a reason why I chose to go in that direction. I knew the construction thing, but if I made the left-hand turn in, I'm not disputing that.
When's the last time you had a ticket?
I haven't had one in, I don't remember what I have a clean record.
All right,
Dismiss it. Judge, dismiss it.
150. Yes, you're into the hall to your right. You're all set. Good luck. Samantha, you too. Samantha Ann Cobb, 25F244152.
This court is a money machine. They just crank people through and charge them $150, $170.
Ard, Derek Ard will be next. Your name?
Samantha Cobb.
Hi, Ms. Cobb. You're going to plead to eating traffic. These are easy days. I want you to know. Most people walk out happy, right?
My first time ever, so we'll see.
Is it?
Yep.
The charge impeding traffic, responsible or not responsible?
Responsible.
I'll accept your plea. 150. You're all set. Cash, you're into the hall. Good luck.
Yeah.
Thank you.
It's the court's
Derek
equivalent of a
Ard.
super chat, but they can order.
How you doing, Mr. Ard? 25F244040.
No fine, Judge, how are you?
Not too bad. You're going to plead to impeding?
Yes,
To that charge, responsible or not responsible?
responsible.
All right. You need time to pay, right?
Yes.
Okay, so I'm gonna make it. I'm gonna cut it down a little bit here. 210. How much can you pay today? Anything or not? Tell me when you can pay this. We'll make it easy. Just tell me when you can pay it.
Well,
Tell me when you can pay it.
I'll definitely have it paid off by the end of the month.
I'll make it July 31. If you don't have the money, you call the court or come up here on or before that date. I'll be glad to give you an extension. Just don't ignore me, okay?
Okay, that's fine. You said you dropped it down to 210?
I did.
Okay, thank you.
Have a good day. Grace Ann Bukowski. 25T645693. How are you, Ms. Bukowski?
Hi, thank you. Judge, Your Honor.
Nice to see you.
Nice to see you.
You have to remind me, well, I shouldn't talk about that.
Apparently they know each other.
Whatever. All right, I'm just gonna take your case here. You're gonna plead to impeding, right?
Yes, sir. Yes, Your Honor.
To that charge, responsible or not responsible?
Responsible.
Impeding traffic could have been like parking in the lane when you're not supposed to. It could be
170 is your total. And you can go down the hall. Have a great day.
Going 20 miles an
Thank you
hour,
very much.
minimum 45-mile-an-hour zone.
Dear Western, Alex, ma'am, can I ask you, Grace?
Yes.
Alex,
Yes.
what happened to him?
He's living in Newport.
Okay, I just wondered. I always liked him and liked you. I was sorry to hear all that, but good luck. Thank you. John Samuel James Deerwester,
He knows her ex.
25T644889. Mr. Deerwester, how are you?
I'm doing well, Your Honor. How about yourself?
Your name? Your name?
John Samuel James Deerwester.
He's got all the names. John Samuel James Deerwester. JSJD. Hate to spoil it for you, but most of these people did not impede traffic. Most of them had a
You
higher
got to
offense.
slow down and be careful.
Yes, Your Honor.
Either be more careful and not get caught or slow down. Either one would help. Most of these people had a higher
And I
offense.
suppose that one falls outside of it. To the charge of impeding traffic, responsible or not responsible?
Responsible.
250 is your total. You can go online and pay that, all right?
May I have a little extra time, like the end of the month?
How much do you have today?
I have $20 to my name. I start a new job.
When can you pay this?
By the end of the month.
July 31. If you don't have the money, you call the court. We'll go on Zoom, or you can walk in here and I'll give you an extension, but don't ignore me, okay?
I won't, Your Honor. Thank you very much.
Gabriel Bailey Yost, 25T645704. Mr. Dubin, what case do you have in here?
Mr. Spites, Brandon Spites, he had the, sorry for interrupting, Your Honor. Mohammed had the file, but he said it wasn't on the docket, but it is set for today. It's
Let me see what I can do. Let me see what I can do. Ask Mohammed about that. Your name?
Gabriel Bailey.
You're going to plead no proof of insurance, right?
Yes.
Is John
Do you
just
have
hanging
insurance
out?
now?
I do.
Why were you driving without insurance?
My parents were paying it and they had to stop paying it due to lack of money.
How old are you?
20.
Are you in school, working, or what?
Working.
Where?
With my dad, in Gibraltar.
You have to make sure you make these payments, okay? All right. To the charge, no proof of insurance, responsible or not responsible? 125. I'll accept the plea. I'll cut you a little bit down, okay? Good luck. Can you get that charge, whatever Mr. Dubin has or what have you, counsel? Jennifer Victoria Gutierrez, 25T645832. How you doing, ma'am? Your name?
Jennifer Gutierrez.
You're going to plead to impeding, right?
Yes.
Responsible or not responsible? Please accepted. 150. Cash your end of the hall. Good luck. Emily May Alley. 25F244165. Did she give you Mr. Dubin's file? And do I have Mr. Spaniola's Rodriguez's file? Ma'am, your name?
Emily Alley.
How you doing? You're going to plead to impeding, right?
Yeah.
Responsible or not responsible to that? Please accepted. 150. Cash your end of the hall to your right, and you're all set. How much time do you need? I'll give you until the 18th. If you don't have the money, come talk to me or call the court. We'll go on Zoom. I'll give you an extension. Just don't ignore me, okay? Good luck. Dennis Gainier. Dennis Michael Gainier, 25F244236. Could I have Nightingale seated at the table, my right, your left, please? Mr. Gainier, how are you? Your name? All right. You're going to plead to impeding traffic, right?
Yes.
Responsible or not responsible?
Responsible.
Please accepted. 150, and you are all set. Good luck. Nightingale. Mary Frances Nightingale, 25F244238. How you doing?
Good. How are you?
Your name?
Mary Nightingale.
You're going to plead to impeding traffic, right?
The prosecutor,
Responsible or not responsible?
prosecutor's giving everybody a plea
Please
deal.
accepted. 150. You're all set. Good luck.
Thank you.
Robert Leo Hammond.
The plea deal keeps points off their record.
Hammond.
It keeps points off the record. It makes
All
it
right,
cheaper
counsel,
for
your
the.
appearance.
Good morning, Your Honor. You get one by your own.
Is this going to be a plea or a hearing?
This is going to be a plea hearing.
Sir, your name?
Robert Hammond.
I need Emily. So he's going to plead to both charges?
Yes, Your Honor.
Is that what you want to do, sir?
Pardon?
Is that what you want to do, is plead guilty to both charges? If you do, I'm just telling you the maximum could be 10 days. These are 2 technical violations. You don't have any priors. You can get 5 days jail for each technical violation, so you could get 10. Do you understand that?
Yeah.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. As to count 1, that you failed to submit the monthly testing as ordered on May the 12th of 25, how do you plead?
Guilty.
Did you fail to submit the testing that day?
Yes.
As to count 2, that you failed to submit the testing as ordered on June 17 of 25, how do you plead?
Guilty.
You failed to submit the testing on that date.
Yes.
Anybody forced you to plead guilty?
No.
Please accept it to both counts. What is going on here?
So he called both of those days. I do have the screenshots with his phone calls. He called at 6:03 a.m. on May 12th. He called at 5:05 a.m. on June 17th. He also called his probation officer and did take retests. I believe it was either that day or the next day. He really is unsure how this happened, but he's taking responsibility for the fact that it did happen. I'm going to make sure he knows his right color, that he knows what to do if this ever happens again. We don't expect it to happen again. He has been calling numerous times now to make sure that he's not missing. He's been calling at least 3 times a day. He's not drinking alcohol. He did have significant injuries from this issue.
From the accident?
Right. He just graduated to a cane from a walker. Unfortunately, while on probation, he did lose his wife. They had been married for 51 years.
Oh, geez, I'm sorry.
In late December. So he has been dealing with that. But it's really more of a oversight in a sense, because he has been calling. He did take a retest. He's not drinking alcohol. He's been doing his community service. If anything, I'm asking that the court add some more community service.
Emily Tessito?
Did he take retests on these?
He did, but not the day after. So, the one for May, I kind of given him an opportunity to go again. He went the 20th, and then he missed again the 17th, obviously, and then he
The
called.
20th of May or the 20th of June?
So for the May one, it's on there. May 12th, he didn't go till the 20th.
Well, that doesn't do any good.
And then this June 17th, he got the notice and called me. So he kind of took initiative to go July 1st.
How often did I order testing last?
Just monthly. He's been decreased on monthly.
He's what?
He's been decreased. He didn't start it as monthly. He's now at monthly.
And I swear on the Bible, I do not drink.
Oh, I know. You're not going to be the first guy that's told me that.
I know.
I just need some proof here, okay? And the only way to get proof is to have you test. Is DNA open today?
Yes.
You're going to test today. Are you going to be negative?
Pardon?
Are you going to be negative? I'm ordering you to go test today.
Yes, definitely.
Is there anything?
I'm on medication.
Is there anything you'd like to say?
Me?
Yeah.
Oh, man, I know I'm having a hard time dealing with my grief on top of everything.
No, I can understand that. I feel bad for you.
I just can't imagine how I missed my color.
All right. You tested DNA
on my
today.
phone now, you can see I call numerous times every day because I don't want to make the same mistake again.
Defendant to serve 5 hours community service additional to be completed by July the 11th, July the 21 rather, 31 rather, sorry. Be completed by July 31. You tested DNA today. You pay additional costs of $50 today. So you can pay $50 with 5 hours of community service by July 31. Tested DNA today. If you miss another test, I'm going to extend your probation.
Okay.
Okay? I'm gonna have to extend your probation.
Now, on the community service, what's my total hours I gotta do?
She'll talk to you about all that.
I can only do 2 hours.
Yeah, we'll talk about that.
Okay? All right, he doesn't have his community service done yet?
He had a medical. He just got his cast off.
I see.
A lot of work ethic training.
Right. I got it. Okay, I'll let you work with her. Good luck.
Thank you, Your Honor.
Thank you. Julian Geisig. This is 24W 835467. Mr. Muhammad, do you have Mr. Dugan's file?
Your Honor, I turned it in.
Where is it?
I believe it's a waiver and there's no objection.
Okay. Name?
Good morning, Your Honor. Let me keep you 550 on that. These guys includes my right.
Sir, your name? What's he going to do here, counsel?
He is gonna plead guilty.
All right, if you plead guilty here, this would be, again, if you plead guilty to both counts, that'd be 4 violations. You could have your probation revoked and you could be jailed for up to 45 days. This is an attempt larceny. Do you understand that?
Yes, sir.
And did you sign an advice of rights and read and understand the rights today?
Yes, sir.
You plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
Is the count one that you failed to attend the court work program on June 21? How do you plead?
Yes, sir.
Did you fail to attend the court work program on June 21?
Yes.
Count two, keep your voice up nice and loud, to the charge you failed to enroll in the positive strategies program. How do you plead?
Guilty.
Did you fail to enroll in that program?
Yes, sir.
Anybody forced you to plead guilty? Please accept it. So I ordered this March 5th. I gave him 4 days on the court work program, ordered him to do the positive strategies program with 8-week follow-up. Mr. Nahikian, what do you have to say?
So for the court work program, he just had one left, it's my understanding. He did have a doctor's appointment on 6/21. He can provide verification to probation. I think he notified probation of this, but he didn't provide verification. Obviously, court work program comes first. He needs to make sure that his scheduling is all around that. I had a good conversation with Mr. Geisig about taking responsibility, making sure that a lot of these things are on him. He was unaware of how to sign up for the positive strategies program, which again falls on him. I made that clear that, hey, if this happens or something you haven't done or something you need to do, call probation. They're going to answer, at least make a record of you attempting to do these things. So I think he has a better understanding of that. I don't see these issues reoccurring again. I do think he's taking this serious and he understands that, hey, jail is a real possibility. So we're just asking that he be allowed to re-enter that positive strategies program, that support work program days are added. He did have 4 previously, he has 1 left. So we're asking that he have more court work program days, that he be allowed to continue on probation.
Your name?
I'm Casino.
Anything you'd like to say, sir?
No, I honestly don't know.
Got it grow up. What do you want to say?
I would agree. I did reschedule, the alleged doctor's appointment was May 31st. And I did reschedule him for June 21st. And then he missed that one. And then I didn't include it, but he missed our probation appointment on June 16th also.
You're going to end up in jail if you're not careful here. What are you doing?
Honestly, I just be at work losing track. Like,
What do you work? Where do you work?
I'm certified rescue safety.
A what?
Rescue safety.
Who do you work for?
Ace Industrial. We're contractors.
How long did they put him on probation for? What do you think?
I think he needs to get organized because I do feel like I'm chasing him.
So I understand. I kind of had that sense from you before, if you don't mind me saying. I don't want to sound mean or anything, but I just had that sense from you the whole time on this case. I'm telling you, that don't push me any further, okay?
Yes, sir.
Serve 1 day on the court work program additional, pay 35 for that, pay additional cost of 100. To be registered.
If you can flag me in the question, that would be a little easier.
Any reason you can't register next week, by the end of next week?
No, I can't.
You can register for that by July 18th and attend that program. Do you understand?
Yes, sir.
All right, last chance. Can you pay the 135 today?
Yeah.
Come on. You got to grow up, son. All right?
Yes, sir.
Gotta grow up, son.
Good luck. Thanks. People against spikes.
They're not supposed to know what the divide is.
25M.
Good morning, Your Honor. If you
Hang on 1 second. 25M 712713. Go ahead, Mr. Dubin.
Sorry, good morning, Your Honor. Attorney Maxwell Dubin, P number 86012 on behalf of Mr. Spites. He is in the waiting room. He's been in the waiting room. This is just a waiver. I have went over my client's rights as well.
All right, hang on 1 second. Bring out Mr. Spites, will you please?
He's out, Judge.
Mr. Spites, take your hat off, please, and tell me your name.
Brandon Spates.
All right, so I'm sorry. Go ahead, Mr. Dubin.
Nope, no problem, Your Honor. I have went over my client's rights, had ample time to talk to the prosecutor. We have discussed this matter. We are wishing to waive my client's right to a preliminary exam and have this matter bound over for circuit court, Your Honor.
Is that what you want to do, sir?
Yes, sir.
All right, you have the right to a preliminary examination. Your lawyer tells me you wish to waive that right. If you waive that right, you're waiving the requirement that the people show that the crime was committed and that the crimes were committed and that you were the one who committed the crimes, and you'll automatically be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes.
You still wish to give up your right to a preliminary exam?
Yes.
Anybody force you to do that?
No.
Waivers accepted. I will set this over for exam in the Criminal Justice Center, Wayne Circuit, July 22 at 9. Bond is continued at $25,000 personal. There was no indication by the prosecutor he objects. Anything else, Mr. Dubin?
No, Your Honor, I'll just say thank you for keeping an eye on me. I appreciate it very much. Always a pleasure being in front of you, and I hope you have a good rest of your day and your staff.
Thanks a lot. You too. Good luck, Mr. Spites. Thank you.
Thank you.
All right.
Mr. Dubin said that before.
Is
Breezy,
lawyer for SEAC?
27
Andrew Stephen SEAC, 25T 708-941.
Greeners, 26
When, your name?
Andrew Stevens,
When was he supposed to be here for sentencing, Heather, in front of Judge Hesson?
Judge, you're a little loud today. I'm going to turn you down just a tiny bit. Greeners, 26 months. Thank you very much. I hate public speaking.
Yeah, I think his last
love it.
Scheduled hearing was a show cause arraignment on July 2nd at 10:45 that he missed.
There's no, oh, I see. You didn't show up.
What? The lawyer's like,
so she took his plea, it looks like June 12th. Is that true? Wait a minute, what is going on? And then he didn't show up for another one on July 2nd.
Yeah, that's correct, Judge.
Do I have to give you a cash bond?
Your Honor, I believe that he has a court date on July 17th for another separate matter. Judge, I'd ask that this be scheduled for that matter. I spoke with his probation officer. That's what she had requested as well. And we can get this matter resolved all in one court appearance.
Why weren't you here?
He was in jail from the 26th to the 30th
of June.
Correct, Your Honor.
Yeah, but he was supposed to be here on July the 2nd.
Correct, Your Honor. He's apologetic for not making that.
Why weren't you here?
I didn't even know I had a court date. I had no contact.
Is that unimportant to you? You don't know you have a...
No, I didn't receive paperwork. I wasn't contacted by probation. I saw you after this violation, and you sent me down to DNA, and I dealt with probation on June 26th. This is from the 19th prior. Like I was under the impression this was all taken care of. I saw you the following.
All right, slow down. When are we rescheduling this for, Heather? July 15th you wrote down. You want what day?
I spoke with his probation officer, indicated that he has court date on the 17th. I'd ask to be put on the 17th.
Is there any problem with that for Judge Heston?
Well, on the same date that he's coming back for on the 15th that we just gave him on his other case. That's why I gave that time.
Oh. What's the problem with that?
There's no problem with that, Judge.
July 15th at 9 you'll be here, okay? I'll reinstate I don't know what kind of bond we have on this.
He's on a house arrest right now, to my knowledge, Judge. I guess that just run concurrent.
House arrest for what?
I guess domestic.
Yeah, that was here, that was adjourned today.
Yeah, you're gonna have to bring that up with Judge Heston. I mean, that has nothing to do with this case, right?
Correct.
Personal bond, I'll give you $10,000. She had 20,000, 10%. You might want to tread lightly. You might want to make sure you're here.
Yeah,
Don't miss this one.
Sorry.
Stephen.
10,000 personal.
This
Comply with all terms and conditions that she's outlined. And you come back in a week and you can talk to her about it, okay?
Yes, Your Honor, thank you.
Thank you.
Thanks.
Messina Hinojosa. Nicole Marie Messina Hinojosa.
What do you guess? Impeding traffic?
25T645594. Could I have Alyssa Sanchez seated over here?
Yep.
Sancho, rather. Your name?
Nicole Messina Hinojosa.
All right. Was there an accident?
No, sir.
No accident? You're going to plead to impeding, right?
Yes, Your Honor.
Responsible or not responsible?
Responsible.
All right. I'll accept the plea. $150. You can go down the hall and take care of it. Good luck.
Can I have till the 31st, sir?
You can have till the 31st. If you don't have the money, come talk to me, okay?
Thank you, Your Honor.
Don't ignore me, though, all right?
No, sir.
July 31. Alyssa Marie Sancho, 25T645804. Could I also have Jose Rodriguez up here? Yeah, I'm not going to do this. I mean, maybe Judge Heston will do it for you, but who's on Rodriguez? Your name, ma'am?
Alyssa Marie Sanchez.
You're going to plead to impeding, right?
Yes, Your Honor.
Responsible or not responsible?
Responsible.
170 is your total. Cash your end of the hall to your right, okay?
Am I able to have an extra week, Your Honor?
July 18th. If you don't have the money, come talk to me, all right?
Thank you for your time.
Good luck. Who's got Rodriguez? Jose Rodriguez. Yeah.
Good morning, Your Honor.
Hang on one second. Counsel, your appearance. This is 25M546110 A and B. Your appearance.
Good morning, Judge McNally, to you and your staff. This is Attorney Paul Spaniello. My P number is 72366, and I'm here on behalf of Mr. Rodriguez.
Is this yours?
Yes.
Your name?
Good morning, Your Honor. Mohammed.
I just don't do these approved courses. You can come back and do it next.
No, Judge, defense indicated to me that he's going to have his client submit it to me, or he's going to submit on behalf of his client. So I'm just putting it so the court is aware that they're going to be doing a program. It's not a requirement to enter into.
Well, then don't write it on. I mean.
Well, I just want the record to reflect what we've discussed.
For what it's worth, Judge, we're entirely agreeable. So I understand that we don't present it to the court, but I have all the intentions and already advised my client.
Don't write it on here. I mean, you guys can.
Judge, like, I don't want to know about it.
I'm not going to order somebody to complete a driver improvement.
Nobody's asking me.
Okay, but you got it on the bottom here, defendant will complete. All right. Okay, so this can be a plea to impeding. The failure to yield to emergency vehicle will be dismissed. The violation of seatbelt will be dismissed, right? She's going to plead to one count of impeding.
Correct, Judge.
All right, and I'm going to make that on file B. That's how she wrote it up, Heather. To the charge, failure to yield, to impeding traffic, responsible or not responsible?
Responsible, and I have authority on behalf of my client to enter into that plea, Judge.
All right, yeah, I'm just a little...
I'm sorry.
Oh, it's just been a busy morning, and I got to get out of here.
I see.
$155, and you're all set. Thank you. Thanks, Mr. Spaniel. Good to see you. Gilroy.
Good to see you, Judge. Thank you.
Thanks a lot. Ann Gilroy.
Thank you, Mr.
Gilroy. Anne Marie Gilroy, 25T645831. Could I also have... So that defendant failed to appear, so that's a default judgment. Also, Josiah Orvin Ganstein, 25T645880. That's a default. Defendant failed to appear. That was scheduled for 10:15. We also have Lynn Yvette Benton, 25F244231. And then could I have seated up here Laskowski, William Laskowski. How you doing, ma'am? Come on up here and tell me your name, please.
Ladies and gentlemen.
All right, you're gonna plead to impeding, right?
Yes.
Responsible or not responsible?
Responsible.
Please accept it, 150, you're all set. Good luck.
I told him I could pay 50 today, that'd be pushing. Can I get into next?
I'll give you till July 18th to pay it off,
Yes.
right?
Yes.
If you need more time, call the court, we'll go on Zoom or come in, Your Honor, before that date, I'll give you an extension.
Okay, where do I pay on the 18th? I just come.
Cashier, not in here, the cashier
The
down the
cashier,
hall.
but I come in this building on the 18th.
Right.
Thank you.
Have a good day.
Thank you. Have a blessed.
Good luck. William John Laskowski, 25F244-245, your name?
William Laskowski.
You're gonna plead to impeding, right?
Yes, sir.
This whole block is just
Responsible or not
impeding.
responsible?
Impeding,
Please
impeding,
accepted,
impeding.
150, you're all set. Have a good day. Diamond Gee, Diamond Mercedes Gee, 22B141007, is she here?
She is, she's in the hallway.
Yeah, wait.
In the hallway.
Why are these people sitting in the hallway? Right? You didn't go to the Tiger game last night and sit out in the parking lot, did you, Mr. Muhammad?
I did not.
Okay, just want to make sure. Jacob Roberts Zrebic, 25B148131A and B. All right, how you doing, Mr. Zrebic?
I'm good, right? Yourself?
Good. Your name?
Jacob Roberts, Zurich.
Who's your lawyer?
He just stepped outside, Your Honor. Will?
Nahikian? All right, why don't you step back there a second? I'll recall you in a minute, okay? Sadie Latisse Lindsay, 25F244163. Defendant failed to appear. Default judgment's entered. Come on. Ibrahim Diallo.
Right here.
Diallo, 25M510297. What do we?
Dr. Kaylee's office is trying to get a hold of him. Did you talk to him at all, Mohammed?
I haven't spoken to him, but I did send him a notice to appear for today's hearing.
Who?
The officer associated with the citation for this formal.
Well, I don't even know what we're doing. What are we doing?
So today's scheduled for a formal hearing. We sent notice to the officer to appear for today's formal hearing. He's failed to appear. It's my understanding from speaking with defense, they're moving to have this case dismissed.
And Mr. Kelly is the attorney.
Hold on a second. Can I just get my bearings here? I'm not sure why this was coming in front of me to begin with. What is this? A formal hearing?
Correct.
Did she grant the motion to set aside default judgment? It looks like she granted that on June 10th,
Yes.
right?
That's
Your appearance?
Attorney Lawrence Coogan on behalf of Attorney Roger Cayley.
Your name?
Yeah.
So I see. So she granted the motion to set aside default. They set it for a formal hearing today in front of me, right?
It was in front of Judge Hessen, but she's not here. It was something, I guess.
No, I get it. I get it. So the officer's not here. He was here at 10:45 and you haven't heard anything.
Correct.
And you moved to dismiss.
I moved to dismiss.
Case dismissed.
Thank you, Your Honor. It's a pleasure seeing you again.
You too.
It looks like you're pretty efficient in today moving through the docket.
Well, it's just a lot. Good luck. Nice to see you. Good luck, sir. Case
Get out of my
dismissed.
way.
Rebeck,
Go more impeding.
wait, I don't have
You're
your file
impeding my
yet.
court
Amelia
traffic.
Moore. Amelia Michelle Moore, 25F244043.
Don't impede my court traffic.
You want an off, you were offered to plead to 5 over. Your name?
Amelia Moore.
Okay, I'm
5
just
over.
telling you, you were offered to plead to 5 over, which is 1 point, and you don't want to do that, right?
No, sir.
Okay.
You want a jury trial?
Okay.
You're
You set it
speedy.
for informal. Give me a date, somebody, please.
You're going to lose this one.
July 22nd at 10 o'clock.
Day before Brian Koberger sentencing.
July 22nd at 10 a.m.
Thank
You go down the hall and they'll give you a notice, okay?
Okay, thank
Thank you. Scott Michael Bricker, 25I714371.
Good morning, Your Honor. You and your staff, Attorney Kevin Burton, appearing on behalf of defendant Scott Bricker, present to my left, PA 666.
All right. Mr. Bricker?
Yes, sir.
Your name?
Scott Bricker.
All right, so you're adjourning this for you want an adjournment of this, right, counsel?
That's correct, Your Honor. We're waiting on the prosecutor's digital file. We do want to proceed with the exam, but we'd like to adjourn it to get a hold of that digital file first.
All right, so I arranged your client, right, or not? Yes.
Yes.
All right, so I'm going to go ahead. Sir, your lawyer wants an adjournment for 2 weeks. You have the right to a probable cause conference within 14 days. Today is within 14 days of the date of the arraignment. If I grant his request, that means that the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, sir.
Do you waive that right?
Yes, Your Honor.
Anybody forced you to give up that right?
No, Your Honor.
All right, so I'm gonna go ahead and set the PCC for July 22nd. At what time, Heather?
9:30.
That'll be 9:30, July 22nd, PCC. Preliminary exam will be July 29th at what time?
10:30.
At 10:30. Okay? Anything else?
Nope, that should be good for us, Your Honor. I greatly appreciate it.
All right, July 22nd, 9:30 PCC, July 29, 10:30 exam. Have a good day. Thank you very much.
Thank you, Your Honor.
Diamond Gee,
Ready, Your Honor.
22B141007. Can I get to Beth in here?
Good morning, I'm looking at PA 1520 on behalf of Ms. Gee, who is to my left, receiving correct, Ms. Gee.
Oh, you got your child here? You got 6 technical violations. Is that your child?
Yes.
Why'd you come with your child?
Because I didn't have any watch.
What is this case? Do you live on Chrysler Street, ma'am?
No, I updated my address.
You live on Harding?
Yeah.
Okay. What are we doing on this one? I have a note here saying I will be dismissing count 3 because she appeared for testing the next day at on-site and emailed me about it. She's got 4 counts, so I'm going to dismiss count 3. To count 3, I will indicate count 3 dismissed, motion to the PO. What's she doing on 1, 2, 4, and 5?
Is count 3 the?
Let's be able to submit the testing April 15th.
Okay.
I wonder if there's a typo here. What's going on?
And then there was a missed test on the 7th, correct?
6th.
Or 6th, okay. That's the only one we'd ask for a hearing to, she'd be pleading guilty to the other 2.
There's 5 counts. Count 1 is failure to attend or scheduled probation visit on May 30. Same thing, missed probation visit June 11, count 2.
Yep.
Count 3, she's dismissing. Count 4, failure to submit the testing is ordered on May 6th. Count 5, failure to verification of attending and completing outpatient treatment.
She'd be pleading guilty to that one.
She's pleading guilty to 5, 1, and 2?
Yes, sir.
And you want a hearing on 4?
Yes, sir.
All right, ma'am, if you plead guilty to counts 1, 2, and 5, that would be in excess of, you could get 93 days on this. Do you understand that? And did you sign, read, and understand an advice of rights form today or not? I don't see.
I did that.
I can't hear you.
I did that before.
I know, but I can't have you do it before. You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court, to bring in those witnesses, and the testifier remains silent. If you remain silent, that silence would not be held against you. Do you understand that?
Yes.
Ms. Biles, your name?
Elizabeth Occupation.
Again, you move to dismiss count 3, right?
Correct.
I'm dismissing count 3 on your motion. She's pleading guilty on 1, 2, and 5, and they want a hearing on 4. So you understand your probation could be revoked. You could be incarcerated for 93 days, right?
Yes.
You understand your rights?
Yes.
You have the right to a hearing, and at a hearing, you have the right to remain silent or testify if you plead guilty. You'll be giving up all those rights, and there will be no hearing. Do you understand that?
Yes.
All right, that's the count 1, that you failed to attend your scheduled probation visit May the 30th, 25. How do you plead?
Guilty.
You failed to attend your probation visit on that day, ma'am.
Yes.
Count 2, that you failed to appear for your visit on July 11. How do you plead?
June, Your Honor.
I'm sorry, June 11. How do you plead?
Guilty.
That you failed to appear on that date?
Yes.
Count 4, that you failed to submit, count 5, that you failed to provide verification of attending and completing outpatient treatment. How do you plead?
Guilty.
Did you fail to attend and complete outpatient treatment?
Yes.
And you were dismissed for lack of attendance, correct?
Yes.
Anybody force you to plead guilty?
No.
I'm accepting that plea to count 5. I'm dismissing count 3 on motion to probation officer. What's your defense on count 4?
Your Honor, count 4, I can move to dismiss. I've asked Ms. G twice now for proof of birth of the baby. She just provided it to me about 30 minutes ago in an email.
Counts 3 and 4 are dismissed.
Proof
I
of
don't
birth of the baby.
understand, Ms. Gee. You're not taking this very seriously. When did you have the baby? This is July, though. I mean, you got to do these things. Now, you've been in here on a multitude of violations already.
So with the visits, Your Honor,
Why's she missing?
her phone was off. She couldn't afford it at the time. She got it back on, and also on top of that, they didn't have Wi-Fi. So she had gotten emails that she didn't check.
Is she married? Is the father in the life? I hope you're going to collect child support. I hope you're going to go after him for child support. These guys can bring babies in the world. They don't support them. They don't work.
I'm not married, but he's in his life.
Oh, he is. That's what I asked. The father's in his life. It's a boy?
Yeah.
Okay, well, that's good. All right.
So she's got her phone back on. She has Wi-Fi now. There'd be no reason for her to miss anything.
I know, but you know what? It's getting a bit old with her. She's had a multitude of violations here.
I agree, Your Honor. I would just say that having a child and trying to stay on top of a probation is going to be really difficult for anyone. And on the fact that she was...
It was difficult for her back in November.
No, I know.
She had 2 violations from a November 8th show cause. Then she had 2 more violations from a February 28th show cause. Actually, 3 violations from that.
Right, yeah, I have no explanation or excuse for that. I didn't represent her at that time. I would just say that being pregnant, giving birth, and coming home while also dealing with a probation is going to be extremely difficult.
Can I see the screening, please?
Yeah, sure.
You didn't clear your warrants either, did you? You didn't take the time to go over to Inkster? I mean, I ordered that back in July of 24.
I don't know, but I have to pay $150 that I do not have. They don't see you unless you can't make a payment first or a scheduled court date.
You're 24 years old. You had a 242 on the breathalyzer.
Whoa.
Yes.
That's really high.
Yes, years ago. No.
What do you mean years ago?
We're going to jump to another
This is a
case.
2022 case. I think she's referring to the date of the offense, right?
So she was only 21 then. That makes it even worse. Go ahead.
No, I would just say that it seems like she's getting on top of things now. I mean, she certainly understands how important it is. She has a new responsibility, which makes it even more important to her because she is breastfeeding. So she understands she has a real possibility. We're just asking for one more chance, if possible, maybe set this for a sentencing date to give her some time to get signed up for that treatment.
We're going to jump to Licking County.
We're not going to get along if you keep doing this. I'm going to set a sentencing date in a month. You better get in treatment.
There we go. We're going to jump really quickly. Sorry. Licking County, what's up here?
43023.
Thank you.
Okay, proceed.
Thank you, Trooper Casimir. Can you tell me who you're employed with?
The Ohio State Highway Patrol.
Okay. And were you working on June?
We've got a witness testifying.
Sorry, March
in this
8th
case.
of 2025?
Looks like a pro se.
Okay. And were you wearing your uniform that day?
Yes, sir.
As you are today in court?
Yes, sir.
Okay. And on that day, were you driving a marked patrol car with a working visible light bar?
Yes, sir.
And were you enforcing your duties as a law enforcement officer?
Yes,
This
sir.
is
And,
the
what specifically
prosecution
were you working on
asking
that day?
questions.
Traffic enforcement at that time.
Were you and or your cruiser equipped with video recording equipment that day?
Yes, I had dash cam and body cam.
Okay. And how were those activated?
My dash cam's activated through my activation of the light bar. My body cam's activated as my light bar's on. I open my driver's side front door. My body cam automatically activates.
Okay. And at any time that day, did those activate?
Yes.
Do we have videos to watch? The defendant's pro se.
As a law enforcement officer, are you have you taken training in the visual estimation of speed?
Yes, sir.
Okay. And how is that training?
Training through the academy is a week-long training set up as both a written test and practicals.
Where and when did you receive this last?
It was at the Ohio State Highway Patrol Academy back in 2021, I believe. I can't tell you the exact month. It was a week long. First was a classroom portion, learning about radar, LiDAR, visual estimations, tracking history, all the components that go into that. The second half of that's practical, where we actually go out and apply what we learned in the classroom to the real world scenarios.
And were you current on that, up to date on that training on March 8th, 2025?
Yes, sir.
Did you have any speed measuring devices in your cruiser on that day in question that I mentioned?
Yes, I had my B3 radar and as well as my ultralight laser.
Ooh, laser.
And have you received training in using those devices?
Yes, sir.
Okay. What did you use on this case in question?
I used my B3 radar.
B3 radar. So specifically radar training, when and where did you receive that?
At the Ohio State Highway Patrol Academy back in 2021. I am up to date on my yearly recertifications.
B3 is the units that
on March
fixed
8th,
on the dash.
2025, did you, first, in those trainings, do you learn how to conduct confidence checks?
Yes.
Okay. And what do those confidence checks consist of?
Confidence checks for the radar unit specifically, we have two tuning forks that are associated with our specific radar unit. So in my cruiser, I have a specific set of tuning forks. To conduct a confidence check, you leave the radar in moving mode. You strike a tuning fork that's 50 and another tuning fork that is 20, put it in front of your radar unit. The output should read 30 for your patrol speed, 20 for target speed. That's how you conduct a confidence check in moving mode. To do it in stationary mode, you just strike the 50 tuning fork. The reading output should be 50. This is due to the frequency that those tuning forks let off will imitate 50 miles per hour and 20 miles per hour.
And by doing that, is that how you confirm that it's working properly?
Yes, sir.
Okay. And so did you conduct those checks at the beginning and end of March 8th, 2025?
Yes, sir.
And when you performed those, did you find it was working properly?
Yes.
And at any point during that day, did you have to take your radar device out of service?
No, sir.
Based on your trainings that you've just talked about, what first drew your attention to the defendant's vehicle on that day?
I visually estimated him traveling above the posted speed limit on State Route 79 at milepost 12. Speed limit there is 35 miles per hour.
Okay. And about how much faster did you think they were going?
Approximately 10 miles, I believed he was going. I visually estimated him going 45 miles per hour.
Okay. And what did you do? That portion of State Route 79, where is that?
It's in the city of Heath.
City of Heath, and is that in Licking County, Ohio?
Yes, sir.
Okay. And
we're in Ohio, if you didn't know. Licking County.
At that point, when you visually estimated it, were you stationary or were you moving?
Moving.
Okay.
That's what happens when you take a traffic ticket to court.
Did you do anything to verify how fast they were going?
Yes, I then activated my B3 radar unit. Reading output was 46 miles per hour.
Like I was off
audio was consistent with the vehicle. As he passed me, the audio did drop off. I did lock in his speed.
The audio that you mentioned, is that, are you referring to the Doppler principle?
Yes.
As you can hear the radar, the noise it makes as a person approaches?
Yes, sir.
Okay. And based on that, are you confident that the radar was in fact tracking the same vehicle you were looking at?
You can hear the radar?
Yes, sir.
Okay. He's got like special ears?
He's
a human radar detector.
What speed did the radar measure them to be traveling at?
46 miles per hour.
46. Did you get multiple
yes.
measurements, the tracking history?
Yes.
Okay. And what did you say the speed limit was there again?
35.
At that point, did you initiate a traffic stop?
I did.
Did you maintain visual contact with the vehicle?
I did.
The whole time between the radar measurement and when it stopped?
Yes, sir.
Do you recall what type of vehicle the defendant was driving?
I do not recall. It would be on the citation.
Okay. When you conducted that stop, your body cam would have activated, as you mentioned before?
Yes.
Okay. All right, at this time I'd like to show State's Exhibit 1.
Right now it's just a dark screen.
Now I'm shopping for police radar guns. Not sure they even sell them to me. But.
Can you see anything on your screen?
It's still a dark screen.
Can we get a tech guy in here? Because this guy is going to get he's going to get off on his speeding ticket 10 miles over if we can't get tech up here.
There it is.
There it is. We see it now. Can we see? Oh, we get to watch on his desk right there. Look over his shoulder.
Okay. Can you tell me what you see on your screen now?
This is my body cam as I'm approaching Mr. Hayes' vehicle.
Okay. And what is the date that's listed on the upper right-hand portion of the screen?
March 8th, 2025. The timestamp right now is 3:38 in the morning.
Okay. So is this the events that we've been discussing so far?
Yes, sir.
How's it going?
Pretty good, sir.
You know why I got you stopped?
No, sir.
It's free speed. You know how fast you're going?
I'm gonna say like 30, sir.
Checked you at 46. You got a driver's license?
Yes, sir.
Thank you. Josiah?
Yes, sir.
You know who I am.
Tom, yeah, I'm on my way to UPS.
Okay. So you spoke to the driver of the vehicle?
Yes, sir.
On my way to
And
UPS.
did you ask for their identification?
I did.
Okay. And is that when they became known to you as Josiah Hayes?
Yes, sir.
And is that person in the courtroom today?
Really loud,
yes,
by the way.
Can you identify them and where they're sitting?
Sitting right over here with a long sleeve button up shirt.
Your Honor, let the record please reflect that the witness has identified the defendant.
Sure.
So did you inform the driver as to why you initiated the traffic stop?
I did.
Okay. And did the defendant say anything in response?
He stated he thought he was going 30 miles per hour.
Okay. At this point, was the defendant wearing a seatbelt?
He was wearing it underneath his left side armpit.
Under his left side armpit?
Yes, under his driver's side, left side armpit.
Okay. And how is it properly worn?
The shoulder belt has to be over top your shoulder, diagonally.
Okay. And so if it is worn over the shoulder, that is in accordance with the statute 4513.263?
Yes, statute stated it has to be properly worn per manufacturer specification. In this case, if there is a lap and shoulder belt on it, it has to be worn correctly in that case.
Okay.
The judge is like,
in the rest of this video, do we ever get to your recollection, do we get a clearer view of the seatbelt?
I do point it out at one point. Maybe my body cam does give a good view of it.
Are we going to watch the whole video?
You still have 2790?
No, sir. 289 Radian Drive.
Where you live at?
289 Radian.
We don't know where he lives. 123 Sesame Street.
Radian Drive. Yep, the Dunkin' Donut.
By the Dunkin' Donuts. You know where the Dunkin'
Radian?
Donuts is, right?
Yes, sir.
What's the zip code?
430.
43056?
Yes, sir.
All right. Just cruising, not paying attention, man?
Yes, sir.
I get it. You said you're on the way to UPS?
Yes, sir.
Why don't you got your seatbelt on?
So is this, what would we see if the seatbelt was being worn in accordance with specifications?
Seatbelt is locked back to the B pillar on the driver's side, so if it was worn correctly, you would see it over his left side shoulder, coming across his body, down to his passenger side waist.
The judge's looks.
Did that law 4513.263 rather, did those apply to the defendant as he was driving the vehicle that day?
Yes, sir.
So did you issue a citation that day?
Yes, I gave him a warning for the speed, did issue a citation for the seatbelt.
Is everything that we've seen on the recording today, is that a fair and accurate representation of the events as you recall them?
Yes, sir.
Okay, no further questions? Let's let this pro se guy
At this
step
time,
up.
we'd like to submit into evidence Exhibit 1, the video, and nothing further for this witness.
Mr. Hayes, do you have any questions for the trooper?
Not really, sir.
Okay.
Nope.
You may step down.
Thank you, Your Honor.
I'll just let that testimony stand against me, unquestioned. No further witnesses?
The state would rest.
Any objection to the video, Mr. Hayes?
No, sir.
Okay, I'll admit Exhibit 1. Mr. Hayes, would you like to testify today?
No, sir.
Okay.
No? Why did you take this to court?
We'd ask for a finding of guilty based on the testimony of the officer and the body cam footage of that day, that the seatbelt, if it was being worn at all, was not in accordance with the state law.
That was one sentence.
Mr. Hayes, you want to say anything in
One
closing?
sentence closing.
Not really. I thought I was wearing my seatbelt, but besides that, Officer Thomas is a great officer. We have good history, kind of friends.
I like the guy.
So I don't have a problem.
I thought I'd get a deal.
He did all the correct traffic stops, and we've known each other for about a while now, so appreciate you guys.
All right, thank you.
Just spinning the
basically,
court's
this proceeding
wheels.
today, I find you guilty. I'll be $30 in court costs.
Yes, sir.
Thank you.
Guilty in court costs. Here we go. This judge is like... Okay, so this guy had no plan, no lawyer. He fought his ticket, pled not guilty, went to court. It was a bench trial. At least he didn't get a jury called. Doesn't question the... I imagine there was no open. I can't go back on this court. We can only see it live. Doesn't provide an open. Doesn't question the witness, the officer, and has no closing. Doesn't object to the evidence. And I guess he's surprised. I guess he's surprised that that he was found guilty, because I thought I was wearing my seatbelt. Clearly in the video, I'm not. All right, thank you, Licking County, for delivering yet another banger. Oh, we just caught the judge. Just got the judge going out the door. Judge McNally's called a break. He managed to effectively clear his courtroom by fining everyone who was there, $125 to $170, and letting them plead to obstruction of traffic. And with that, he's done as well, so we get to bail on that as well. Let's see. We are, while we wait here, we are 7 hours and 20 minutes into deliberation. The court counts 1 hour less than that. They're saying we're only 6:20, obviously giving them an hour off for lunch, assuming there was no deliberating happening in that jury room while they ate. But Judge Dad has left the building. He usually has a little break, and then might come back. So usually the blocks are sort of sorted out that way. Okay, so Licking County. I think we're done with Licking County. Licking County is always a good one. Fun fact, when we look at Licking County, let me just see if I can do this here. Licking County Municipal Room 1. This, let me show you here. What are you guys seeing? Oh, okay. This live stream has been running nonstop for 13 days. Licking County shows everything nonstop. If it happens in court, they turn it on and it happens. But when you live stream for longer than 12 hours, it does not save it. You can't go back and replay or show it again. You can live stream 24/7, as a few of you do. Colleen, with the horses and everything else. It's YouTube will allow you to live stream 24/7, but saving videos stops happening. The stream has taken a licking and has kept on ticking. Greeners steps in with the obvious pun there. Celestial Force, do you have any follow-up to the Mullis case? I do not. Not at all. We do have a bench trial that started in Iowa, Boober. Thank you. We might jump to it. Here's the thing. I've got today and tomorrow, and then I'm going to be gone for 2 days. I think we're going to speed trial, especially because the first part of trial is generally the slowest, until we get to the end of the trial. But we're going to speed trial. The audio is terrible. Oh. When you say terrible, how bad is terrible? You know that it actually, like, I'm like, oh, really? Challenge accepted, right? Let's see how bad the sound is. Is it? Is it Ali Yunus? Is that the one? Iowa versus Ali. Yeah, let's give it a quick listen just to hear how bad the audio is. Oh.
We haven't moved at all, so we're still kind of in the dark. So I went out real quick and waited on the ambulance and I didn't have much to go. And were you able to direct the ambulance?
It's terrible. Look at this.
Yeah, back to the
Let's go 8.
and after the ambulance arrived,
We have earthquake footage and Capitol Rotunda audio.
Valle was on the ground with her, and I was going to stay back, so I moved out of the way so they could, then when I could do what they needed.
That is awful. That is awful, and I don't think it's fixable. It's worse than potato audio. What we have is a hard-walled, hard-ceiling, hard-floored courtroom. Basically, think marble floors, marble walls, marble ceilings, an echo chamber, large space, so you get a longer echo, more delay between the when the sound is generated and when you hear it again. You have a single mic picking up general audio, ambient audio, so every sound. And you have like a tripod mounted on something that's moving and shaking, probably with an air handler or something. So let's skip that one. That is a high school gym, but terrible. The camera is secured by slinkies. Sounds like a high school hallway. At some point, you just have to say this is not effective. Might skip that one. Did they hear the news out of Idaho? They're looking for somebody. They might have found him. At least somebody might have run into. Was it Todd? Todd is on the run up in the Sawtooth Forest, charged with kidnapping and murder of 3 young children. And somebody bumped into somebody who looks just like him. Travis. I know it started with a T. All the T guys. Troy's like, it's not Todd. It's Travis. You have a backup case out of Warren County starting Monday. Josh, that sounds good. We'll keep our ear to the ground on that one. Travis Decker. That is crazy. Yeah, just a wild one up there. But how would you like to bump into somebody who's on the most wanted list? I say this because as a young man, just a young boy in the Boy Scout program, I went up camping in the Wind River Mountains in Wyoming, which is one of my favorite places in the world to go and hang out in the wild, just because they're amazing. They're beautiful. Rugged, just think Tetons, they're just amazingly beautiful mountains, hiking, wildlife, fishing, beautiful sights, ice cold, clear, crystal clear water, all of that. We went up camping in this campground, and the week after we left on a Saturday, and on the Monday, the FBI busted a top 10 most wanted serial killer camping like half a mile from us. It was wild. It was crazy. Nope. Too much nature. Gossip room in India. Kathy, good to have you. I will tell you that we hiked up to a little lake. It's probably about a mile above our campground. So we hiked up to this lake, and there's boulders, like just granite boulders, on the side. It's just beautiful. Gray stone, whatever it was. Well, probably wasn't granite. But we're fishing over there and we're climbing around the rocks and we found a kitten, this cute little kitten with little tufts. And we ran all the way back to camp because Mama Cat, the kitten, was about the size of a regular cat, and Mama Cat is going to be bigger. I even left a fish on the stringer in the lake. But don't mess with Mama Cat. Fun stories from up there. Other than the crimes that happen, there are quite a few crimes that happen up there. We found a wallet while we were up there one time. I also got my first picture of a moose, and this was on a camera that was one of those 110 cameras, not the 35 millimeter, but the 110, the long cartridge camera. That's what I had. I took my first picture of a moose with that camera. It's a fixed lens. It's pretty much what you see is what you get. Little click, wind, click, like that. But I took a picture of a moose, or part of a moose. It was the moose's foot as it was running by me, and I have a picture with my foot and the moose's foot in it as it charged. I could have reached out and touched it. Best moose picture ever. But that was wild. It ran right through our camp. All right, where are we at on our timer? What do you guys see? You're seeing that. We'll see this. 7 hours and 28 minutes. Jumping back to court, nothing is happening here. So we get to do a little more court hopping. We won't be going to the Iowa case, this one, just because the audio is terrible. I mean, listen to this. Oh, that's terrible. That is just so bad. Okay, so let's bail on that one and see if we can find another trial. Cedric Simpson is doing landlord-tenant stuff, but Judge Boyd is around. What's
but
she
since
up to?
Bashan is here and everybody else is here.
Is that a DMB purse I see?
Bashan is like, what? You got beef?
That's got to be a DMB purse. You guys see that?
So what is
That's DMB,
happening
right?
with the Stillers?
They're being like unusually aggressive. It's kind of crazy. Yeah. So they got Jalen Ramsey, who's really
We're talking
good.
sports.
I was pretty surprised that they traded Fitzpatrick.
Jason, I'm going to start some conflict right now. So who has a greater chance of making the playoffs?
Definitely
The Dallas Cowboys or the Steelers?
The greatest case.
Who has the greatest?
That was like the Aggies when they were making the big show.
Who has the greatest chance of making it to the Super Bowl?
I think it's a Florentine drawstring purse.
Probably Eagles.
From DMB.
Yeah.
Unfortunately, yeah.
Would be the Cowboys, right? Oh, it's always the Cowboys.
I think the Steelers got a chance, though. I think getting Rodgers helped. I think.
Okay.
They kind of went all in
I'm
for
so
you.
sorry.
I think it'll be better than last year.
Sorry.
All right.
They'll be better than last year, I think.
Okay.
Better than last year.
Oh, yeah. So is Aaron Rodgers going to have a team?
You'll either be really, really bad or really, really good.
Yeah.
That's usually how it goes when you're 40,
Yeah.
41 or 42 or however.
Yeah.
My age.
Okay, well, then why are you not playing football?
Oh, because I was never good anyway.
You know what? I will join any league. It doesn't matter if it's male or female. And you know what I would do? As long as you just let me ride the bench, I'm okay. You don't. You
Just
can,
likes
you
the
know,
players.
you don't even, the other people who ride the bench, they're still making millions. I would say, give me 2 tickets to every game so I can give them to people.
And make like 10 million. I think QBs make like 10 million.
You can just pay me $250,000, but just don't put me in the game.
And whenever you still think, I played, I think they call it intramurals, just some organized basketball 3 or 4 years ago. I broke a finger, so I stopped. But someone had they were taking videos of us playing, and you feel like you're really fast out there. And you're like, it looks like you're moving in slow motion. It's like,
And molasses.
I need to retire.
Oh my gosh. But it will be interesting. We'll see what happens.
Yeah.
So. But I love when the sports start. I am a big fan of every sport. The only exception, and I know people are going to get upset with me, I like indoor soccer because I think it moves faster. But then I've never been to a live soccer/football game, and I probably should.
So I took I took my boy, we went to Steelers Texans in Houston. We had like a night with nothing to do. And there was a Houston the Dynamo is their MLS team. And I was like, oh, we should go. It was really fun.
Yeah.
Actually, really
Yeah, I think the indoor, it moves so quickly. That's what I like about it.
It's a small court.
But
I've never seen a live indoor game.
Yeah. Was it? There's an attorney, I can't remember his name. He actually ended up going to the World Cup. And he said, I think he did the World Cup in, I want to say it was either Brazil or South Africa or somewhere. He said it was awesome.
Oh, I'm sure. Yeah, they're so into it.
There's so many people, right?
Well, the only thing is if your team loses, then like someone might get stabbed or whatever is the unfortunate part. They care a lot.
Yeah. But I recently got into rugby.
Oh,
I love watching that. And I love curling.
Oh, I've never seen curling.
In the Olympics,
I know it's in the Olympics, but yeah, I've never seen.
So I don't know how they make their money, but I like curling.
Baseball's tough to watch.
Yeah.
I have too much ADHD.
Okay. All right, Deputy Laura.
Good to see you.
So we're gonna bring the jury in at 11:30. I'll do my spiel for 30. All right, so everyone, there's a jury outside in the hallway. I told everybody to move with efficiency.
I'll take it.
And efficiency has not been seen.
As we talk sports
what's going
for
to
10
end up
minutes.
happening is the jury is coming in here at 11:30. We're going to start jury selection, and everyone else, you're going to end up getting recalled. Unless you move with efficiency. You know, now you can hear crickets. People are like, what does that mean?
Oh, good. Heat value index will be 102 to 107 today. That's just great. We're cooking. We are cooking. Heat advisory. 107 till 9 p.m. this evening. Guys, I like having a fun time talking about Judge Boyd's purse, mostly because I know
Deputy Laura,
absolutely
there's no
nothing.
need to bring anybody else out now because
I know nothing about purses. I just use Google Glass and take a quick screenshot, and it tells me what kind it is, so I'm cheating. I checked it out before we could jump to our channel so I could pretend I knew what I was talking about. I had to confess. I know nothing about purses. As a matter of fact, there was a time when I was buying and selling stuff at thrift shops for money. I love that.
Brian Mejia.
People say, "Oh, you should do purses." No, I'd never know what to buy. I would get fooled by every single fake fraud.
Honor, the state received
I did girls'
several
jeans, though.
Snapchat records, which is what we were here for last time, and we've been setting up times with defense counsel to come and view. But it is three different, my understanding that it is three different teenagers and young adults Snapchats, and it's just very voluminous. And so defense counsel has come to our office, I believe, 3 times for a couple hours each to view them. And there still is some that they need to go through.
And that's the only discovery?
We believe so. We're trying to figure it out.
All right, Norma. Recall this for August 28th. That's the last discovery and states you need to be prepared to tender an offer.
Yes, Your Honor.
All right.
Tennessee is swamp rump humid. Bring on the fall season.
Yes.
Robert Castillo in your trial docket this morning. I've not done a trial docket in your court before, and I'm just trying to figure out what I need to be doing. I don't want to be holding things up. I don't know where I am at. What's going on?
All right, just give me a moment. Let me do this and I'll.
No problem. Just trying to make sure I'm not doing something wrong.
Okay.
The attorney comes up and I have no clue what I'm doing.
Yeah.
I have no clue.
DeAnthony Gordley and Deputy Laura, you can start moving them back. Oh, well, tell them that he needs to come. Morning. All right.
Stacy, 105 in New York. Wow, that's hot.
So you're
right there.
asking for a PR bond?
Yes, Your Honor.
All right, so what I can tell you is legally, I'm not allowed to give a PR bond in this type of case. You have to take that up with the governor. So.
The harassment case also is included in the, okay,
Because it's a public servant.
okay.
So is
You
that the one,
harassed a
the
public
only one you're
servant?
asking for a PR bond?
Yes, Your Honor. The other, one of his cases was dismissed.
Okay.
So the only case that's before the court is the harassment of a public servant.
All right, so what is happening with the harassment case?
I've seen that it's still unindicted. I read some of the facts, and the state is not prepared to recommend a reduction.
Okay.
I believe it's set at 7,500 currently, Judge.
Yes. All right, he has it listed as being indicted.
Let me confirm right.
Yeah, it's hot.
That's correct.
We're all cooking.
Okay.
As of 6/12, yes, Judge, indicted.
Okay, so this is what I'm going to do.
You're going to sit in a cell until your court date.
Counsel, are you available to return on Thursday?
Like it's Tuesday?
Mm-hmm.
Yes, John.
All right, so we'll call this back on Thursday. That'll give the state a little bit more time to look into things as far as the bond. So we'll bring you back on Thursday, okay? All right, thank you for your patience.
Thank you.
You're welcome. Norma, this is coming back on the 10th.
Everyone is melting. That's pretty much it. I like heat more than blizzards any day. I live in snow country, so heat is a short window for us before we get into the cold. Tell you, Laurie, I miss ice fishing. Oh my goodness. I love ice fishing. That's my happy place.
And what page is Gortley on?
Put me out on a frozen lake by a little hole, little rod in my hands, a couple $1,000s worth of fish finder technology. I'm a happy guy.
Joic Yanes.
Morning, Judge.
Good morning.
Yeah.
78 in San Clemente, California. That's nice.
All right, so where are we on discovery?
Judge, I would be asking the court for another setting for discovery compliance. There's a lot of financial records in this case. Obviously, I've been mostly focused with the case that's set for trial today.
All right, Norma, set this in late August, and this will be the final discovery.
I understand what you're saying.
All right, August 28th, once you sign the reset form, you will be excused.
Yeah, there's no law against wearing an extra layer, but taking it all off, people start to frown on that.
Hillary?
Oh, man.
And Deputy Laura, when you all want to empty the box?
South Dakota.
Yes.
Never been to South Dakota. I don't think I've been to either of the Dakotas. My perch total on the ice this winter was 227. That's not a bad day fishing, Mr. Fix-It.
Emmanuel Perez.
That's a lot of fish. It's a lot of fish to clean. Hope you have an automatic fillet knife.
Right.
All right, counsel, did the state make an offer?
Yes, Judge.
All right, sir, how old are you?
36.
All right, Norma, I need a plea deadline date in 3 weeks, please. Yes.
July 29th.
All right, July 29th, once you sign the reset form, you are excused.
Thank you.
Yeah, that's the website.
I can never live somewhere where it's super cold. Mrs. R.A. Not a fan of the cold.
Hillary.
All right, and counsel, if you let your client know he's not to be late again.
Ooh, don't be late. Client, do not be late.
All right, to everyone else in the audience,
Yes.
you're going to need to be back here at 2:30.
Are you leaving
Pilar
us?
Munoz.
Present, Judge.
Court is calling 2025 CR 005740 State versus Pilar Munoz II. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Good morning, Judge. Alfonso Cabañas for the defendant.
Are there any applications?
No, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Munoz, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
You are, Your Honor.
Sir, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He did, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 108 days in the state jail facility. There's a $2,000 fine, no applications. The state will take in consideration 2025 CR 005742 and 2025 CC 004950. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Judge, I just want to make sure I heard it correctly. That's 180 days.
Yes.
Okay, that is correct, Your Honor.
All right. And did you understand that to be the plea?
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State exhibit number 1 with office attachment.
Judge will review the same.
All right. State, you may be excused.
Thank you, Judge.
Did you review the waiver and
We're going
stipulations
to bail
with your
just
attorney?
for a minute.
Did you
Just for a minute. We have not been to Judge Wolf in so long. I'm just looking here. He's got a lot of people bustling around the Cheatham County courthouse. Looks like something's about to go down. Judge is not in the chair yet. Judge David Wolf travels. He's a traveling judge. Goes around to different courthouses and is overworked and underpaid, I think. At one point, he even went up and spoke in front of a legislative committee trying to seek more funding to hire more judges to help him out with the workload. Very seasoned judge, very reasonable, and he has the Heavenly Wood Courtroom, which this is not, by the way. This is not the Heavenly Wood Courtroom. But I'll keep an eye on this and see if something's happening here, what that is. All right. Meanwhile, what state is it's really harsh for a drug offense? Nevada. Depends on the amount. Unless we're just looking, we can jump back to Judge Boyd. While we look around a couple other places. Let's see where she's at.
To appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, so we can go off the record. Here's the thing. Using heavy drugs, only one or two things going to end up happening. Either you're going to end up in prison, in and out for the rest of your life, or either somebody's going to have to identify your body. Now's the time, and I know it's probably difficult. I've never been addicted to drugs, so I know I don't understand the pain associated with it. I know it affects your brain chemicals, and you get really endorphins and everything else from using. But you're going to have to get a control of it. Otherwise, it's not going to end well for you. When you're released from the state jail facility, if you need help finding a place for inpatient treatment, come back to here if I'm here, and I'll pick up the phone and call a place for you, okay? All right. Counsel, on this, you're welcome. On this, some courts don't like for us to sign theirs, so I can't remember which county courts don't allow that or don't want that. I can still sign it, but I just don't like to step on any toes.
I understand that.
So if for some reason they don't sign it, you can bring it back to me.
Okay.
All right.
Thank you, Judge.
Yes. Mm-hmm. Well, I mean, how long is it going to take them to do the paperwork? All right. All right.
Let's see if we can go to
You're
Kansas
welcome.
instead. Hold tight. Hold tight.
Yes.
Let's go to Kansas. It's going to be 7. Have not been to Kansas in a long time as well. Oh, you need to use the right computer. Where are we at? Well, that's 12th. I need 13th. All right, we've got a full Zoom courtroom to bring you now. So let's go there now. See what we got. A whole ton of people. Where's our judge? No judge yet. Josh Winkler, Jennifer's here. John Jorgensen, Rocky. Rocky's here. Probably not that Rocky. You've got a PSA. Jay Pinniger, looks like a lawyer. Danita Lawless, Carol Smalley, Mary McDonald, Jennifer Simon, she looks legal as well. Greenwood County, also legal, and Jill Gillette. That's a county attorney.
Audio either.
Oh, we can hear you, Carol.
Are they talking?
John's like, hi, it's me, I can hear you. Love it when the ones who look like lawyers are the defendants. And when the defendants look like, or the ones that look like defendants or lawyers, that's even better. It's Blue Shirt Day. I see 4 or 5 of them got them, 6 of them maybe. Holy cow. Danita Lawless. Stand up. Let's see. Holy cow. Jennifer might be wearing a blue shirt. Mary. PSA guy, technically. Jay Pinniger obviously got it. Oh, red. Danita. Okay. Thank you for standing. I appreciate you saying that. You heard me. You stood up. But no, wrong color shirt. Both the people in Rocky got it. Jennifer and Josh. Let's do that. Let's do blue. Blue is not guilty and red is guilty. Sorry, Mr. Miss Lawless. You lost today because of the clothing you wore. John, choosing all the colors does not help. You have to commit. Go change real quick. There's still a chance. Having the last name Lawless is not a good look with the court.
Good morning.
Good morning.
We are on the record.
Oh, Judge Webster.
We are on the record in the 13th Judicial District, the District Court of Greenwood, County, Kansas. This matter does come on for preliminary hearing in 2023 CR 41, State of Kansas versus Thomas J. Spexarth. The last time I was involved in this case concerning felony theft of cattle.
It's a cattle rustling case. Grace, I'm so sorry about that.
Some time ago, the parties appearing then are the parties appearing now. County Attorney Jill Gillette for the state, Attorney Rocky Weishman for the defendant, who appears in person as well.
Where's Rocky?
Now, I tried to reconstruct a little bit of what has happened since the case was sent to Judge Hart for arraignment. Basically, the defendant, when he was before me for preliminary hearing, waived his right. The charge was felony theft level 7.
They have 7 levels?
Since that time, he did appear before Judge Hart and was arraigned on the charge. There was a jury trial set with Judge Hart. Thereafter, the county attorney filed thereafter the defense attorney filed a motion to continue the trial that was set in October 14th. There was a motion for continuance of the jury trial. I did not see that it was ever journalized and would instruct the attorney to do so. But at the defendant's request, the jury trial was continued. It looks like to February of 2025. But prior to the jury trial, as continued, the county attorney filed a motion to amend to amend the charge. But again, no amended charge or order was followed by what was apparently a grant of the motion. So I understand that the state has at least orally indicated it plans to amend to a level 5, and that the jury trial is set some date in the future. But because the state amended the charge upward after the defendant waived arraignment, he motions for and is entitled to a new preliminary hearing. So, counsel, as I understand it, we are here today for a second preliminary hearing, which the defendant does not intend to waive, and the state has subpoenaed numerous witnesses. Ms. Gillette, do you agree with that chronology and the purpose for being here?
This is wild.
Mr. Weichman?
Well, I was asking Miss Gillette first, but Mr. Go ahead. I was going to ask you next. Do you agree with that, Mr. Weishman?
I do. It's for waiver today, Your Honor.
Oh, you are going to waive the amended charge. Okay.
Yes.
Well, have you seen an amended information?
I think so, yeah. I think I saw one. You don't see it in the file?
No, Miss Gillette, when did you file that?
What's the penalty in Kansas for cattle
I'm
rustling?
sorry, you're muted.
It was attached to the proposed motion to amend complaint information. I believe that it was granted that it could be filed. So we'll go ahead and record it. It amends the complaint
They still
for
hang
the
them high.
number of cows that were reported for 2019, and that was the last year they were on the property in Greenwood County.
Well, I'm not particularly comfortable with the idea of waiving a preliminary hearing on a charge that has not been filed yet. Ms. Gillette, is the document prepared? It just needs to go to the clerk?
Yeah, a copy is attached to that motion to amend complaint.
Let me see if I can call that up. I didn't see it before, but I may have just not gone down enough pages.
Cattle rustling used to be like a hanging offense. I didn't know people still did that. I mean, obviously innocent unless proven guilty, but defendant has a
Okay, that's the motion
lawyer
to
named
amend.
Rocky.
And I do now see that you've called my attention to it, and when I scroll further down, the amended complaint. All right, Mr. Spexar, there is now before me an amended complaint alleging that on or about the first day of October 2019 through the 31st day of December 2019 in Greenwood County, state of Kansas, you, Thomas J. Spexar, then and there, contrary to the statutes of the state of Kansas, did unlawfully and intentionally obtain or exert unauthorized control over property or services by deception and with the intent to permanently deprive the owner, to wit, Greenwood Properties, parenthesis, Paul Allen, Mike Clark, Carol Smalley, and John Jorgensen, close parent, of the possession, use, or benefit of the owner's property or services, to wit, cattle with a value of $100,000, parenthesis, approximately 237 head of cattle, close parent, in violation of KSA 21-5801 A2B1.
How many Big Macs
This
is
is
that?
filed as a level 5 person felony. And if you were to be convicted of that, your penalties would include a minimum of 31 months up to no more than 136 months in the Kansas Department of Corrections and a fine up to $300,000. Now, do you understand the
10
charge
years.
against you, Mr. Spexar?
This is utterly
And I can't hear.
I do.
Okay. Now, because this is still a felony, your attorney has surely told you that you do have a right to a preliminary hearing. You had that right when it was a level 7, but now that they've moved it to a level 5, you still have the right, but it's to the amended count. Your attorney says you wish to waive your right to preliminary hearing on this amended charge. And I will need to determine that you understand what you're waiving and the consequences of your waiver, even though you've done that before. Now, do I understand correctly, Mr. Weishman, that your client does wish to waive preliminary hearing to the amended felony charge?
Yes, Your Honor.
Very well. Then, Mr. Spexar, you do have, as you've heard several times now, the right to this preliminary hearing. A preliminary hearing is one in which the state of Kansas has the burden of producing evidence to make it appear that the felony crime has been committed and to show probable cause that you committed the crime. A preliminary hearing is not a trial to determine whether you're guilty or not guilty. Rather, it's a hearing to determine if there's enough evidence to require you to stand trial, or in other words, to be bound over for trial. You would have the opportunity to challenge the state's evidence, to challenge the existence of probable cause for further bail as to this felony charge. And you have the right to subpoena witnesses, to cross-examine the state's witnesses, and present evidence on your own behalf at this preliminary hearing. A preliminary hearing would apprise you about the nature of the crime charged and the sort of evidence you'd be required to meet if you were to stand trial. If you waive or give up your right to the preliminary hearing, however, there will be no preliminary hearing. You will be bound over to the district judge for further proceedings. You will be required to appear at a later date before the district judge for arraignment on the new charge. And at that time, you will enter your plea to the amended charge. Until that time, you will be continued and obligated to appear under the terms of your existing bond. Now, have you talked to your attorney about waiving your right to preliminary hearing?
Yes, I do.
And do you need any more time to visit with your attorney before we proceed?
No, I don't.
Do you,
Is he wearing
in
a
fact,
John Deere
want to
hat?
waive your right to preliminary hearing to this amended charge?
Yes.
Have any threats or promises been made to cause you to waive your preliminary hearing?
No.
Are you in good health today?
And today I am, yes.
Are you taking any medications which might impair your judgment today?
No, Your Honor.
Mr. Weishman, do you know of any reason why the court should not accept the defendant's waiver?
I do not, Your Honor.
And Ms. Gillette, does the state wish to waive its right to preliminary hearing on this amended charge?
State does, Your Honor.
Looks
Very
like Rocky
well, the
got some
court
sun on the
finds
4th of
that the
July.
state of Kansas has waived its right to a preliminary hearing. The court further finds that the defendant has made a knowing waiver of his right to preliminary hearing after consultation with counsel. It is the order of the court that the defendant is bound over to district judge for further proceedings, and the defendant shall next appear before the court for arraignment. And Missy, will that be with Judge Hart again prior to the jury trial setting?
I think Rocky fell asleep with his sunglasses on in the sun on the 4th of July. He's got that
Missy?
raccoon.
Can you hear me?
Raccoon
Now I
thing
can.
going.
July 31st at 9 with Judge Hart for arraignment.
July 31st at 9 a.m. by Zoom with Judge Hart. So, Mr. Spexarth, your bond will be continued with all existing conditions as well as the added condition
He's
that
leaning
you
over
appear by
to see
Zoom
around his
July
attorney.
31st at 9 a.m. with Judge Hart.
Yes, Your Honor.
Anything further we need to address?
No.
No.
All right, and thank you all for honoring your subpoenas to be here.
They were all
Your
subpoenaed.
testimony will not be needed as the defendant has waived his right to hearing, as has the state. At this time, you're all excused as we are in recess.
Wow. Cattle rustling, still a thing in Kansas. It's the Wild West out there, I guess. That's crazy. I think there are some states where it's still like legally you can shoot someone if you see them, if you catch them in the act. Like if they're stealing your cattle, you can shoot them, right? Like then and there, stone cold, judge, jury, executioner, all wrapped up in one. Kansas though says it's going to be 2.5 to 10 years in prison for stealing 237 head of cattle. That's $100,000. It's a lot of cows. Let's see if we have anything else coming up that let's see. Licking County still at recess. I think it's quiet. All is quiet here. Let's jump back over to Judge Wolf.
The bond restrictions themselves to see what is actually imposed.
Your Honor, I don't even actually have a list of them. I'm told there is one. I haven't seen it.
Well, in the case I'm looking at now, which is docket number 19744, on a charge of 2 counts of stalking, the bond conditions, as I see them at least, are no contact with the victim unless to discuss issues regarding their children.
Yes, Your Honor. That's the bond restrictions I was aware of. But there's been some issues with the ankle monitor. I don't want to cause any more issues. And he's being told by the ankle monitor company and I understand the clerk's office that there were more restrictions on locations. Like I said, he was told you can't go to church. And so, or that church. So we're trying to make sure he don't go where he's not supposed to.
We assume there are restrictions regarding his travel, but there also may not be. I'm just looking to see if I can find what bond conditions there are.
And that's the indictment he was just reading, or the charges he was just reading.
Okay, I missed chat for a minute. What did I miss? Sorry. You saying they're getting another note right now, Camilla? Or is that the one from this morning? We had one this morning. Well, one this morning was actually written last night, right before the jury went home. And we've got the other one that happened 2 hours into deliberation. I'm not aware of any others. Let me check. Matt McFarland.
Clerk has assisted me in locating what I think of this is the no contact order that was entered in. It's not actually shown as a bond condition per se, but it is a no contact order. Well, the main one is that the defendant is prohibited from harassing, annoying, telephoning, contacting, or otherwise communicating with the alleged victim either directly or indirectly. But then that is modified by a handwritten notation that may have contact with the victim to discuss issues involving minor children only. And subsequent to that, there was another provision that said the defendant is directed to vacate or stay away from the home of the alleged victim and to stay away from any other location where the victim is likely to be. I'm assuming that that is the provision you're referring to, General Silver. But I don't see that there is any restriction on his travel.
Okay.
So, you know, my suggestion would be that we just put an order down clarifying on this motion that all of the bond conditions remain in full force and effect, but that nothing in that bond, and there are no bond restrictions against him traveling as long as he is not, again, having contact with her or going to places where she is likely to be, which would be the friends and family that General Sylvie was referring to. So.
Well, I don't know who those persons would be because they've got extensive, they're a church family. I mean, they have friends through the church. She doesn't live in Tennessee. She's in California. If General wants to get with me and let me know when she's going to be in Tennessee, I'll be glad to tell him an address where she might be. But I mean,
I don't think they're going to want to tell you and let your client know when he is charged with stalking in violation of an order of protection. The last thing they're going to do is tell you where she is going to be located so you can relay that to your client. I mean, I would assume you understand the reasoning behind it.
I do understand, Your Honor. I also did the prelim in this one, so this is going to be an interesting hearing. But the issue is that my client, that just prevents him from going anywhere because he doesn't know when she's going to come to Tennessee or who she might stay with.
Well, this states that he is directed to vacate or stay away from the home of the alleged victim, to stay away from any other location where she is likely to be. Now, if, as far as he knows, she's not likely to be somewhere, then he's free to go.
Wherever.
And if she is there and he finds out, then he needs to vacate it to be in compliance.
Absolutely.
About as simple as it can be.
I'm good with that, just as long as that's how it's communicated and not just he's got to stay away from her friends' houses because he assumes she's not there.
Well,
they're his friends too.
We oftentimes, when I was General Sessions Judge, we used to explain it like this. He can go anywhere he wants to, but if he walks into Walmart and she's in Walmart, he leaves.
That's how
He goes to the church and she walks in, he gets up and walks out.
Absolutely.
It's just, I mean, the burden's on him to avoid it. You know, as long as he leaves, she can't complain.
Yes. Well, she wasn't at the church and they made him leave. So I'm just trying to make sure. Thank you, Your Honor.
All right. And are we ready on any of these other matters that we'll put on second call? All right, the Eric Lavoie Henderson is going to be at 1 o'clock. We'll bring him down at 1 o'clock. I have an officer coming with the multiple search warrants, so it'll be after 1 o'clock before we start. The sport ice on Rebecca Lambert, Joe Burt.
And then on Mr. Medina, we have a disposition. However, we wanted to discuss one aspect of that with you when you take a break to see if you're agreeable. Okay, let's do it right now.
Okay.
Yeah, I checked the message on Twitter about the note. That's a reporter who has posted 2 texts about this trial. One was about the first note, and that second one he just posted an hour ago was about the second note from this morning. So he's just behind the times. Nothing new yet, so we're still at just past 8 hours, 15 minutes of deliberation time. We've got the court up in the top left corner, showing that nothing's happening in Connecticut. If it did happen, you would hear it first right here. We have the live audio from court still turned on in case something happens without warning.
And we're trying to figure out one more thing on that one, and I think we'll have a disposition.
Yes.
Judge Wolf is just
Well, it doesn't sound like I have anything I can
a lot of fun.
take care of. So let's just go ahead and take our lunch recess. We'll stand in recess till 1 o'clock.
He goes to lunch for half an hour. Let's see if we've got. Let's see, I think we have another. Josh sent us something from Judge Wolf that we're going to try to pull in really quickly. So I eat my salad that Mrs. R.A. made for me. Let's see. (5-16-25) Dixon criminal docket. (5-16-25) Dixon criminal docket. I think we got it here. Two-hour 26 mark, 46 seconds, says Josh. Just 1 second. 2:26. Here we go.
All right, Mr. Vaughn, we're here today because you have filed a number of different motions, and I want to address those motions with you, give you an opportunity to be heard. So if you want to come to the podium, since you are representing yourself, I will deal with each of those motions. First of all, let me advise you that in April of this year, you sent a notice stating it was to the judge of record, stating that on the 15th day of April 2025, I have some concerns that I wish to speak to you about before I file papers in your court. I'm letting you know this isn't a request for advice. It concerns actions by your staff of the courts and yourself. With the utmost respect, I write this ex parte letter. If we can meet in private, I will. If I can't meet in private, I'll file it publicly and the order will be noticed. I could not speak with you privately because of the rules of conduct for judges. So the first notice or first motion that you have filed has been a request for a criminal record, and states that you're requesting the courts to move the state to furnish the defendant with a copy of a prior criminal record per Rule 16 of Discovery and Inspection, Rules of Criminal Procedure. If I understand correctly, you're asking for a copy of your criminal record?
Yes, all them requests, the motion discovery is supposed to provide all that anyway, so that'll summing up half the motions. I mistakenly filed them separately.
That's fine.
Some of them.
You're entitled to discovery requests. Here, when you have a lawyer, a lot of times what will happen is the lawyer will be given access to the electronic system that the DA's office has implemented, where all of the discovery information, all of the evidence is loaded into an electronic system that then the defense lawyer can access that defense. Now, you don't have that ability representing yourself. So I'm going to order that all of the evidence in Mr. Vaughn's case needs to be put into written form, hard copies, and he needs to be provided with that.
Judge, the problem with that is going to be that there are videos from his arrest. One of his charges is retaliation for past action. And so there are videos from the officers in the jail at that time. And that's going to be one of the largest problems in providing that to him?
No, sir. That's not a problem. I filed a civil suit years ago. They provided me with the DVD, and it was my issue to deal with after that. And they allowed me to go into the office privately, view my own case, to fight my own case before, so that is not an issue.
Sounds like he's got it solved.
Okay.
You provide him with a DVD or a video on a compact disc, he'll access it as he needs to at the jail.
Okay.
All right, when is this gonna be? Because I've been doing some of this since 2021. I'm tired of coming here looking at y'all. Like, this is going on for a minute. This is getting ridiculous. This is my first, I still ain't got a motion yet.
A motion?
I ain't got a motion yet. All the attorneys I had, all the public defenders I've had, nobody have provided me with nothing yet.
Okay. Well, I'm going to deal with all of that today because you're going to get written discovery. You're going to get a copy of any videos so that you can look at them yourself. How long will it take for him to be allowed? His trial date's in September. How long will it take to get the hard copies of the written discovery? All right. We'll have it within.
Ben, she should have it today.
We'll have it within 10 days. Okay? You have a second motion, which is a motion to remove your counsel. Mr. Spratt was appointed as what is generally referred to as elbow counsel. You want to represent yourself, and I've granted you that opportunity. I've also appointed Mr. Spratt to assist you in representing yourself so that he can, because you don't understand, I assume, the rules of evidence and the rules of criminal procedure fully as if you had been to law school. So having a lawyer who can assist you in making objections to evidence, for example, and things that's the reason that you have elbow counsel. So Mr. Spratt was appointed, and he has tried a number of criminal cases, is very competent as an attorney, and that's the reason. So why do you want to dismiss your elbow counsel or your assistant
For
counsel?
one, the court doesn't respect the fact I'm pro se. They prefer to talk to him instead of to me. And anything should come through me first. He's an assistant. For two, Mr. Spratt, since December, has had a sickness or illness going on, which is on record in Humphreys County Jail, where he never could show up out there. I called 2 or 3 times. I should have had the motion discovery he just handed me.
All right. Well, that's part of life, that people have illnesses and sickness. I am
not for a month and a half. I'm sorry, sir. Excuse me, but not for a month and a half. I mean, he ain't able to help me.
Right. Well, I'm of the opinion that Mr. Spratt is able to help you with this because he is only elbow counsel. You're representing yourself. I will order that the discovery and motions that are filed in his court need to be sent directly to Mr. Vaughn rather than a copy to Mr. Spratt directly to Mr. Vaughn so that he gets a copy without having to wait for his co-counsel.
He's winning so far. Is an elbow counsel like a shoulder angel?
No, you just have to mail it to him and he'll receive it. So I'm denying at this time your motion to remove counsel because I think it's important for you to have someone at trial to help you with that. I've ruled you're going to have access to the discovery directly. You're representing yourself. Mr. Spratt's role is as elbow counsel to assist you in, the trial itself.
Well, what about the fact that he couldn't even come to Waverly? How are you going to get to Decatur?
I'm going to appoint Mr. Spratt. You want to address any of that, Mr. Spratt?
I will, Your Honor. I'm not sure of what illness I had for a long time. I was sick back during the holidays. I did just hand Mr. Vaughn his discovery in case number 2021 CR 462. My understanding is the state wishes to proceed to trial in 2022 CR 336. There is no discovery that's been provided to me electronically for that case. When I did finally feel better and go to see Mr. Vaughn, he had been transported to West Tennessee, and I just simply have not been able to make it down there with my schedule. But he does have the discovery, or the written discovery. I did not give him the electronic discovery today because of reasons which he's now clarified.
Well, I told you that too when we talked on the phone. Me and you done been over that.
Let me hear from Mr. Spratt. This is not a time for you and him to discuss.
I mean, I'd be happy to mail him a DVD of anything electronic for that case that I have. I only have discovery for one case.
He needs the discovery for the case he's going to trial on, so let's make sure that that discovery is provided to him. Ms. Bryson says she can provide it to him next week, so I would order that she provide that by mail to Mr. Vaughn next week, as he wants to have it directly, and then a copy to you, Mr. Spratt. All right. I am denying your motion to discharge Mr. Spratt from being your elbow counsel for the reasons I've stated on the record. Another motion you have filed is a demand for speedy trial. Your trial date is in September, which is the next term of court that I have. It's available, and for that reason, I believe that that complies with the request for speedy trial that was filed. It is the first available date that we can put into play according to our rotation of judges and our schedule that we have. That is the first available day. The September date does, in my opinion, comply with your request. Case won't be continued, so we'll need to make sure that it is ready for trial on that day. The remaining motions that you have filed are all motions for discovery, which I think you had mentioned before, and I think we've now addressed that. So he's set for trial on September the 19th, is that correct? That needs to be shown to be first on the docket.
Excuse me, sir.
Docket, so that we'll go to trial. And let me address this. You filed a motion to recuse, notice of recusal or request for the master clerk, and you're asking to recuse or to somehow recuse the clerk of the court, and there is no basis that you have no basis, you have no standing under the law to ask this court to disqualify the clerk of the court. I understand your reasons for why you say that, and I have addressed the problems that you're saying you've had thus far with receiving copies of things, and that's going to be mailed directly to you. The court file will have it reflected that you are to receive all of those as lead counsel in your case, and I am not of the opinion that you have a basis in law or in fact to remove or ask for a recusal of the circuit court clerk, so that motion is denied. In addition to that, you had a motion to recuse the court recorder, and again, I have no idea why you would allege that there is a reason for that, but I don't find any basis for removal, or that you have standing to remove the court reporter. She worked for me, and under that basis, I don't find there's any reason.
Well, then me and you have a conflict then, because you was on there doing the same thing they was doing. You want to put this on YouTube and not act a professional? Y'all want to make jokes in here? And then they don't want to file the paperwork? How am I going to get a fair trial here?
You're going to get a fair trial because you're going to be tried according to the law and the facts. And a jury of impartial people who know nothing about your case will make the decision.
So if I want to make an appeal and she ain't recording it, how are we going to do that?
She will be recording it if it is a felony case. There are certain times when the cases are not recorded, or if we're on break, it's not recorded. But
well, we wasn't on break because look, I just walked out the courtroom and I said something after we went on break. You said omitted, and she said, "Well, I ain't got to omit it." She said I wasn't recording no way. So how can I appeal something if y'all taking it out of the record without me being present during the proceedings?
Well, first of all, I don't recall any such thing that.
Well, go back and look at the video.
I'm not required to go back and look at the video, Mr. Vaughn. I'm required to make decisions based upon whether or not you have standing for the motions that you filed. In my opinion, you don't have any standing to ask this court to discharge our court reporter or our clerk. And for that reason, I'm denying those two motions.
Well, recuse yourself because you're not doing it. You're not doing it.
And there's no basis for me to recuse myself.
Is this being recorded?
If you want to file a motion for me to recuse myself, then I will deal with that under Rule 10 and then I will.
I'm
address
familiar
that.
with all the rules. Y'all sit me in jail long enough, best believe I read them.
All right. Anything else?
No, that's all.
All right, thank you.
Briefly, if I may, when would Mr. Vaughn be transported up for this trial? Because the trial that I
I done
mentioned.
put in 3 motions for that. That ain't get heard neither.
I'm just asking the court, because the trial that I have in Davidson County that I mentioned in the earlier matter is the first of that week. We do not expect that to be a 5-day trial. But I'm wondering if I'd be able to meet with him to strategize at all for this trial beforehand, other than Thursday, the 18th.
We can order that he be transported earlier if you just tell me when you want. The 17th?
No, I like my cigarettes where I'm at. I don't need his assistance.
Okay. Well, that'd be fine, Your Honor.
That's fine with us.
Yes, sir.
All right, thank you, Mr. Vaughn. You step back.
So what are we doing in September? Look at his escort. He's got 4 bailiffs.
Leaving the room.
All right. I believe now that we've dealt with Mr. Fan that concludes our business for today.
Wow. We watching this one? Josh, can you keep that on our docket? If that makes the light of day, if that that case moves forward, I'd like to see how that goes down. I like my cigarettes where I'm at. Thank you. Looks like Judge Boyd is on lunch as well. Judge Wolf, who we just watched, is still on lunch in real time. That was from a bit ago. We're still in a holding pattern for hang on. Why is that not working right? Oh, we want this one. They want me there. Super source, box source to 4. There we go. 8.5 hours of deliberation time have passed. Judge Stevens. Oh, we got a parole board, Louisiana parole board.
Does have any questions?
I have.
Mr. Frazier, what happened in the emergency room?
I went for I had brain tumors and I got heart murmurs. And I went for MRI with a CAT scan and EKG, and he had tried to give me a shot. I forgot what the shot was called, and I told him no. And then they had strapped me to the gurney or whatever. And then after that, they came there and he booked me in with assault and a battery. But they had told me they were dropping. They had told me that I can't get revoked for criminal mischief. That's the only reason I pled guilty.
Well, I don't know if they told you that or not, but that isn't true.
I had a paraphernalia charge that I went to rehab for. This is my the second misdemeanor that I've got.
If I can, I will say that it was that my appreciation and considering I've known Mr. Frazier for a while and been involved in his representation, he does have some mental health issues, and I would suggest to the parole board that a lot of his conduct is tied into his mental health issues, which is why I was appointed to represent him for this parole purposes. And I think, in being in that hospital, he was clearly having a mental health episode, which he clearly has a history of.
Okay, so Mr. Frazier, where were you residing? Where were you living when you were on supervision?
Staying in months right there by the Place, 101 Churchill down.
Okay, and did anyone else live there?
My dad, he did live there, but he had passed away as soon as I came to jail this time. As soon as I went to the hospital, he had passed away.
Okay. So you were actively doing drugs according to your parole officer. There were dirty needles and spoons on the floor, evidence of drug involvement. So you were doing drugs while you were out. Is that correct?
I had a paraphernalia. They found a spoon in my room, and my dad's diabetic. But they did find a spoon in my room, and I had to go to rehab for it. But other than that, the needles, my dad's diabetic. But he has needles.
Okay. So had you been receiving mental health treatment while you were on supervision?
I take a shot. I take an Invega shot once a month. I go to the mental health center and I take a shot once a month.
And you were on the shot when you had this episode at the emergency department?
Yes, ma'am. The medicine they were trying to give me at the emergency room is for like it affects your DNA. And I didn't know how many brain tumors I had at the point. So I told him no, and then that's when he harassed me and put me on the gurney. And after that, I just done my time.
Okay.
I tried to tell him that I didn't want a shot because I didn't know about my brain tumor.
Okay.
This guy needs help, medical and mental.
Your expiration date is 2026. So I think my concern is, do you have a stable place to stay?
Yes, ma'am. Yes, ma'am. I have a stable place to live.
You have a stable place, and do you receive government benefits?
I'm a tattoo artist.
Okay.
I do tattoos.
So you are able to
my cigarettes.
support yourself.
Yes, ma'am.
I'd like to go into executive session.
Okay, we have a motion for an executive session.
I second.
Got a motion and a second. All in favor, say aye. Aye. So we're,
Brown?
yes.
Lulu? Yes. Tibbs?
Yes.
Okay, we'll be in executive session for just a few minutes to discuss this, and then we'll come back and ask any more questions or make our decision. All right, thank you.
Yes, sir.
So Kathy says, I guess I missed something this morning. What was the question the jury had this morning? The jury had a question that they actually filed last night. They'd given it to the judge right as she was coming out to say, hey, we're going to bring the jury in and send them home for the night. That question was another note saying we are still hopelessly deadlocked on all the charges. But something in the note told the judge that they were still deliberating. Possibly because it did include the count, which this time the judge did not read. The first time she did read the count, said it was 11-1. This time she did not read it. That count might have been different. It might have been 10-2. But we're still waiting, and now we're at 8 hours and 40 minutes. There's nowhere to send people. I can tell you that jail and prison is a very poor place for mental health treatment. Although, in some cases, some individuals will get more help there than they're getting on the outside. Group homes stay full. There's no funding for all that, for the demands. I don't know of any states that do this properly. Deadlocked on all the charges, even the assaults? Yes. All it takes is one holdout. If there's one holdout who feels that the entire incident was self-defense, that all 4 charges are covered by self-defense, they are hopelessly deadlocked. If there are 11 people that feel that all the 4 incidents are self-defense, and one person feels that they're not, they're hopelessly deadlocked. Could be either way. Angie, it takes mental health professionals, one of which I am not. But it's clear that that there's confusion about what was happening, what was going on, and a mental health episode can easily look like resisting arrest or assault or something like that. But when you realize the individual who's going through that feels like they're the victim of assault or worse, it makes a little more sense, even though their thoughts might be irrational and not based in fact. It's just as real to them that something terrible is happening. They're fighting for their lives or something. And let's see what the decision is.
Okay, we are back, and we need a motion to get us out of executive session. Got a motion and a second to get us out of executive session, go back into regular session. And I guess we need a vote on this. All in favor say aye. Aye. Any opposed? Okay, good. There's not. So we're back out of executive session, and we are back with you, Mr. Frazier. We had talked about this, and I think it's time for a vote. Ms. Ledoux, would you tell us what your vote is? I guess we ought to give the attorney. Is there anything else you'd like to say, sir?
They've already voted.
No, sir.
Okay. What about the attorney?
I will just say that again, and the reason why I believe I was appointed just for the sole purposes of this parole revocation was because of Mr. Frazier's mental health and history of mental health issues. And while obviously Mr. Frazier has had a history of drug abuse, and I'm sure that plays into his mental health issues. I believe that the conduct for which he's before the board was clearly he was having a mental health episode. He might have been on medication, but as I'm aware of in my practice, is medication and these sorts of things wax and wane, and medication helps sometimes and it doesn't. It needs to be adjusted. So I would ask the board to take Mr. Frazier's mental health history and what I believe to him being having a mental health episode when this occurred, take that into consideration.
Okay, thank you, sir. We'll do that. Mr. Ledoux?
And that's what I was reviewing, is to make sure I understood the sequence of the events. Mr. Frazier, apparently you did have some substance abuse problems that were addressed through counseling, but you continued to be to use illicit drugs. I believe that you were having that mental health was a significant part, but you were also under the influence of illegal drugs during the commission of that hospital scene. My vote today is not punitive, but I am voting to revoke your parole. But I'm stipulating that you need to go to Elaine Hunt for mental health evaluation and substance abuse evaluation during your time. Yeah. So my vote today is to revoke with those stipulations.
And my vote also is to revoke.
Okay. And I likewise am voting to revoke because you're in violation of I believe it's number 4, which is violating the law while on probation or parole. And so for that reason, your parole is today revoked, sir, and good luck. Time is now 12 noon.
No. Thank you. Just note my objection for the record.
Lawyers like, that was the wrong answer. Wow. So parole, when you're granted parole, that's when you get out. And if your parole is revoked, it means you don't get out. All right? So he's back in jail. Is that my understanding? He broke the law by assaulting someone while having a mental health episode at the hospital, getting a shot that he thinks was going to kill him. Great work, legal system. Is it correct the judge has not given the jurors an Allen charge yet? It is correct. The only difference is in Connecticut they have a different law. They call it the Chip Smith charge. It's still an Allen charge, but it has specific parts or components in there that are designed to prevent the coercion of a minority holdout. So there's that. I was seeing if they're going to come in with the next session. Usually it'd take a couple minutes and come back with the next one. Let me look at the schedule here. Let's see. That was... Got a couple more. Riverbend, D.C., Charlie Matthews and Terrell Johnson. Charlie Matthews has an older inmate number. Is that what it is? Well, not as old as Henry. Not sure. Not sure if that's inmate number or case number or something. If she gets another note, she will need to give the Allen charge. Yeah, but that's like sending them back over and over and over. They've got to be frustrated at this point. She's told them 2 times. They probably think they have to get a verdict. If she tells them again, it will be telling them that they don't have to switch if they hold a strong opinion. They should not switch. Do we know what count that was and what? We don't know what the count was the second time. The first time it was 11-1 on the first charge, but just the first charge. What is an Allen charge? An Allen charge is instructions the judge gives a sitting, deliberating jury, trying to get them to break the deadlock that's preventing them from reaching a unanimous decision. It's the go back to work, try again, relook at the facts, talk to each other, try to see it from somebody else's perspective, and vote and see if you can come to a unanimous decision. But Allen charge, dynamite charge, Chip Smith charge, it's all the same thing. It's just every state has their different name. Still nothing from Judge Wolf. Let's see if we've got anything else. Judge Simpson is still, well, he's got an expungement and motion docket now. Ooh. These are sometimes interesting. Getting your record expunged. Sometimes that can be a good thing. But he is, he's currently on break for that one. Let me see if we can go back a little bit and see what happened there. Nothing yet. So he's about to start this one. We might hold out here just for a minute. He normally starts about 10 minutes after the hour. So we might have an expungement coming up. But they can be really interesting. Expungement is when generally after a significant time has gone by, you've completed your sentence. You've re-entered society, being a contributing citizen, have not reoffended. You can go and ask, in some cases, that your record be expunged, basically get that wiped off. How do you spell that word? Very carefully. A lot of times you'll have somebody who's It's been many years, 20 years. They're up there as an adult for something they did as a young adult, and just would like that wiped off, expunged. Not quite. Not quite. It's spelled like this if you look. Expungement. Expungement. So. Love that some states are giving automatic expungements on non-violent offenses. I think Judge Dad should include that. If you do time, it should be automatically expunged, because everyone who doesn't do time just gets to take impeding traffic and no points. So expungement is useless thanks to the internet. Use expunge in a sentence. All 3 of my cousins who have 4 DUIs between them have had their records expunged. Duflé, thank you. Very, very good. You get an A. I just wondered if we'll find out what the numbers of for and against was. The judge put it in the file and basically sealed it, but had shown the attorneys, is my understanding, the note, so they saw it. But I don't know if this note had more information as to which side the majority's in. My ex was a sponge. Your husband. Amy, I'm sorry. I saw a message from you back there. Didn't click on it, but I saw some messages of support for you. Right there. Oh, we have a prank call. Come on. Hello? 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 Man. Okay, we're connected. If we get another one, we'll take it. I think I took too long. All right. Amy, thank you. Thank you. Thank you. I appreciate it. This is an amazing community here. I think it was good for Raul. His lawyer gave him a pat on the back this morning. Yes, there is a difference. Is it easy to get your juvenile record expunged? Not asking for me. I don't know. I imagine it might be different in each state, but Ivan, you are being targeted. You are being targeted with a social engineering attack is what that's called, where they try to make friends with you to glean information. And every bit of information you give one person, the next person who calls you from the same group has that already. Juvenile record is typically sealed. I managed to make it through my juvenile years without picking up a record, only because I run fast and the cops didn't. Generally, it would have been mischief related, but Mike, next trial, we're not going to pick up till Monday. I will be here today and tomorrow, and then I'll be off Thursday and Friday. So I'm in Virginia doing filming. Just pay a lawyer around $1,200, and then the lawyer does all the work. Is there a Chat GPT version that's cheaper? I always got calls for William. After 2019, I started replying that he had passed from COVID. The calls stopped. That's... You've got to use these things to your benefit. What's that mean, sealed? It's basically not available to the public. It's locked up, kept somewhere safe that some authorities would have access to, but generally it's not doing it. I'm not getting calls, all texts. Oh, tons of those. I get those as well. And it's like, hey, are we still on for golf tomorrow? Or what time are you going to be at the restaurant? Or, something like that. Just some like random question from somebody I've never seen. And then I'm like, you've got the wrong number. And they'll say, oh, it's so fortunate we met. How are you doing? Never do it. They'll eventually try to get you to go to some other app to communicate, where they'll try to send you a link, which will appear to be a file and be a virus. Don't do it. Are we still waiting just a little bit longer to see if Judge Cedric Simpson comes in with an expungement case? He just started this live stream just a little bit ago. Apple Treasure member for 18 months, the best true crime community out there. Recovery Addict and the wonderful mods make this a great place to watch and chat. Melting in South Carolina. Melting here as well. We're currently at 92 degrees and rising, and high humidity as well. Some scammer in California invited me to their family barbecue. I've invited a few people to watch on the channel. We might have a few of you might have been scammers at one point. If you are, you don't have to own up to it. But welcome. Good to have you here. Do you mess with them? What I like doing on the text message ones is getting the lyrics to a song that's more like conversational type songs, and no matter what the response is, just post the next line in the song. I've got nothing but time, Ivan. I've got nothing but time, so I like to wind every one of them up. Hello? Is it me you're looking for? That's... What's a good way to block text spammers? Sherry and Max, the best way, the most effective way is to get rid of your phone. For most people, that's not an option. But that is 100% effective all the time. Other than that, it's a constant battle. Angelo, I was scammed into joining this group. Best scam ever. 21 months. Shh, don't tell them. Yes, a wonderful, wonderful scam. Glad to have you here, Angelo. You can never leave. Thank you very much. My kiddo was just on TV. That's awesome. I'm back from lunch, but kept Recovery Addict going in my office, so never really left, says Tony. Thank you, Tony. You didn't miss much. It's been a slow day as the jury has now deliberated just over 9 hours. Did you see Magoo was arrested again? There's 2 hearings. I did see that. Didn't surprise me. He's takes a bit to get through sometimes. If the phone doesn't ring, it's me. Thank you. Yes, hopefully your child was not on Crime Stoppers or cops or hoarders. Any one of those 3. Oh, we had a proposal in chat. Look at that. Paula? I'm thrilled to be able to be here and... Oh, wait. This is a song. You're quoting a song. Sorry. Squire says I'm already married. So I thought you were proposing, Joe. I thought this was the big moment. You're down on one knee. You had the ring. And Paula was about to consent. All right. They're taking their sweet time here. We'll keep an eye on Judge Simpson and maybe look around some of the other courts to see if anybody else is going to go live. I think Judge Wolf, where's he at? There he is. Judge Wolf is on lunch for about another half hour. They get a long lunch. Judge Boyd should have a trial going in her courtroom. Judge Boyd is probably about to begin if she hasn't already. Let's weigh in. Let's jump in and see what she's doing here.
67, 68,
Jury
69,
selection.
and 72. Is
Jury
there anyone
selection.
else? All right. Number 2, what is your time constraint? Oh, where are you going?
Going on vacation.
Where are you going?
I'm going to Minnesota. It's a baseball game.
Staycation.
Yeah.
Okay. All right. Thank you.
Okay.
Number 4.
I've got a staycation. I can't serve.
Therapy appointments. That's embarrassing.
All right. What date?
That would be tomorrow and Friday,
All right. What time tomorrow?
3 p.m.
And what time on Friday?
3 p.m.
Thank you. Number 7.
On the 19th, I'm going to St. Lucia for vacation.
One of my classmates went to St. Lucia. So when do you leave?
The 19th.
All right. Are you going by yourself?
No,
Family?
my husband and some other friends.
Oh, well, thank you for letting us know. We're a little bit jealous, but okay. Number 11. Oh, remember to keep your voice up.
Thursday.
All right. And where are you going? And it's just for vacation? All right. Thank you. Number 12.
Cancun, Mexico on Friday, June 11th with my family.
All right. Cancun or St. Lucia? Oh, no. You're competing here.
Oh, okay.
Number 14.
Vacation.
All right. Thank you. Number 15.
Everyone's going on vacation.
All right. If you could speak up for the court reporter. All right. Thank you. 16.
I'll be on vacation next Thursday, the 17th through the 24th. I'll be in Houston for the first 2 days and then Chicago for the remainder.
All right. Thank you. 16. I'm sorry. That was 16. 21.
I have 2 appointments tomorrow morning at 9 and tomorrow at 3.
All right. And are these doctor's appointments?
Yes.
All right.
At the 3 is my annual physical that has been scheduled a long time ago.
All right. Thank you. 27.
Missed appointment
When?
tomorrow
What?
2 p.m.
2
Never
p.m.
been grateful for a
Are
dentist
you expecting
appointment.
good results from that?
I hope so.
All right.
Dentist appointment.
31.
On Friday, I get my kids.
Oh, you need to stand.
On Friday, I'll get my kids and I'll be on vacation for a week with them.
All right. When do you pick them up?
On Friday,
What time?
8 o'clock in the morning.
All right. Thank you. 40.
I have a doctor's appointment tomorrow for to review 4 biopsies, and at that time they'll decide whether radiation or surgery.
All right. And what time is that?
4:45.
All right. We're going to say it's going to go well. 42.
The Malbo conference next Wednesday starting at 5 p.m.
All right. Thank you. 43.
There's appointments on the 17th and 18th.
What time?
8 and one's at 5.
All right.
8 and 5. You have
Number
appointments?
45.
No dentist opens at 8.
16th through the 19th.
And then it opens
I'm sorry.
at
Could you
5
speak
either.
up?
16th through the 19th.
Texas Gulf Coast.
Yeah. Yes.
And what dates again,
What,
please?
Galveston?
Through the 19th.
All right. Thank you. Number 52,
Military contractor work, in Oklahoma from 14th to August.
the 14th of July.
Yeah, July 14th, August.
All right, thank you. 57,
Oh, sorry, that's me. I have a post-op surgical appointment tomorrow at 8:45 a.m. And then Friday morning, I leave for Dallas, Texas for my second job. From there, I'm flying to Las Vegas and I won't be back until Monday night.
all right, so Las Vegas, you're just there to have fun. You can
No, I sing for a living.
All right, thank
She's a
you.
singer. Who's singing in Las Vegas?
59.
Who is this?
Yes, Your Honor. The 20th through the 26th, my wife will be out of town at Rockport. She has a court case. She's a paralegal. I have 2 kids under 9 that I got to take care of. I'll probably be on PTO.
All right, thank you. 60,
I travel for work. I know I have some shifts coming up in Seguin and Lockhart, not very far away. I just do know that I do have those shifts coming up on the schedule.
all right, thank you. 67,
12th and 13th, I'll be in Austin for vacation.
all right, thank you. 68,
I have business travel for my company. I haven't forecasted for a week until it gets approved, so I don't have an exact date, but I know in the near future, within the next couple of days, I'll be traveling out.
all right, thank you. So everyone, when you speak, please don't let your voice trail off because the court reporter needs to take it down. 69,
My vacation starts on the 12th. I'll be in Fort Worth. My son competes in go-karts, so I'll be doing that.
all right, thank
Go-kart
you.
racing.
72,
Tomorrow, I'm spending the week with my grandmother.
does she want to see you? Sometimes they're like, we're done.
Judges call him BS on
All
that one.
right. Is there anyone else? See, now they're like, it's not so scary to raise my card. All right. 29, yes.
I'm going to be in San Marcos for Wednesday through Friday for vacation. Then July 12th through 13th, I'm going to be in Austin for my, I guess, vacation / birthday.
Okay. 39,
Surgery cases on July 11th and 18th. And
I'm sorry, what?
I'm the only assistant available to be there face to face.
All right, thank you. Who else?
She's a surgeon's
53,
assistant.
Family vacation.
where? A family vacation in Vegas? Are there underage children? Okay. Who else? 54?
Work travel, Friday the 11th, Eagle Pass, and then on the 12th to Dallas, to return to San Antonio to on vacation to Port Aransas on 13th.
All right. Who else? 56?
I leave on the 18th to Galveston for a cruise that leaves on the 19th.
All right, thank you.
Cruise out of Galveston.
61.
Galveston.
I'll be in Mexico City the 19th to the 27th to visit family.
All right. 71?
I'll be in Lady Bird Johnson Lake from the 18th to the 21st.
Thank you. 74?
I have an appointment tomorrow, flexology appointment that charges to cancel. It's at 10 a.m. And I also have family coming in on the 21st, my grandbabies.
All right, thank you.
Thank you.
Charges to cancel.
All right. Yes, 9.
Speak up.
What time? All right, and so you're the only parent who's going? Okay. All right. So there are 2 things that I want to tell everyone. One, I understand when people have work issues, right? But this is what I always tell people, to determine whether or not your job is indispensable. What that means is if you're not at your work, nobody else can do that job. And that means that that job is just going to become extinct because you're the only person who can absolutely do that. For me, guess what? I'm not indispensable. If I could not do this job anymore. Another judge is going to come in here and do this. So I tell you all that because jury duty and jury selection is very important. Everyone wants someone who will listen to the evidence and be focused on that and make decisions if they can come to decisions based upon the evidence that they hear. I always tell people jury duty is an inconvenience. Why is it an inconvenience? Because one, traffic is horrible. Some bright person decided that to alleviate traffic, the best way to do that is to have a bunch of one-ways. Buildings are not labeled appropriately. Then people, when you come, it's hurry up and wait. I see you all rushing to get there at 8 a.m. I'm like, please don't fall, slow down. It's going to be fine. They're going to get you assigned to courts as soon as possible. So it's an inconvenience. How many people raise your card if you've actually served on a jury where you've actually heard evidence? Raise your card. There are 4 people. So that is jurors. Could you keep your cards up, please? That's 46, 49, 63, and 70. And there are 75 people here. Your government only asks 2 things of you. Pay your taxes and serve on a jury once in a blue moon. That's not even a tenth of a tenth of a tenth of the people. And there's only 4 people. Your government doesn't even call you up every 3 months. They call you up once in a blue moon. I know some people who've never been called up and they want to be called up. They're like, how do I get called up? So it's an inconvenience, and it's not much that your government is asking of you. This is what I always tell jurors a sacrifice is. My family grew up in a small town called Grand Cane, Louisiana. My uncle, everybody said he was super intelligent. So that was back in the day where all the teachers knew all their students and they knew all the families. So they would tell my grandmother, they would say, Miss Lane, we taught him all we can teach him. We're going to pass him on to the next grade. Now, when his sisters and brother got to school, they didn't like it that much because all the teachers said, you're going to really have to show us something because he's super intelligent. And they're like, oh, man, we got to come up here and do a lot of work. So he ends up graduating, and he graduates early. And there's a conflict that breaks out called the Vietnam War. And he goes to my grandmother and he tells her, because of civil rights and everything that's going on, I can't improve my lot in life here. So can you sign for me? Now, I know mothers say they have no favorite children, but there's something about the firstborn, because the firstborn is the child that you practice on. And you're like, yay, they survived my practice. But that's her firstborn. And there's a special kind of love that you have for your firstborn. So she signs for him to go. And this is back in the day. My grandmother, they started out having a radio. That's how you would hear programs, through the radio. So they didn't have a television set. Then they finally had money. They got a television set. It was black and white. It has 3 stations, ABC, CBS, NBC. NBC, you really couldn't count on because the weather had to be nice. If the sun were out, but the wind was blowing, NBC, you're probably not going to get anything. You put the aluminum foil on the mouse ears and just pray that you get something. Wasn't 24-hour television. At some point, the programming ended. And when that programming ended, when they were high tech, they would play the national anthem and the flag would blow. NBC didn't have the flag. NBC, you just get static. And it's like program is over. You wait till the next day for new programming. My grandmother did have a phone. Young people, I know you don't know what a rotary is. I know you don't know what a touch tone is. But my grandma's phone wasn't a rotary. It wasn't a touch tone. It didn't have numbers. Well, what ended up happening is you would pick up the phone, the operator would answer, and you would tell them who you would want to call. That's why they would have songs like Beechwood 45789, because that's who you want. Operator, I would like Beechwood 45789. And they would call that. So my grandmother had a 6th grade education, but she was super intelligent. She taught me to read, write, my ABCs, my numbers, how to tell time, not with this digital thing you see here, but where you have the big hand, the little hand, minute hand, hour hand. And so she would babysit me when my mom was at work. So she was super intelligent. One thing she figured out is that you did not want the military knocking on your door in uniform because that wasn't good news. The only thing she had for my uncle, of course, was his name and his number. You send a letter and you wait for that letter for months to come back. And if you can imagine, she's not living in a big city. She's in Grand Cane, Louisiana. And so she's waiting for the letters to arrive to make sure that her baby has arrived safely. That is a sacrifice. And when you think about it, nobody at that time knew where Vietnam was. Nobody knew what was going on. It's just that my baby is off somewhere. So I used to end that story at that point. And then Deputy Laura and everybody was like, Judge, people want to know what happened. You got to tell people, did he make it back? What happened? And so I would tell people, yes, he made it back. He's since passed. Some of his siblings have since passed, but I got a chance to get to know him, where I was cognitive of an age where I could listen to his stories and everything. So I tell people that story to let you know that this is an inconvenience, not a sacrifice. And this is the only two things that your government asks of you: pay taxes and serve on a jury trial once in a blue moon. Now, before I release you for your lunch break, if anyone, raise your card if you know anyone on this panel other than just meeting downstairs or standing in the hallway. All right. All right, so what we're gonna do is we're gonna take our lunch break at this time. I've had docket all morning. Court reporter needs a break, staff needs a break. So I'm gonna have you all line up outside, and I'm gonna need you outside by 1:30 p.m. So look to your left, look to your right.
That's where you stand.
You're responsible for that juror being in line. So, but make sure you line up outside and line up in order. Your placards with the numbers on them, if you could all leave those behind, and if you please take your personal belongings with you, and we'll pick up at 1:30.
So the judge tells him, this is not a sacrifice. This is not a sacrifice. You are now who has vacation, right? Now who has a dentist appointment that's going to keep you from serving. We're going to jump over to Judge Simpson. He's doing some expungement stuff. Let's see what's happening here.
Mr. Simon, it's your petition. Go ahead.
Thank you, Your Honor. Did the court receive my memorandum in support of our petition?
Hey, you had a memorandum in support? I did not see a memorandum.
Then let me just give you a couple of the highlights that were in there, Your Honor.
Yes, sir.
Pardon?
Yes, sir. Go ahead.
Oh, okay. Your Honor, my client has had, this is her only contact with the criminal justice system. She's had no contact since she completed her probation on time. She now is in, I think it's pronounced Duarte, California, where she's participating in a fellowship and at the UCLA Harbor Medical Center. She's planning on returning.
I don't like UCLA. Go ahead. Never mind.
That's why I quickly tried that, and she's planning on returning to Michigan. And Your Honor, she's not only eligible, but I also had her and attached it to the memorandum, do an updated assessment with Ms. Geiger. And Ms. Geiger concluded that she does not warrant or need further treatment or further educational services. In a case like this, sometimes I do that so that the court can have even greater assurance that the setting aside a conviction like this would be in the public welfare and consistent with the public welfare. So, Your Honor, we are asking for that privilege of expungement.
Spell anything you want to tell me other than the UCLA thing. Go ahead.
Just that it would be, it was something that happened a very long time ago, and I've learned a very great lesson from it. And it would, if this were to be expunged, help me with my future jobs, as well as multiple medical board licenses, and help me provide care for patients in the future. And I really appreciate anything you guys can do to help. Thank you so much.
All right. Has this kind of hindered you along the way, or?
I'm looking for jobs now, so I'm hoping that with my future prospects and being able to have to apply to many medical boards and different states, hopefully if this gets expunged, it will not hinder me from future jobs. So I'm starting now.
Starting now. Okay, very good. And actually, I have nothing against UCLA. That was Mr. Simon who started that all. All right. Okay. Looking over the petition, hearing the petition by Mr. Simon as well as the elocution of the defendant in this case, an opportunity haven't been given for the Attorney General and prosecuting attorney to contest this application, and neither contesting, saying the court does believe that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application do warrant setting aside the convictions, and the court does believe that it is consistent with justice and public welfare, and therefore your petition is granted, and I have signed the order. All right. Thank you. Thank you so much. Best of luck to you in the future.
Thank you. Thank you.
Thank you, Your Honor.
All right. Thank you, Mr. Simon.
Oh.
Court's going to stand in brief recess while we try to figure out.
Doesn't get through to anyone, but she's still in hold.
All right.
Simpson?
Yes, Phillips?
I contacted the attorney office. They said I don't have an attorney. I'm here by myself.
Oh, did they?
Yeah.
Okay, then just give me a second. Let me get your files back because my staff took them, and then I'll come right back out, all right?
Okay.
Court's in recess.
All right, they're going to go to a quick break. While they do that, let's jump down to Judge Raquel West. Let's see, I think she's on 7. Let's see what she's doing today.
Mr. Rojas, you have Tiffany English, 2 cases. Can I get the second one on English printed out, please? Good morning. Are you Tiffany English?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion in each case?
She will, Your Honor.
Ms. English, in 18-30705, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation June 10th of 2019 for the offense of assault on a peace officer, a second-degree felony, and that was a 7-year deferred probation. Is that correct?
Yes, ma'am.
And in cause number 19-31722, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2019 for the state jail felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
And Judge, I just want to clarify for the court's knowledge. I spoke with Ms. Cole. That was extended. When I first looked at it, it looked like it was 2019, and now it's 25, that it would have been expired, but I confirmed
That it had.
been expired.
Okay, thank you. Each of these cases allege that you violated your probation. Count 1 in each case alleges that you tested positive on a drug patch for tetrahydrocannabinol and cocaine May 8th of 2025.
THC
And is that
is
true
marijuana.
or not true?
Yes, ma'am.
True or
Yeah,
not?
sure.
Count 2 in each case alleges that you failed to provide verification of completing a job search. And is that true or not true?
Yes, true.
Count 3 in each case alleges that you are behind in your court-assessed fees. Is that true or not true?
Sure.
Count 4 in each case alleges that you failed to successfully complete the SAFE program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1 Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. English is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. And cause number 1830705, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your plea agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 1931722, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of your cases that shows these were agreements that I followed, so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas.
Yes, ma'am.
Good luck to you, ma'am. You can go back with the bailiff.
Thank you.
Shelton Reddick, Mr. Rojas. We're going on count 1 only.
Yes.
The copy machine is super loud.
Good morning, sir. Are you Shelton Reddick?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Reddick, in cause number 250050, the state has elected to proceed on count 1 only. It alleges that you committed the state jail felony offense of unauthorized use of a vehicle from October 14th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Reddick is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. See, Carrington Scott, Mr. Rojas. Good morning, sir. Are you Carrington Scott? Mr. Scott, in cause number 250538, you're charged with the second-degree felony offense of robbery from March 20th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand? And I have here...
Judge, actually, there's some priors that are not listed in the indictment.
Okay.
Yeah, I think his actual range is habitual.
Okay, and you've gone over that with them, and as notice either has or will be filed of those?
Notice will be filed. They give oral notice on the record today that we will file notice with intent to enhance his punishment based on his prior convictions. We will get that in writing and get that filed this week.
And there's at least 2 prior non-state jail sequenced. Okay, so Mr. Scott, if those prior convictions are true, what that means is that if you go to trial and you're found guilty, the range of punishment becomes that of a habitual offender, which is a minimum 25 years in prison up to 99 years or life. Do you understand? I have here on the computer a plea bargain rejection that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be to go, I guess, on count 1 only, and for a 15-year term in the institutional division of the Texas Department of Corrections. That would be to go on the robbery itself without those enhancements for a 15-year sentence. You have every right to reject that and have your case set for trial. I want to make sure you understand what your possible consequences are and what your options are. You understand all of that.
I understand the court.
And you want to reject that offer and have your case set for trial.
Yes, ma'am.
All right, we'll get that done. Mr. Scott, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, Mr. Rojas, you are released. Mr. Scott, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. Terry Thompson, 2 cases. Mr. Rojas.
We're going to jump. Ready to jump?
Hello?
Hello.
I don't know if we can hear you.
Hi, can you hear me?
There we go. We can hear you now. Okay. Let me look and see what I've got.
Judge Wilcox up in
So
Thurston
who's
County,
got
Washington.
The documents. Oh, you've got them? All right. 1 second. So, Mr. Sabian, what's the resolution?
Plead guilty as charged with
Okay.
90-day suspension.
All right. So, Mr. Stanton, it looks like you're ready to plead guilty to driving while suspended in the 3rd degree from that February event. Is that right?
Yes.
He's in a car
Okay.
right
Feel
now.
you had enough time with your attorney to make this decision?
Yes, Your Honor.
And in that plea of guilt are all of your rights to have a trial in this matter. Do you understand those rights?
Yes, Your Honor.
Do you know that if you plead guilty, you give up your rights to have a trial?
Yes, Your Honor.
And is that your choice?
Yes, Your Honor.
Okay, good. And I see that there is a recommendation here as to how the court should sentence you to this. Do you understand that recommendation?
Yes, Your Honor.
All right. And you know, the court does not have to go along with what the lawyers are recommending. You know that?
Yes, Your Honor.
Okay. And could impose anywhere up to the 90 days in jail and a $1,000 fine. And you're aware of that? Your connection's getting a little spotty.
Yes, Your Honor.
Okay, there you are again.
Welcome back.
All right. I've asked you to make a written statement as to what you've done wrong that makes you guilty. And you're saying that on or about the 5th of February of 2025, you were here in the city of Lacey. You operated a motor vehicle while knowing that your driver's license was suspended. Do you accept that as what you did wrong that makes you guilty?
Yes, Your Honor.
Now, has anyone threatened you with harm or made you any promises that have caused you to plead guilty?
No, Your Honor.
Okay. All right. Well, how do you plead to driving while suspended in the 3rd degree?
Guilty.
Okay. Well, I will accept your plea, Mr. Stanton, and I'm doing that finding you know what you're doing. That you're doing this voluntarily and intelligently, I find, and you're doing this understanding the consequences of pleading guilty, and that statement you made there supports this. And then we'll move on to sentencing, and I'm going to hear from the lawyers, but I will turn back to you as well. So
Nothing further from the city.
Okay.
Are you in a car right now?
Yes, Your Honor. Asking to follow the recommendations. Mr. Stanton is working, staying out of trouble, working on getting his license back. We're hoping the court will follow the recommendations. Thank you.
Okay. Well, Mr. Stanton, anything you want to add to all this?
No.
Where are
Kind
you
of
at?
lost you there for a moment.
No, Your Honor, you're working. Well, yes. I'm working. I'm trying to pay off my fines. I'm trying to get my license back. I'm sorry I drove without registration. Yeah, that is all. Yes.
Okay. All right. I see that
You're in a
you
car.
got a lot of fines and fees to pay off. Some of them in this court and some in other courts. So if it sounds like you're working, if you wanted to contact this court about any of the tickets you have here that are in the way of getting your licensing, feel free to kind of put something to writing, either email, snail mail, whatever you want to do. And the judicial assistant will get that, and she'll have one of the judges look at things. Maybe we can work with you, getting things out of collections, reducing fines. There's community service. Who knows what plan you might have, but maybe we can help get those hurdles out of the way. But I leave that to you to contact the court in writing so that we know you're ready to deal with it.
Okay.
Okay. So, okay. On this matter, I'm not going to impose any more money. I think there's enough. I'm going to accept your plea. You're welcome. I'm going to accept your plea and tell you that for the next year, you don't violate the law, which of course, as you know, includes don't drive unless you have a good license and insurance. And then we shouldn't have to have any more jail imposed if you follow those conditions. And then just work hard on your license.
Thank you, Your Honor.
You're welcome. Any questions?
I have a question. If you're working,
no, Your Honor,
and you're sitting in your car, how did you get
well,
to work?
have a good day, and good luck with getting that license reinstated.
Thank you, Your Honor. Have a good day. Bye.
So long.
Are there any laws? He drives off into the sunset.
And your next client, Mr. Sabian.
Judge, we were hoping to call Mr. Hernandez Estrada. I don't believe he's on Zoom.
That's at 10 o'clock. Mr. Jesus Hernandez Estrada is not on Zoom. We don't have anybody in a breakout room. Okay, not in the courtroom. We've got Ms. Almada here. Is that our only matter for Ms. Almada? That's all we have Ms. Almada here for?
I believe so, Your Honor.
Okay. I don't want to waylay you anymore. So it's 11:45. Let's give a notice to be here. We've got trial next week. Anything to know from?
Last contact I had with him was back in April, and maybe April, Judge.
Yeah, I don't think he's going to show.
Let's see. He was here April 22nd.
Could
He handed notice. We gave it to him on the record. We have the Spanish language interpreter present and his attorney. And then we were back May 27th again with a Spanish language interpreter. and his attorney, and future court dates remain for today. And so he's failed to appear with notice. Anything from the state or the city? This is the only thing on his criminal record here. We don't have a mailing address, so we can't summons him. The vehicle is licensed out of Oklahoma. Anything to know, Mr. Sabota, or your point of view from the city?
I'm guessing he's not going to show up.
I'd probably note the non-appearance, strike the panel and reset.
Don't have a way to give him notice because he hasn't given us an address. Do you have some updated address, Mr. Sabian?
No, Judge.
So
I'd probably just ask for a low bail warrant.
I'm thinking, all right, this is what I'm going to do. I'm just looking at everything I possibly can to see if there's.
Maybe the citation. Sometimes those citations list addresses.
Yeah, didn't. Unfortunately said unknown with an Oklahoma registration.
Oklahoma.
All right. What I'm going to do is just leave. I'm going to strike the panel. It's not present. Make a finding he's failed to appear, but leave it set for the 16th. If he appears over in Chandler, maybe we can transfer him. We can see. If he doesn't, then we might have to consider a warrant, but give it all the chance we can. We've got a text message reminder number. We've been sending him a text message reminder in Spanish. Maybe that's another avenue to dig around and see if we can't get him here on the 16th. So that's it for today. So
thank you for giving him another chance, Judge.
Here. All right. And then anything else to bring forward?
I don't know if Miss Ratzel's case was addressed while I was in the waiting room. Oh, there she is.
There she is.
We're hoping to enter a speedy waiver, Judge.
Ms. Ratzel, there you are. Hello.
Hello.
All right. So we've got trial scheduled for next week, and the plan is. Thanks, Ms. Almada.
Thank you.
All right. And the plan, Mr. Sabian?
Yes, Judge. Close to resolving. Miss Ratzel really needs a few days to think it over, but I understand. We might not get the next pretrial until weeks from now, but whatever the next available date is, I'm sure she'll make a decision by then.
Well, one thought is to keep things set for the 16th, strike the jury panel, and if there's a resolution, then we can enter it. Is that enough time?
Yeah, I think that's what she actually wished. Ms. Ratzel, you think you'll make the decision by the 16th of July?
Yes, absolutely. Thank you very much, Your Honor.
Great. No, we want you to have time to think about things. So I'm going to cancel the jury, though. And if we need to reset, we can reset. If you want to resolve it, we can resolve it. But I'll cancel the jury. And then you've already got notice for 9 o'clock. You'll be in courtroom 4, and your attorney will be there, and we'll take it from there.
Okay.
All right. Great. We'll see you then on the 16th at 9.
Thank you. Have a good day.
I could never grow my eyelashes out that long.
All right.
They look heavy.
Next.
See anyone else?
I saw Mr. Foster at one point. Is there something to take up at 10 o'clock on the Foster matter? I thought I saw him. Maybe I didn't. I don't know. But it's almost 11 and Mr. Foster's not in the courtroom nor on Zoom.
Pantoufle, they're deadlocked
probation issue. Mr.
On all 4
Sabota,
charges.
what's the basis on this one? Help me out.
Well, he needs the ADIS certificate. I think what was filed was a receipt for the class.
Yeah, we never got proof that he finished.
Yeah, and there was nothing, I think, as of Saturday in there that showed, the regular completion completion certificate of ADIS.
So the hope here, yeah, so he hasn't shown us proof that he did the Alpha Drug Information School. We've talked about that. He was
Bench
present
warrant.
in March.
We're going to bail on this one.
He
and
wasn't
jump over
present
here.
May 13th.
Hang on. We're going to bail. Back to, I forget whose courtroom this is. Looks like they were about to begin. Maybe I'm wrong. Everyone's just sitting in a holding pattern. This Judge Raquel West. Update on the jury deliberation. We're showing 9 hours and 46 minutes. It's probably 2 hours less than that if they took lunch break. But they should be coming back from lunch right now. Who's the guy in the background there with the lifted his feet up right there? Who is that with the blue socks, the blue ribbons on the socks or whatever? He looks really familiar. Anyway, what we have was 2 notes. Both notes actually came in yesterday. One after 2 hours of deliberation saying we're deadlocked on charge 1, 11-1. And then another note came in right at the end of the day as the judge was calling them in to excuse them for the day. So she just excused them for the day and said, come back tomorrow. We'll deal with it then. And the note was that we're hopelessly deadlocked on all 4 charges. But she said, keep working on it. We haven't heard back from them yet. Do you ever see any live streams from Kentucky or Tennessee? We don't see Kentucky a lot, although we'd like to see that the sheriff case that turns out it's a mental health issue. Seemed like something spicy when it first happened, but the sheriff shooting the judge, that's in Kentucky. We did just jump down to Judge Wolf earlier today. He's out of Tennessee. Do like those ones. What Texas court is currently on screen? I believe it's Raquel West. I think it's the judge in the picture. See this little mouse button on the timer? Straight above that. Right up here. Up higher, continue up there. I think that's her in the middle. Is it weird to have your own picture in your courtroom? Maybe that's somebody else. Dude's like, I don't know where anybody is. Ooh, look at that suit with the elbow pads. You don't see that a lot. Probably more in Texas than elsewhere, but Corey Richens got new charges. By new charges, meaning a whole book of them. We're probably going to cover that here maybe tomorrow. We've got until, I think, February before that trial rolls around in Utah. That's going to be a fun one. Anyone thinking she's going to take a plea on that? Yeah, I didn't either. It's weird because she's the only one who sees it. Everyone else has their back to it. Judge Wolf makes you wait 10 months to chat? 10 months? Is that, I didn't even realize that was an option. Let's see. Edit. Customization. Subscribers. Yeah, you can. You can do months, years. You have to be subscribed for 60 years to chat. Right? No, I'm not going to do that to this one, but holy cow. 10 months. Okay, just for a test really quickly. Let's go up and do a test. 10 months. I have now made it so you have to have been subscribed for 10 months to talk on the channel. Only subscribers of 10 months. Temporarily. I'm going to change this in just a second. I bet he meant 10 minutes, not 10 months. Look at everyone's like, yeah. Yeah. 10 months, no problem. Everyone's like, a couple of you are like, what? A few of you are saying, why can't I chat right now? Yeah, most of you, this hasn't changed anything. It didn't change anything for the channel. There's like 3 people who haven't been able to chat. We're going to change that back to 5 minutes. That is crazy. I didn't know that was even an option. Okay, 5 minutes. 5 minutes is back. That is crazy. 10 months. He does that so people involved in current cases don't get on and write crazy stuff. Oh man, I know he's had some trouble with YouTube, particularly. He's had some people upset about him live. The guy we watched today is upset about the live stream and stuff like that, but it's all good. A couple of you who have been here for a long time have had to unsubscribe and resubscribe again, trying to fix problems with YouTube. So even though you've been subscribed longer than that, it only counts the time from the latest. But membership's different, I think. Kim is ranked number 10. Kim, good job. Rudy's faring, member for 11 months. Thank heavens I'm at 11. Just barely made the cut. Oh, man. That's why I don't write anything but good morning in his chat. Who does he moderate his own channel? I subscribed to someone and it said 5 minutes and it took me an hour. Whoa. Yes, there was the time that Amber accidentally put it to members only chat instead of subs. I got quite a few messages on that one, Amber, even though it was fixed fairly quickly. Tammy E, I've been subbed longer. Yeah, 10 months, but longer. We know. No mods, barely anyone chats, honestly. Okay, everyone take your seat. One thing I like about this courtroom is the tufted back chairs and the wide, see that wide chair? This one over here, where's my mouse? This one, right here. You see that? The tufted back, it's like a lounge. It's like a bench. No, actually it's just a chair, I think. It's just this wide chair. But over here, it's an illusion. I thought it was a bench. Still, nice, high quality furniture there. Tax rate must be sky high in this place. I have chair envy. Because my chair is currently broken and wobbles side to side as well as back and forth. It's basically an ab workout, just being here on stream. It's 24/7. It's just like, well, not 24/7, but 6, 7, 8 hours a day. I'm just trying to balance. Like it's like sitting on the small end of a baseball bat with a doily on it for cushioning, of course. Amanda H has cracked the top 50. Good job, Amanda. Should have a 6. I should. I've got the whole keg, Roni. Forget 6-pack. I've got the whole keg. I use chairs a lot. Like I sit on this chair, you guys know, for like 8 hours a day. And I recline and I fall asleep in it. So I like fall over and fall back. It's not good for the chair. Someone bought Brandy a chair and had it sent to her. Wow, that's pretty cool. Does yours have lumbar support? No, mine is very basic. Think of glorified bar stool with the minimum armrests and a token backrest. That's what I've got. It is Amazon Prime Day. Maybe I should look for high. I've looked for a couple things. I sent you a link. The Jackery I have, the battery pack that I use, that I'm going to be using this weekend in Virginia, is dirt cheap now. It's like you can get it for like $3.99 or something on it. That was way cheaper than what I spent on it. Hope people are showing up. Is that Conan? Is that Conan O'Brien practicing law? No, that's not him. Okay, sorry, it's somebody else. You can see why I was confused. The hard drives I use in my NAS storage, these ones right here, these are Samsung little. You just slide them in. It's a SATA. I think it's a SATA. I don't know what it is, but just lock in. They're on sale, 25% off. They're only $76 each for a 2 gig SSD, or sorry, 1 terabyte SSD. Let's see. Tall office chair. Oh, they do have deals. Wait, that's the one I already have. With lumbar support. My lumbar support is broken. Oh, wow. Okay, you guys have to look at this chair. Just one second. I don't think I want it. It's sort of like a Frankenstein chair, but it all matches. This one right here in chat. Look at all the pads. It's got like wings. It's got wings and neck support, neck brace, and like a knee extension. It's sold by Come Homa. It's not tall enough. Oh, it's a gaming chair with footrest. It has an extendable footrest. That's why it's so weird. It's like a cross between a gaming chair and something you'd see in court. I need that right now after back surgery. Did Lucky make the chair? Yeah, I don't know. I will say that that today is Prime Day. For those of you that are on Amazon and do a lot of shopping there, if there's something that I linked the Jackery pack. Oh, hang on. Sorry, my bad. That was the wrong one. Copy. You were Jackery rolled. That's awful. Try this chair right here. That should be the right one. No gaming chairs for me. The problem is my desk is too tall for a gaming chair. If I had a gaming chair, I would be like way down here. You wouldn't be able to see me. You know what? You see the Franken chair? Why I call it the Franken chair? It looks comfy. It looks like you could sleep in it. It looks like it's blooming, like it's sprouting new cushions out the side. We'll need somebody who really wants that chair to try it out and give us a report. Where's the footrest? Ergonomic office chair with pocket spring lumbar support and outward fixed soft armrests. Footrest. Gaming chair with footrest. I don't see the footrest. Who's this guy in the $high suit waving around the leather folio? Oh, we can get rid of seconds now on the timer. Well, let me do this. Let me make it fit a little bit better. I think that is box 2. How's that? Has anyone ever beat Greeners to first in chat? Yes, a couple people, but I think he let them win. I did eat lunch. Mrs. R.A. brought me a beautiful salad, no dressing. But you think, oh, good, that's healthy, not having dressing. Yeah, but it was loaded with bacon bits. And we like to take our bacon bits and put them in the microwave so they get all bacony again. Mm. As we watch this, let you know that you can see court up in the corner. We can also show you court right here. We're listening. If anything happens, we'll bring it to you live. Let's see if we can go down here.
I'll just put it on some kind of protracting for 6 months. You're really looking for final completion of treatment in Grace Harbor. SCOMUS has only given you that he's attending, but the content, we have no idea. So I think just some final proof that he completed late this year or early next year.
Is this shirt stitched
on the shoulder?
Would be an approach.
Now, Mr. Pro, the court imposed a $120 probation fee on this matter. So you just say you're working part-time. What's your financial situation? How are you supporting yourself?
Mainly through school money.
Okay.
Oh, no.
So FAFSA.
And work. Yeah.
Any kids to support? Child support?
I do. Yeah, I got 2 kids.
Okay. All right.
Got 2 kids.
So,
1, 2.
All right. This is what I'm thinking. I'm going to say your job is to get information into. I'm going to give you a deadline by. Let's see, July. So you think you have 6 months more if everything goes smoothly in Grays Harbor?
Yeah.
Say by March. By March 1st, you have into the court your completion document from Grays Harbor Mental Health Court. So you'll get some sort of diploma that says you've successfully completed our mental health court. And you make sure that by March 1st that comes into my probation department, or you're in contact with my probation department saying, it's going to be April, it's going to be May, so they know what's going on. All right?
Okay. All right.
Okay. So I'm going to write all that down for you. Superior.
Okay. Amber sent me an awesome looking chair.
All right. And then otherwise, of course, you stay out of the Home Depot and the City of Lacey. You stay out of trouble.
Stay out of Home Depot.
And I'm going to waive that $120 fee. I don't think that's realistic. I mean, that's just going to hang you up. So I'm not going to have you have to pay that.
Amber, can you post the map?
Right. And
links
then
again?
as long as you don't violate the law and you don't go back to the Home Depot and by March, or you're in touch with probation, tell them when they should expect to get that completion document from Grays Harbor, then we should be good.
Okay. Sounds good.
Do you have any questions?
Nope. It's all pretty clear.
Okay, we'll work hard at mental health court, and that's it for today.
All right. Thank you, Judge.
Let me do one more thing, just make sure we got all of our contact information right. I have mailing on Randall Street in Aberdeen. Is that still good?
Yep.
And the text message reminder got to you?
Yep.
Okay. All right. Now you're on your way. Thanks.
Don't take out student loans to survive, though.
You're welcome. So long.
Unless you're doing it to go to school. It's the worst kind of loan.
And, Your Honor, that proof by date was March 1st of 2026.
Yeah.
Over your head.
In front of the Walmart.
In front of the Home Depot.
Yikes. Yikes, 2026.
Stacy, I think we're going to hear tonight. I think right before they break, they're going to say, we're done.
Okay.
But they're going to hand it in sooner. I took out student loans to feed my Bitcoin addiction. Did I do this right? It depends when you bought. If you did it in like 10 years ago, yes. If you did it right now, I'm not sure.
Mr. Swenson?
Libby, what kind of videos do you do? What's the content specifically?
I need to go into a brief breakout room with Dirk.
Tournament? Okay. All right, Mr. Sabian?
Yes, Judge, we have a couple of compliance hearings. I have a Mr. Peter sitting behind me.
Mr. Peter, why don't you come on up and join us?
Oh. Okay.
All right, sir. So you're here because you're on probation with the court for that reckless driving. You pled guilty in January of 2024. You got to stay clean and sober, and you got to go to you got to comply with your treatment. We got a positive UA, and you're not going to your sober support meetings, is what we last heard. So that's the problem. Anything different?
Yes, Your Honor. Mr. Peter is actually going to his AA meetings. He said he's going 4 to 5 times a week.
We're not getting proof of that.
So those are AA meetings. I'm not sure if those are the ones that court gets. He showed me.
If you're doing lapidary stuff.
Here, let's talk from Providence, what they're telling us. And you have to show Providence. And they're saying that June 12th, and if you need this, I can print this out for you, but monthly status report for May. In treatment, IOP currently on Zoom 3 times a week for 3 hours. You've attended your groups in May. Maintaining sobriety, no. Provided a UA on 5/2, which was positive for alcohol, and a UA on 5/22, which was positive for alcohol. Self-help meetings reported were 5. So program compliance, no, due to lack of sober support meeting attendance and continued use of alcohol. And their comments, he reported a, quote, one-time only use of alcohol at first test result. However, he then provided another UA that was positive for alcohol. This Virginia Harris says, I've informed him that he will need to come in more frequently to UA, and that if he's not able to provide negative results, they'll have to recommend that you go to inpatient treatment. So that's what we're hearing from Providence. I don't care what's on your phone. What I'm hearing from Providence is you're drinking and you're not going to sober support as much as they need. And that's a problem. So that's a violation of the court order to stay clean and sober. And part of that is doing recovery, getting a group around you that's in recovery so that you have people to turn to, so that maybe you can not use. And then, of course, the treatment's helping you with tools and education to try and buoy you up and hold you up. But we can't have you out there endangering the community. So I have to decide what to do here. You're on a deferred prosecution in Pierce County. Or do you have a hearing coming up there? You heard from them? Okay, because they're likely going to think about revoking or taking away that deferred prosecution because drinking. And this is this was amended to a reckless driving from a DUI, but that's what we're trying to avoid.
We're going to switch to Licking County. Josh says go here.
So
when did that occur? Let's start there. When did that occur? Initially, my training occurred on electronic speed measuring devices in the academy, where we learned to use the ability.
Let me mute this just for a second. This is the same court we just watched the pro se guy in. Now we have a speeding ticket, possibly might be pro se as well. But
as far as the radar unit itself, what did the training teach you? What was the substance of the training ultimately? That we could use the radar accurately. We also had to demonstrate that we could estimate speeds by visually estimation, and that the radar uses a Doppler effect to calculate speeds.
So a couple different things.
And then auto and the auto tone, what that means from the radar unit as well.
Sure. So let's unpack that a little bit. You talk about visual estimation of speed. What does that mean? How do you qualify for that? How do you go about that?
We demonstrate in front of a ESMD instructor that we can visually estimate speeds accurately within 3 miles per hour for 20 different vehicles.
Okay. So that's the first threshold. You have to be able to visually estimate the speed within the 3 mile per hour window, I suppose, for lack of a better word, and then you can use the radar device itself for the laser device.
Yes.
Okay. The next portion of that, do you have any updates at this point in time? Do you have a refresher training for these items during the course of the year?
Yes. Every year we have to also demonstrate that we can still accurately estimate speeds and accurately use the radar device as well.
So is it fair to say when you're going down the road, you're using your visual estimation, and then you use the device, whether it be LiDAR or radar, to confirm that speed at some point in time?
Yes.
Okay. Back on that day, we first mentioned June 12th of 2025. Do you recall which devices you were using with regard to this case involving Russell Hayes?
In my patrol car, I was driving my normal patrol car, which is equipped with a B3 radar.
Okay.
And then the laser is an ultralight LTI 2020.
But as far as this case, we're talking about the radar device.
B3.
Okay. So when you get into your car for the shift that day, how do you ensure that that radar device is working properly?
I check the radar unit itself, check the calibration on it, using a set of tuning forks that are tuned to 50 miles per hour and 20 miles per hour.
Okay.
I turn the radar unit on. It does a pass and fail check. It's never failed in my, I can speak for that radar, in my patrol car. When I've done the checks, the beginning and end of my shift, it's never failed.
Okay.
So I turn it on, and then I go into initially my stationary mode, place the 50 mile per hour tuning fork in front of the front antenna, strike it on a non-metallic surface, and it reads 50 miles per hour. And then I do the same thing with the 20 mile per hour tuning fork. I place the radar unit in moving mode, and then I strike both of the tuning forks at the same time, non-metallic surface, place them in front of the front antenna, and it shows the difference for the target speed of 30 miles per hour, and then the 20 as the patrol speed.
Okay,
and then I do the same thing with the back antenna.
Sure. So there's the front lobe, the back lobe.
Yes.
You do one independently, and then you do them together. When you did this confidence check back on June 12th, did everything function normally?
Yes.
Did all the results, they were what you expected them to be based on your training experience?
Yes.
Okay. All right, so moving forward to later in the day, approximately 2:11 p.m., did you happen to have contact with the gentleman later identified as Russell Hayes?
Yes.
Do you see Mr. Hayes in the courtroom here today?
Yes.
Can you indicate where he is, what he's wearing, generally speaking?
He's in the middle. He's standing in the middle of the room, wearing the gray shirt.
Certainly. And as far as your contact, I'm going to direct
standing
you
in the middle of the
to your
room?
screen. Is your screen on in front of you?
Where is he?
No.
Okay.
Power.
Powered up.
Well, now
Libby.
the blue light went away. So
Libby, I would recommend for your videos
I swear I hit power and it went
like
away.
a
Wasn't
chest
on
mount
the first place.
GoPro.
All right, Trooper Bowman, there
Lets
is
you watch
a screen.
firsthand the cutting.
I'm guessing it's
Like
on
up
now.
close,
Is
like
there
as you see
anything
it.
playing?
Not yet.
Okay. Freeze frame. Do you recognize that video?
I don't see anything.
There's nothing on. Oh, there's nothing on. I'm sorry.
It's a black screen. So
But lighting is important as well.
there it goes.
There's our defendant.
Now it's on. All right. Same question. Do you recognize that screen or that what we're looking at right now?
Yes.
What is that? What is this? What is this video?
That looks to be a dash cam of my patrol car on US 62.
Is the date June 12th of 2025?
Yes, at 14:09.
All right, so 2:09 in non-24-hour clock mode.
Yes.
All right. How is your dash cam activated, generally speaking?
It well, generally speaking, it goes back a minute and a half before I activate my lights.
Okay.
So it's technically kind of always recording, but it doesn't say that recording until a minute and a half before I hit my lights.
Sure. All right, we're going to watch a short portion here. I'm going to identify this as State's Exhibit 1, Your Honor.
And I will say, I can't remember if I manually activated the dash cam before hitting my lights in this case, because I had to turn around and really drive for a decent amount of distance to get caught up to the vehicle.
Sure. What do you recall what type of vehicle Mr. Hayes was driving that day?
It was a semi dump truck.
Gotcha. All right. So we're going to watch a short selection here. And if you could let me know if and when you see the truck that we're talking about.
There, that Martin. All right. Martin truck. So what I indicated earlier, I had to let some cars pass. I let that truck pass, the pickup, and then there's two cars, I believe, that had to pass by me. So I got a late jump on turning around.
Okay. And I guess my most important question to you is, when did you actually measure the speed here of the truck itself?
As we were still approaching each other.
So so it's the head-on, but he's off to your left, but it's the head-on?
Yes.
Okay. When you were measuring the speed, how do you know that you're measuring the speed of that truck as opposed to any other vehicle on the road?
There's a couple of ways.
Please tell me.
Yeah, visual estimation, what we spoke of earlier. Mm-hmm. And then once I do hit my radar unit, there is an audio tone that comes from the radar unit itself. Pitch indicates speed, tone indicates strength of the signal. So a higher pitch is going to indicate a higher speed. Okay. And once I've been doing this for every day for almost 10 years, mm-hmm. I get pretty used to the tones itself. If it's a higher speed, or a higher tone, I mean, it's going to be a higher speed. I know it's a normal 55 tone is
Sure.
what I'm saying. So.
And so for this case, when you measured the speed of that vehicle, did you receive that tone that you were expecting based on your training experience?
Yes, and in this case, I was even able. So I got 3 checks on the dump truck, mm-hmm. 76, 75, 74, and I was able to lock in the last speed at 74 on the radar unit itself.
Okay. I'm anticipating that there would be an argument that it wasn't his truck that was measured at that point in time. The video we just watched, were there any other vehicles that were directly behind the truck or anything in front of the truck that would have changed the way the radar was functioning or measuring a different car as opposed to the one you intended to?
So there's no vehicles directly. There was that pickup truck that was a little bit behind, sure. And then there was a vehicle just in front, not directly in front of the dump mm-hmm. truck, but nothing that would have changed or gave me any kind of hesitation on which vehicle I was checking.
And that's based on your training. Does that include the tone, the pitch,
yes.
those other items that we just talked about?
Correct.
Okay. The speed limit in that area of Burlington Township, what is the speed limit?
55.
And you mentioned a series of speeds, 76, 75, 74.
Correct.
Why do you do a tracking history as opposed to just one speed?
So with the radar unit in general, the radar unit usually picks up the bigger objects. They're sure. more reflective, easier. In this case, it's usually going to be a dump truck or a semi or something to that extent, rather over than like a 4-door sedan. Mm-hmm. But the reason why we do a tracking history is to ensure accuracy. So, for example, you don't get something like 32, 95, and then 52. That would be a bad tracking history. Sure. So the numbers, the goal is to have the numbers all around the same numbers.
And of course, that all depends on what the driver is doing. Okay.
Correct. Yeah.
Okay. And so you testified that you had to stop, you had to turn around, lost the truck for a minute or so, or a few seconds or so before you caught up.
Yeah, it wasn't long.
Not long, but you had to catch back up to him.
Correct.
Okay. Did you initiate a traffic stop?
Yes.
Did you make contact with the driver of the truck at that time?
Yes.
And who was that?
It was Mr. Hayes.
Sure.
Mr. Russell Hayes.
And did you advise him why you stopped him?
Yes.
And what did you tell him?
That I stopped him for his speed. Okay. initially, I usually ask for people's license, registration, insurance, before getting more specifically into the speed, which he provided to me. He believed that it wasn't his speed. I offered to show him the locked-in speed on the radar, which at first he was willing to see. And then we still got speaking. He said we still got to speaking, I should start. And he said he was having a hard time. His wife was diagnosed with cancer, and his truck broke down recently.
Working today.
And then later on refused to see the radar unit itself.
I understand. Ultimately, did you issue a citation?
Yes.
For what?
For 76 miles per hour in a 55 mile per hour zone.
Thank you. May I approach the witness, Your Honor?
You may.
The points on the map are manually added, so it takes a little while after you've submitted your point for it to show up, just so you know.
Trooper Bowman, Pennywood of Morrison States, Exhibit number 2. Would you take a look at that for a second? Let me know when you're ready.
So, Libby, I'm jealous. I want a lapidary sauce so
Recognize
badly.
what that is.
Yes.
I just don't have any room for it.
This is a screenshot from my body cam inside my patrol car.
Certainly. In the upper right-hand corner, is it the same date and time of this offense that we're talking about here today?
Yes.
Okay. Point of interest in the middle, there's a little device. It looks like it's got some numbers. What is that device?
That would be my B3 radar inside my patrol car.
And what are the readings there? If you could explain them for me, just which one.
So the number on the left is the target speed. So when I'm checking vehicles, that's the speed of the vehicle that I'm checking. The number on the right is my speed.
Okay.
So the number on the left reads 74. The number on the right reads 55.
Certainly. And when we're talking about that locked-in speed that you're talking about, is that the 74 that you're speaking of?
Yes.
Okay. The video that we watched today, that short selection and that still image, are those true and accurate representations or recordings from this day, June 12th of 2025?
Yes.
Right.
Yes.
No further question, Your Honor. Thank you.
All right. Pro se defense.
Mr. Ray, do you have any questions for the trooper?
Yes.
Here we go.
I can hear it fine.
The day before I got stopped for speeding, were you working?
Objection to relevance, Judge.
Not really, Dave, just hear me out for a minute.
Go ahead. You can answer.
Judge said, I'll give you some room.
So I don't know. I don't recall what day June 12th was. If it was a Monday, Tuesday, Wednesday. So I don't know. I don't know if I can answer that question, and I don't know my specific schedule on June 11th, if you will.
So you can't remember the day before that?
So
when you were working or days off?
I could say normally I'm off on Wednesdays. Once again, I don't know. My schedule changes all the time.
The reason I'm asking that is that patrol car that you're in, that's the one you're always in, that you work out of?
I would say about 99% of the time, yes.
Okay.
Unless it needs maintenance or something like that.
Yeah.
Kelly, thank you so much.
And you tune in your radar gun all the time, every morning?
We check
at work?
Yes, we check the calibration of it in the morning and then in the evening.
And then you did the same thing the day that I was got the ticket, right?
Yes.
Yeah. And have you got any documents at all that you would have done that other than what you're saying?
No.
We accept their word for it.
Okay, the other thing is, there was vehicles that were in front of me, right? That was in front of me, the same direction I was going. Okay, and you also had vehicles that were coming in front of you, right?
When you say in front of me, I understand the part about you.
You were behind vehicles with your radar gun on.
Yes, okay. I think so.
Yeah, and also there was vehicles in front of me that were going the same direction as I was.
This judge is
that day when you hit the radar gun or whatever.
There was a vehicle in front of you at some distance. It wasn't directly in front of you.
And also behind me there was.
There was a vehicle behind you in some distance, but it wasn't directly behind you.
Are you saying that you couldn't have got any of those other vehicles per se, but you could get me?
So the way our radar unit works is that we have the option to do opposite direction, vehicles coming towards us, and then also if I'm behind a vehicle, I can switch it into a mode to do the same direction that I'm going.
And that radar detector will tell.
I want to answer your question fully. So the way that we're trained to use it as well is to listen to the audio of the radar unit itself. And those indicate speeds. I see that there's a speed on my radar unit. I look up and see what vehicle I'm checking. That's how that works.
The radar that you were using, it wasn't laser, was it?
The radar and laser are two different devices, yes.
Yeah, the two different things. The one you got me wasn't the laser. It was just the radar.
The one you got me.
Mounted in your vehicle, right?
It was a radar, yes.
Yeah. Have you ever read the manual for that radar detector? How to use it and the pros and cons of what would happen?
I don't think I've ever read the manual. We were just trained on the usage of the radar.
I've read on it. I don't know if it's a specific one that you have or not, but it's saying that the effective speed could have anything to do with rain, aluminum, bouncing off another vehicle. You know, there's a good chance that it wasn't me that was going that fast. And I'll tell you another thing, you know, however this goes, I have a Jake brake, which is an engine brake on my truck, okay? When I spotted you, my Jake is on all the time, okay? So as soon as I spotted you.
You'll have a chance to testify if you like, Mr. Hayes. If you have a question about something, now's the time to ask the trooper a question.
Yeah, that's kind of where it was going with it.
Okay. Yeah. All right, we'll get to the question part.
As soon as I spotted you, I slowed down. You couldn't have got me.
I understand.
Okay, the thing I'm getting at is, from the time when I spotted you and my J came on and I automatically hit my brake, I've tried it half a dozen times on the truck, and it's coming down at 12 mile an hour right now. From whatever speed I am, and I hit that J and my foot is automatically on the brake, it'll come down 12 mile an hour easy.
He's admitting guilt.
And that's just what I'm getting at. You said that I was doing 76 and then it dropped to 74. Well, probably when I dropped to 74, because I had my foot on the throttle, went to 74, I took my foot off, hit the brake, my Jake come on. I know I was going at least 12 mile an hour slower than what you're saying that radar got me at.
Is that a question?
I need a question.
It's an admission of guilt.
I'm trying to tell you. All right.
So can I answer anything?
I don't think so. I don't think he asked you a question.
All right.
Any other questions, Mr. Hayes?
No.
Okay.
I'm not coming down on you.
I just want to point out specifics.
Okay.
Yeah.
My truck.
All right. Thank you. Mr. Cox, any other questions?
Is there any doubt in your mind about whose vehicle you measured with regard to this case?
No, I mean, the weather's clear. There's no weather factor here. I mean, the radar does not work as well, yes, in poor weather like rain or snow, but on this day it was clear. It was a clear sunny day, so that was not, there's no effect on that. And then I will say, I mean, usually I would say, just from doing it for 10 years, based on my experience, I'm usually picking up people before they see me because I'm specifically looking for that. Sure. I mean, granted, I don't know when he saw me. I don't know if he saw me before I saw him. I don't know if I saw him before he saw me. I don't know, but no, there's no doubt in my mind that the vehicle I checked was at 76, 75, 74. Semi.
And thank you. And with regard to this, is it a Jake brake is what you're doing, or a J brake?
Jake, engine brake.
Check. Did he make any mention of that during the course of your interaction with him at all, that this kicked on, knocked his speed down 10 to 12 miles an hour at any point?
No.
No further question.
Mr. Cox, you want to run the beginning of the video?
Sure. Yep. From where let's see here. You want the very beginning or about the minute in when we?
Before the truck comes into view.
So there's a black.
Yeah, go ahead and back up before the truck in front.
Yeah.
Okay.
This should be.
Okay, that's him right there. Okay.
Yep.
Yeah, so there was a truck in front of me, and there was another one right behind me.
Okay, all right, thank you.
Yep.
Okay. Mr. Hayes, any other questions?
No.
Okay, you may step down. Anything else to say, Mr. Cox?
Your Honor, I don't have any further witnesses to present to the court, but I would ask the court to admit State's Exhibits 1 and 2, 1 being the DVD of the dash cam and 2 being that still shot from the body cam.
Okay. Any objection to the video or the photograph? Okay, I'll admit Exhibits 1 and 2. Would you like to testify today, Mr. Hayes?
Sorry?
Would you like to testify today?
Just that I wasn't doing that fast. I know I wasn't.
Well, if you want to testify about that, you can do that.
Yeah.
Do you want to do that?
Yeah.
Okay.
He's going to take the stand.
Raise your right hand. You solemnly swear or affirm the testimony you should give in this case now being heard should be the truth, the whole truth, and nothing but the truth. So help you God or felony of perjury?
Yes.
Have a seat. State your full name.
Russ Hayes.
Spell your last name.
Hayes.
And state your business address.
337. Oh.
You state your full name. Your home address. Where you live.
3377 West
Whoa,
Point Road.
whoa. We don't need everything. Sorry. We don't need his full address.
Okay. All right, Mr. Hayes, you want to tell me what happened? You want to tell me what happened?
I was just going back to the Corps to get my load. It was towards the end of the day type thing. I was on the phone, I can admit that, on a headset. And I was going with my wife, or I was talking to my wife, going down the road. And yeah, I don't believe I was speeding.
Okay, anything else you'd like to say?
Yeah.
Anything else you'd like to say?
No.
Okay, Mr. Cox?
I don't have any cross, Your Honor. Thank you.
Okay. All right, thank you. You may step down.
I was on the phone with my wife, talking on the cell phone. I'll admit that. I was talking while I was driving. I don't think I was speeding. Well, guess what? Radar says otherwise.
Anything in closing, Mr. Cox?
We really just stay on the evidence, Your Honor, the training of Trooper Bowman here, his experience, and the credible nature of his testimony. Thank you.
Okay. Mr. Hayes, you want to say anything in closing? No? Do you want to say anything in closing today?
No,
okay.
I'm good.
Okay. Well, based on the evidence presented here today, I'll find you guilty of speeding. Mr. Cox, you have a recommendation?
Ultimately defer. I know there's been a handful of convictions here relatively recently, Judge.
Handful of convictions? What?
You want to say anything before I enter your fine? Nope. Okay.
Court fees plus what's 74 and 65? 9 over. You won't be able to hear the fine.
Okay, I'll impose a $150 fine and court costs.
Court costs.
You have a right to an appeal. You're welcome to do that. Okay. All right. Thank you.
Thank you, Judge.
All right. I'm curious. They just like to exercise the wheels of justice. Is that what's going on? People just want to see how it works. Okay, let's see. We may have had a Thurston Washington thing here come up. Just 1 second. Oh, that's an interpreter. Arabic. That's going to be tough. Let's see. Court 4. Not live. Thurston County 1. Not live. 2. Not live. 3. It's not live as well. All right. 10 hours of deliberation. I really do wonder if they're making some progress, if people are switching sides over there, or If they started over, maybe they're just reading the jury instructions again. That'll take a day or so. He's a snake of that Jake break. Couldn't have been him. I'm so quick. As soon as I saw him, I let my foot off the gas, and that would have slowed me down at least 12 miles an hour. There's no way you caught me speeding. Not the best argument to make in court, but I want live feed from jury instructions. That would be something. Jury is now 11-1 the other way, says Greeners. And it's the same people. Everyone flipped. No, just kidding. That'd be bizarre. Amber says, look at mod chat and explain that to the people. To the people. If you can't be found on the map, the pinned map, make sure you entered the city, state, country form using a slash or a single space between each. And Amber just updated the map form. If you want to drop a pin, if you want to. Also, if you want to show up on the map and not be the same pin, say if you live in Houston, Texas, and other people also live in Houston, Texas, if you list a very small town very near you, a very small community, there's a better chance that your pin will show up on the map because there will only be one that shows up under Houston, but other cities will show up very well. So just a trick to get listed. Crazy Cat says, I'm back. Can you tell the jury we're ready? Crazy, we were waiting for you. I'll send a word right now. Let them know. Thank you. We've all been on hold here. Should have just paid the ticket. I wonder what court fines are. What are court fines? Amber, are you there? Hello?
I'm here. Are you there?
I'm here. How are you doing? I did a great job explaining. I don't know why you're calling.
I'm good. How are you?
It was a perfect explanation.
You kind of did, but you missed
kind of nothing.
You missed just a small piece.
Okay.
You did good, but you missed a small piece.
Right.
So if you look on the screenshot I sent to Mod Chat, there's a number I circled. Can you peek at that real quick?
Need to find where Mod Chat is. 496.
That's 496 entries that people have sent in that are not showing up on the map because the location isn't formatted correctly. Either there's unnecessary periods, there's a misspelling in the city, or something's not right with the location data that you submitted. So those 496 I have to manually fix unless y'all go in and fix your location.
So
That
if
was
you do
actually
city,
the issue I had with Mr. Fix-It.
So if you do city/state/country.
Correct.
Or a space
Any
between.
of that combination, right? You can disclose just just state and country if you want to.
Can you put a sample
That's
in chat?
fine.
Can you put a sample in chat so we can all look at it here?
Sure. Recovery Addict, Greenville,
Hey. Okay, just kidding.
North Carolina. There you go. So where I have slashes, either a single space, a comma, or slash, one of the two.
There has to be something here.
It's not picking up all of those entries, 496 of them, because there's probably an unnecessary period and it doesn't. Sorry, you're hearing somebody call one of my dogs. But it's not picking up the actual location with unnecessary punctuation. So I have to fix all of those manually.
Yes.
Unless you go in and edit your entry.
Yeah. Which I might
So
I might remind you you
search-
volunteered for.
Oh, I know.
Okay. All right.
I have other stuff going too. I have trivia I have going that I've been compiling for, I don't know, something one of these days that we do, I don't know, a giveaway contest or something. I've got all sorts of stuff going.
Yeah.
But anyhow,
Awesome.
you should be able to edit your entry. If you can't find your name by searching for your name, then it's probably an issue with the location entry.
And by that, we're talking about these links. There's one link right here to submit your entry, and there's another link to view all the entries. So you have to click on those links. Doesn't help putting it in chat. We won't copy it down for you, unfortunately. We're not full service like that quite yet.
I make sure I actually review all of the entries just to make sure nobody's phone or computer auto entered in an actual address. So rest assured, I'm actually looking to make sure that there's no physical address being entered in on the map.
Full information. We mute that part.
Correct.
All right, Amber.
Actually, y'all are saying trial trivia. It's not trial trivia, actually. It's Recovery Addict trivia.
It's all the silly things I did and moments I regret saved for posterity.
What was the original button count? What was the first date that he was late to? How did he get in? What was his first experience with interrogation? Stuff like that. It's Recovery Addict trivia.
Good stuff.
Yeah.
Amber, thank you very much. I appreciate it.
Not a problem. Have a good day, y'all.
All right. Bye. Libby was posting and asked a question about rock saws and videos for sawing rocks in half, lapidary work. I did a Google search, and now my feed is full of lapidary videos. So I've got Agate Dad playing on my laptop over here. 209,000 subscribers watching him cut rocks in half. And I'm one of them. So there you go. Agate Dad is the best. All right, Libby. I so badly want to get a lapidary saw. I had these rocks. I carried those rocks for years, and before my friend, who's a contractor, let me use his saw. I think it was a tile saw I used, which I think works the same to cut those in half. But I want one, but I do not currently have a place to use it or store it, so I can't get one yet. But eventually I'm going to get a rock saw, and then I'm going to have to get all those the little grinder wheels and the buffing wheels and everything else. I like rocks. I've been collecting rocks since I was like this big. All right, deliberations have gone on for 10 hours and 43 minutes. We're going to jump down and watch Judge Wolf.
30 years, but 8 to 12 is a range 1 standard offender. His punishment will be 8 years suspended to state probation, $2,000 fine, legal costs, and this case will run concurrent to a case he's on probation on out of Robertson County. Actually, 2 cases, Judge. Case numbers 2023 CR 293 and 294, and count 2 will be dismissed pursuant to the settlement.
Judge says, all right, sounds like a deal. Let's sign it.
Raise your right hand, be placed on the road.
Yes, ma'am.
State your full name for the record.
Zachary Christian Derek Smith.
Mr. Smith, you've heard your lawyer go over what the agreement is, but have you seen or been shown a copy of the charges? Talked them over with Mr. Saul, you and he discussed the range of punishments you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed for you if you could not afford your own?
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything.
Yes, sir.
Do you understand that if you went to trial, you and Mr. Saul could confront and cross-examine all witnesses the state called to testify against you, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial?
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed through the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by entering this plea of guilty, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
You understand that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
And you want to waive your right to a trial and to an appeal by entering a plea of guilty?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
First of all, you understand if you could plead guilty, the court of the state could ask you questions about this offense. And if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if it finds out that you've been lying under oath.
Yes, sir.
You understand I cannot accept your plea unless I'm satisfied there are facts to support it and that you are in fact guilty of this charge.
Yes, sir.
And I will ask you, are you guilty of this possession of a Schedule I drug?
Yes, sir.
And what drug did you possess?
It was heroin.
It was what?
Heroin.
Heroin.
Yes, sir.
How old are you?
32.
Well, you're relatively young, and I've asked people this before. You ever heard the name of Jimi Hendrix?
Yeah. Yes,
Janis
sir.
Joplin?
Yes, sir.
John Belushi?
Yes, sir.
You know what those people had in common?
Yes, sir.
What?
They was all heroin addicts.
And you know what happened to them?
Yeah. Overdose.
They all overdosed and they're all dead.
Yes, sir.
And they all died, and they were all people that I was fans of, all of them. But the fact of the matter is, heroin is, people in my age, not that I ever did drugs, but I mean, people my age learn pretty quickly that heroin was a deadly drug that would kill people. So I just find it interesting that younger people, for some reason, have decided, oh, heroin sounds like a fun time to me, even though it kills people left and right. All right. Not to be unduly harsh on you, but you understand that if you go back to using heroin, not only will you likely serve all of this 8 years in prison, but you may not live long enough to have to serve 8 years in prison. You understand that?
Yes, sir. Can I add, I'm over 2.5 years clean from everything.
Well, I'm very glad to hear that,
Yes,
because that's the difference between life and death in this particular situation. All right. Then, are you satisfied with your attorney's services?
Yes, sir.
You believe Mr. Saul has done a good job of representing you competently?
Yes, sir.
Mr. Saul, do you know of any reason you should not enter this plea?
No, Your Honor.
Anything further from the state?
No, Your Honor.
And Zachary Smith and docket number 19663, upon your plea of guilty to count 1, felony possession of heroin, I find you guilty, sentence you to 8 years, Tennessee Department of Corrections, suspended to state probation. You are to pay a $2,000 fine and court costs. This case will be running concurrently with your Robertson County matters. Count 2 of the indictment is dismissed as a part of the agreement. Need to see the clerk.
Thank you, Judge.
See the
I'm
clerk.
sorry, the probation clerk.
Judge, I had another case on the docket, the gentleman that's in TDOC custody in East Tennessee, Mr.
That's
Zachary
Turner.
Yes, Judge. He wasn't transported in, wasn't part of the Zoom
Do you want
process.
to try to have him transported for the 22nd? Or do you want him to try to arrange the Zoom? I know that we got one of them in on Zoom, but we didn't have the other one. We've done everything on our end to try
I
to
know,
have him on
Judge.
Zoom.
Will there be another date aside from that 22nd date? I'm hopeful we'll get it resolved, but I have 2 other inmates I need to see in Morgan County, and I want to see if they can
You
add
should call them defendants.
Mr. Turner to that so I can visit with him.
Mr. Willoughby?
I already got one case on the 12th. We could try that.
Let's put it on August 12th, and if you can work it out and resolve it on that day. If not, we'll put it on November the 10th.
Yes, Judge. Thank you, Your Honor.
Zachary Smith, I didn't give back to the
You didn't want it?
He admitted that he was in possession of heroin.
Okay.
Yeah.
I didn't hear that part. I'm listening here.
Yes, sir. Please. Thank you, Your Honor.
All right.
That Jeffrey Smith.
All right, Mr. Montenegro, are you ready on Mr. Henderson?
Yes, I am, Your Honor. He is page 6 on Your Honor's docket. And this afternoon, we're going to enter pleas of no contest to all 3 matters in cases 24 CR 19573, 19574, and 19575. For the matter ending in 573, he's going to plead no contest to count 1 of that indictment, which is a DUI 4th offense. The remaining counts of 2 through 7 will be dismissed. His sentence will be determined at a sentencing hearing, and Your Honor will decide on the sentence itself. But this matter, it is agreed that all these sentences will be concurrent with one another. With regard to the matter ending in 574, he will be pleading guilty to an amended count of attempted possession of a firearm by a convicted felon. Again, that will be determined by Your Honor at a sentencing hearing. And then with the last matter, ending in 575, he would be pleading guilty to, or he'll be pleading no contest to amended accounts of attempted aggravated assault to counts 1, 2, and 3, while the remaining counts 4 through 8 will be nollied by the state. And again, that method of sentence will be determined by the court at a date that Your Honor chooses.
All right, Mr. Henderson, raise your right hand. Let's place you under oath.
Yes.
State your full name for the record. Step in front of the, let him have the microphone.
Eric Lavoy Henderson.
Mr. Henderson, you are here today on 3 different indictments, well, actually 4 different indictments. I think they're pleading to 3. Do you understand what you're charged with, and did you have a chance to talk with your lawyer about the range of punishment you're facing, as well as any possible defenses you might have?
Yes, sir, I have.
Well, it's indicated that you want to enter this plea, these pleas of no contest. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury in this court?
Yes, sir.
Do you understand that a plea of no contest or nolo contendere simply means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence, and they're going to tell me what their evidence would be at trial, and I will use that evidence to find you guilty, and then we'll move to a sentencing hearing in the future. Do you understand that?
Yes, sir, I do.
Do you understand, however, that you have a right to plead not guilty and to have a speedy and public trial by jury in this court?
Yes, sir.
You understand you would have the right to have a lawyer and to have one appointed if you cannot afford to have one of your own?
Yes, sir.
Do you understand at trial you would be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt, to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything?
Yes, sir, I do.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine all witnesses the state called to testify, and you could bring in your own witnesses by the use of a subpoena?
Yes, sir.
Do you understand that if you went to trial, you would be presumed to be innocent? You would not have to testify or prove anything, and there would be no inference of guilt that would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the sentence and the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
Do you understand that by pleading guilty, you're waiving your right to contest the issue of whether you're guilty of these charges, but you're preserving for yourself the right to have an appeal if you're dissatisfied with the sentence that I impose at the sentencing hearing? Do you understand that?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir, I do.
Do you want to, well, you understand, first of all, that this is going to result in a number of convictions, and those convictions are going to be on the record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. Do you understand that?
Yes, sir.
I need to do that.
There's a lot of light in this courtroom. Some pretty hefty charges he's pleading no contest to, which is effectively guilt. DUI, carrying a concealed weapon by a convicted felon, and then an ag assault.
Well, let me just make sure that there's no question about it. He's pleading to a DUI 4th offense. I need to advise you of the following. Any person convicted of the 5th offense, driving under the influence, shall be guilty of a Class D felony, shall be fined not less than $3,000, no more than $15,000, and shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for an appropriate range of a Class D felony, and shall be prohibited from driving in Tennessee for 8 years. Any person convicted of the 6th or subsequent offense shall be guilty of a Class C felony, shall be fined not less than $3,000, no more than $15,000, shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for the appropriate range of a Class C felony, shall be prohibited from driving in Tennessee for 8 years. Any person convicted of any offense while accompanied by a child under 18 years of age, that person shall be fined $1,000 in addition to the fine for the DUI offense, and shall be confined for a mandatory minimum period of 30 days, which shall be served in addition to any period of incarceration received for the DUI offense. If the child suffers serious bodily injury as a proximate result of the DUI offense, the person commits a Class D felony shall be punished for vehicular assault as provided in TCA 3913-106. If the child is killed as a proximate result of the DUI violation, the person commits a Class B felony and shall be punished for vehicular homicide involving intoxication as provided in TCA 3913-213, subsection B2. In addition to the required sentencing, a judge may order substance abuse treatment, substance abuse assessment, conditions of probation and/or monitoring with periodic reporting using one or more of the following: transdermal or other alternative alcohol or drug monitoring devices, electronic monitoring with a random alcohol or drug testing global position monitoring system. In determining whether a conviction is a second or subsequent offense, it does not matter whether the prior offense occurred in Tennessee or in another state. In determining whether a conviction is a second or subsequent offense, all prior convictions within the past 10 years from the current conviction shall be considered. If the person's current conviction is within 10 years of a previous conviction, the person shall be considered a multiple offender. If the person is considered a multiple offender, then all convictions within 10 years of the date of the immediately preceding conviction shall be considered in determining the number of prior offenses. For purposes of determining if the person is a multiple offender, the state may use a conviction for an offense committed in another state that would constitute the following if committed in this state: driving under the influence, boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide. The state may also consider an offense committed in another state as a prior conviction if the elements of the offense are the same as the elements of the comparable offense in this state. For purposes of determining if a person convicted of DUI is a multiple offender, a prior conviction for boating under the influence, vehicular assault, aggravated vehicular assault, vehicular homicide, or aggravated vehicular homicide shall be treated the same as a prior conviction for DUI, as long as the person was convicted of the prior offense before committing the instant violation of DUI. The defendant's automobile may be subject to seizure and forfeiture upon a second or subsequent conviction of a DUI offense, unless a person convicted of violating TCA 5510-401 is determined to be indigent. The minimum applicable fine shall be mandatory and shall not be subject to a reduction or suspension. All fines are to be paid on the date sentences imposed, unless the court makes an affirmative finding that the defendant lacks a present ability to pay. The court shall then order a date certain before which payment shall be made. Should the defendant fail to comply with the order of the court, the clerk shall notify the court of the failure for further proceedings. The payment of restitution to any person suffering physical injury or loss as a result of such offense, if such person is economically capable of making such restitution, shall be imposed as a condition of probation. Now, you're pleading to a fourth offense, and the law on the fourth offense is any person convicted of a fourth offense shall be guilty of a Class E felony and shall be fined not less than $3,000, not more than $15,000, and shall be confined for not less than 150 consecutive days, no more than the maximum punishment authorized for an appropriate range of a Class E felony, and shall be prohibited from driving in Tennessee for 8 years. Need you to sign
some pretty hefty
this
penalties
form
here.
that shows that that has been explained to you in open court, and have your lawyer as well sign off.
No new notes yet. Just reaching 11 hours of deliberation overall. I've got in the top left-hand corner, that's a live shot out of the state of Connecticut, that court. If anything happens, you'll see that move. That is not a still image. That's a video. You're also listening live to audio from that court, so if the judge says anything, you're going to hear it here. But it's been silent since this morning, since the jury came in and was told to get back to work after they sent a note late last night, their second, saying they were deadlocked.
You understand now everything I've explained to you?
Yes, sir.
Do you wish to still enter a plea of no contest according to these agreements your lawyer has worked out?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand I cannot accept your pleas unless I'm satisfied there is a factual basis for it and that you are in fact guilty of these charges.
I understand.
And I want you to listen as the state tells me what their evidence would be in each of these cases.
Yes, Your Honor. Docket 19575 on July 3rd, 2023, Mr. Henderson's daughter and her boyfriend arrived to his house at 1187 Neptune Road. He had been making complaints that they didn't come see him enough. When they got there, he was highly intoxicated, upon their arrival, and eventually an argument ensued, and he had a handgun out and directed him to leave. When officers went to that address, Mr. Henderson, I believe, was passed out on the porch, and there was a firearm in his vicinity. In docket 19574 on November 12th, 2023, officers again were dispatched to 1187 Neptune Road here in Cheatham County. Mr. Henderson was alleging that his home may have been broken into and some items taken. I believe he was alleging guns had been taken. He showed the officers a closet where he was keeping a gun that was still there, a shotgun, as well as alleged stolen firearms. When they ran him, he turned out to be, again, a convicted felon in both.
He called
I
the
do
cops.
not know the docket number for the DUI case, but in that, on or about March 2nd, 2024, Sergeant Mahika with the Cheatham County Sheriff's Office was dispatched to 1187 Neptune Road in Cheatham County due to a BOLO for a motor vehicle crash where witnesses observed a man leave the scene and hide in the woods nearby. Officers did locate the defendant, Mr. Henderson, nearby, and he admitted to being in the crash. Sergeant Mahika noted signs of impairment on scene. Mr. Henderson was taken to a nearby medical facility where he refused to cooperate for a blood draw, including drinking water and trying to use chewing tobacco. He did, however, admit to consuming beers, blacking out, and crashing. Mr. Henderson has prior DUI convictions to include ones in 2015, 14, and 2012 for accounting purposes. Those are the facts.
All right, Mr. Henderson, I'm not asking you to agree with those facts, but you understand that's what the state's evidence would be if this case went to trial.
Yes, sir.
You still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
I am.
You believe that Mr. Montenegro, I always mispronounce your name, but you believe your lawyer has done a good job of representing you competently?
Yes, sir, I do.
Do you have any reason he should not enter these pleas?
I cannot.
All right. Anything further from the state?
No, Your Honor.
All right, then Eric LaBoy Henderson, in docket number 19573, upon your plea of no contest to count 1, which is DUI, fourth offense, counts 2 through 7 will be dismissed. And I find you guilty. That will be sentenced at a sentencing hearing, which we'll set a date here in just a moment. In docket number 19574, upon your plea of no contest to attempted possession of a firearm by a convicted felon, I find you guilty. We will determine your sentence at a sentencing hearing. The agreement is that any sentence you receive for that offense will run concurrently with your other sentences. Docket number 19575, you're found guilty of attempted aggravated assault and counts 1, 2, and 3. Counts 4 through 8 are dismissed, and each of those, the sentence will be imposed at a sentencing hearing. The weapon is being forfeited, and again, the agreement is that this will be concurrent with all of your other sentences. Let's now talk about when we're going to have a sentencing hearing. Weird. Generally speaking, it takes more than 30 days or longer for a pre-sentence report, what I'm understanding.
Judge Wolf is reading.
Well, it's either going to be that August 25th day or it would be in November.
It's got to be August.
In Houston County. You know how to get to Houston County?
I do. Aaron, Tennessee.
Well,
it's like Ireland.
It's like Hawkeye said, you turn real, you kind of face north and turn real subtle to the left. And just get on.
I'm familiar with it, Your Honor. What time would that be?
Well, I'm going to find out from the state if they're in agreement with that.
What was the date, Your Honor?
August 25th. I've already set one. I set the Jones sentencing hearing on that day at 1:30.
I fish there, so can I come and fish and vet?
I'm sorry?
I fish in Houston County, so can I come to court in a fishing vest?
You fish in Houston County, you come to court, you would not be the only one in court in Houston County dressed.
Yes, that date's fine.
Judge Joe Spencer, back when I first started out, Judge Joe Spencer would finish court as quickly as he could so he could go fishing. And sometimes he would bring his hunting dogs with him, and when over in the courthouse outside in Charlotte, he'd have his dogs tied up outside to a tree in the shade while he held court so he could go hunting.
I like it.
All right, so I'm assuming we're not going to have a very long docket on the 25th in Houston County, so we'll put this at 1:30 as well.
Wonderful.
It'll be behind the Jones sentencing hearing.
Not a problem. Do we need to do any orders?
Yeah, there'll need to be an order of transport. She's well ahead of you. You're going to have a transport order and a pre-sentence report ready. So.
Wonderful. Thank you.
All right, we will impose the sentence at 1:30 or thereafter in Houston County, Tennessee.
I believe this one is live. Live.
Right. Thank you.
This is live. Judge Wolf. He travels around. I like his other courtroom better. But
We got two
Chief
other
and one.
defendants. Come up to the podium.
Audio's not the best here, but
You too. Up to the podium. We are honored to have two future lawyers in our midst. And I'm just going to have you for the record, since this will go out to the entire world that's watching on
the
live
interwebs.
stream of the YouTube. You can state your name and where you attend school and what your intentions are regarding the practice of law. So we'll start with our female counsel here.
I'm Kirsten Brown. I'm a rising 3L at Belmont Law, and I haven't completely decided where I'm going, but I'm liking criminal prosecution.
All right, you're going to stay in Tennessee or you're going to go somewhere else?
I haven't decided that yet either.
Well, it doesn't count now. You got to decide right now whether you're going to stay in Tennessee or go somewhere else. All right, and what is your name, sir?
My name is Matthew Barron. I'm a rising 2L at Vanderbilt Law. I am getting a lot of exposure to criminal prosecution, and I'm excited about it. I don't know where I'll stay long term.
Well, ask Mr. Willoughby about exposure to the criminal practice. Sometimes that's a good thing, sometimes it's not. So.
I don't think my dad had gray hair this young, so.
But if you think your hair is gray, you might want to think
It
about
has
it
its
again.
moments, its spots. Beard is for sure getting there.
All right. Well, glad to have you both here. Please come back and join us anytime you want to. We're happy to always encourage people to get exposure. I think one of the best recommendations I can make to anyone who wants to pursue a legal career that would involve the courtroom is to be in the courtroom as often as you can and observe as much as you can, because as you both know, watching a courtroom proceeding in real life is nothing like what you see on television unless it's actually a live broadcast of a case. So anyway, good to see you both. Thank you for being here. We are now adjourned.
Thank you.
Thanks, Judge Wolf. Kind words. I guess we're going to unadjourn.
Okay. Oh, that's right. Yeah, he told me that. You have a list.
Okay, we're gonna adjourn. We're gonna adjourn. All right, it is now 3:30. I expect to get a note from the jurors today. Here in the next little bit. I'm thinking it's gonna happen. Where's my mouse for 7? There it is. This mouse is so loud. Let's see, Judge Boyd is still alive. I think she's in court right now. Well, nope, she's not. She's on a break. She has a jury trial coming up during jury selection. That was a lot of fun. I'm not sure if that's completed or not. Let's see if there's anything else. In the true crime world, let's see, Lubbock County. What's this one? This has probably got terrible audio, but we'll see if we can listen here in just 1 second. Oh, we've got a call first. Hang on 1 second. It's AWOL. Hang on 1 second.
To accept, press 1. To send a voicemail, press 2.
Hey, AWOL. How are you doing?
What's up, Scott? How you doing?
I'm doing well. Happy Tuesday to you.
Good. Yeah, happy Tuesday. Got out of work early, so life was great. I was reading chat. Oh, I'm sorry. Go ahead.
Did I read correctly? You're in the spice business? Like the spice trade?
Yes, I'm a truck driver. I pick up spices from ports on the East Coast, from Newark, Elizabeth, Staten Island. And it's raw spices from other countries, and they come over here, and then my job fumigates them and everything.
I can't order like one cinnamon stick from you. I'd need like a whole pallet or a truckload.
Yeah, no, this is a privately owned. The health department ran by the government comes and inspects us. This is not like a private thing. This is like it's a major company, and I don't want to say the name of who we are picking up the spices for.
Right. Okay. I don't want to get you in trouble, but could like a box fall off your truck as it was driving by my house? I mean, is that something that possibly could occur? I'm not saying it would, but just kidding.
I mean, hypothetically, I could maybe make it happen. If you want some raw ginger, hypothetically,
some raw ginger.
I could,
I go through so much ginger, I'm a big ginger user. All right. What'd you call to talk about for real? Just giving you a hard time about that.
Even with this case or any other case, as far as Raul, somebody asked like, what would, if he gets found not guilty, what will the rest of his life be? There is a saying that goes, I'm very hip hop, but there is a saying that goes, taking or unaliving somebody is the easy part. Living with it is the hard part. Yeah. Like you could unalive somebody, that's easy, but living with it is the hard part. Now, that's a hip hop lyric. But now, in this real life scenario, even if he gets found not guilty, let's just say for the thought experiment that he was afraid for his life. Let's put our feelings aside and just have a little steel man argument. Let's say he was afraid for his life. If he did this thing and he gets found not guilty, I don't think he's going to Ibiza or is going to go to Cancun and party.
No.
He still has to, I think a sane person would say to themselves, for the rest of his natural life, that is going to be on his conscience. If he's an evil person, it's not going to matter to him. But if he is a normal kid that got caught up in a bad situation, I don't think he's ever going to let that go. It will haunt him for the rest of his life.
I think as long as he is 100% convinced that what he's saying is right, that this was self-defense, if that's not a stretch, if that's not like looking for an easy out, I believe he could do better than. I mean, if he lied about this, if he's like, yeah, it was, I went there to get back, it was revenge, it was the whole, I say it's self-defense, but it wasn't. That I think that would haunt him a little bit more. I mean, that's like the ghosts in the darkness sort of thing that keep haunting you. I'd hate to be that person.
That would be even worse if he intentionally meant to do it and is like lying, like, oh, I needed self-defense, but he really wanted to, pokey poke. Then that's bad, and he's gonna have to deal with that when he meets his maker, whatever. But if it was self-defense, it's not like if he gets found not guilty, he's just gonna ride off into the sunset. I mean, maybe.
Yeah, there's
Me
no
personally,
after court party
yeah.
planned if he's found not guilty. I think this one's going to end in a hung jury. I don't think we're going to get to hear the verdict music on this one. I think that the jury is very close to convicting him, but I think there's a holdout. That's my personal belief. But I think he's going to be tried again. They're not going to let this go.
And I did go back today and I listened to the closing argument from his lawyer, and he said during jury selection, some of you stated that you had to use self-defense. And I thought I heard that before, but I went back and double checked, and sure enough, he said that.
Yeah.
So there are people on the jury
Who've used force.
that use self-defense. So that might be, maybe one holdout was like, yeah, I know my case wasn't that serious. There's probably one that is on that jury that was like, no, I needed self-defense, and I think he's innocent. Now, that might be the holdout.
Yep, I don't know. I'm waiting to hear what they say. I do think we're going to hear from the jury before they go home today. I think, well, at least the judge will. I'm not sure she's going to read it to us. She might wait till tomorrow to read the note if it's the end of the day.
Read it in the morning.
Like,
well, I mean, you're going on vacation, or
yeah. Decided not to read it.
But you're leaving, so you're leaving tomorrow afternoon, correct?
I might be able to do a full day. It depends what I pack tonight. If I get everything packed tonight, tomorrow all I'll have to do is install the bike carrier on the back of the car, put up the Starlink on the car, and load it up and go Thursday morning. So I might be able to do a full day tomorrow.
I hope they come back before you leave. Well, let them come back with their right decision. You know what?
Yeah.
I'm being a little overzealous because I want an answer, but let them come back with whatever they feel is correct and just. But for my selfishness, I hope they come back before you leave.
Yeah, because I won't be able to even spy on this at all. I just won't know until like Monday what happened.
Right. So, all right, I held you up long enough.
All
Just
right.
wanted to state that.
Sounds good. Thank you very much. Appreciate it, Will.
All right.
All right.
Yes, sir.
Bye.
Later. Bye.
All right. Judge McBurney's got something going on. I'm going to take a peek down in his court real quick.
Statute about home arrest, where somebody can be sentenced to house arrest, basically, house arrest, instead of jail time.
Right. But I don't think that it impacts them. That would be where we give them an ankle monitor and they basically have a 24-hour curfew.
And they said something about the sheriff had to, I don't know.
Okay, so share the statute. Shoot me an email with the statute because I'm intrigued.
Yes.
That might be a good middle ground in some instances.
Like for the fleeing. That's really
Right.
where I'm at.
Oh, right.
There's no felony. It's just,
Yeah. Yeah, that
so
statute
tough.
Is whack.
All right, Mr. Davis, let me go back there and take a look at that stuff.
It was just a hot mic in court. Everyone's shooting the breeze. This would be such a fun court to visit if we could get his mic turned down just a couple notches. Just a couple. It clips so badly and he's so loud. But all right, so enough with him. Let's go back here. Let's see, anybody else? Judge Boyd back? No. I think they should be coming back from lunch here just a second for Judge Boyd. Might keep an eye on that one. I think she's about to have the jury members come back. She gave them the "it's your duty to serve" talk already. So maybe they'll be more willing to spend some time in court instead of saying they need to have vacation or dentist appointments. Never seen so many people with dentist appointments. All right. Let's see, nothing in Thurston. Not working very well. Hang on one sec. Thurston's a no. It's a quiet Tuesday. Early in the week to be quiet. Let's see. Somebody asked me about how to get Wi-Fi on a road trip. Going on a 12-hour road trip with 3 kids and need a way for them to connect their tablets. Can I say Starlink? Starlink is is beautiful for that. Now I realize it's not the cheapest, but there are some cheaper plans you can get, and you can pay for it by month. And if it's a question between sanity and insanity, sometimes it becomes worth it. You can also get a hotspot. Generally, those come with contracts that I've seen. Maybe if you can find one that's month to month, that would be better. But they're cost-wise, you're going to be paying about the same for a hotspot as you pay for equipment cost, as the same as your Starlink Mini. And if your phone allows you to do a hotspot, that would be great, but you will be surprised how fast it eats up data if you're limited on the tethering. So if you have a limit to your tethering, it's going to be 3 kids on a tablet, especially if one of them watches a video. Their data is used up in a heartbeat. Let's see, there's a, can I click this link? Copy link address, there we go. Whoa. That's a long link. This is me texting, by the way. Those clicks. All right, very humid as well here in southwest Ontario. It is hot, pretty much across most of the country. It's 93 degrees here where I'm at in Greenville, North Carolina. It is, it's smoking. It's absolutely smoking. Use hotspot off my iPhone. It's included in my plan. You can pause the service with Starlink. You can just do 1 month and then not use it. And right now the Starlinks are a little bit cheaper. Plus they give like a $100 credit. It's a great deal right now. $93 here in Denver-ish. Verizon Unlimited Hotspot. Just drove from Texas to Florida and back with 4 kids. Amanda, that sounds like a sweet deal. A Verizon Unlimited. Can I ask price range per month? What the if you know just the unlimited portion, just the hotspot portion, what that costs? Does it include so no contract? And it includes the hardware. I mean, what's the total cost of getting into that? $95 feels like $104 in South Jersey. $111 in Vegas, but it's a dry heat. By dry, it's searing dry. Your eyeballs will dry out just looking around down there. So hot here, I turned on the hose and the water burned my hand. On Verizon 2, we pay $150 total for 2 of us. Did not ask for the hotspot. It was just part of the deal. The area demonized him. He needs to move to the trial to northern. I don't think he's going to get a change of venue. Just because there was a hung jury. Verizon's $20 a month. It's a good deal. $90 in Playa del Carmen. I just stay inside and watch you. Aren't you in? Where is Playa del Carmen? That sounds like a vacation spot if I've ever heard one. It's got the word playa in there, so here's me not knowing my geography. Just 1 second. Yeah, this is full on like Cancun. Just say Cancun. I'm in Cancun on the beach, sipping a cold one, and wow. I zoomed in on the map. I can see it here on my screen. It's right there. You got the Mexico going down. It sort of curls back up around the Gulf. It's right there below Cancun. Pronounced Playa. $117 in Phoenix tomorrow. Oh man, the time I spent in Phoenix, it got hot. But you know what Phoenix does and does really well? Thunderstorms. Some of those summer thunderstorms, lightning storms, are just incredible, just amazing. If we could harness just a fraction of that energy, it would power the whole earth. Let's see. I'm in Phoenix, says Laura. Laura, it's going to be hot tomorrow. Stay inside. Cool, crisp 95 in southeast Missouri. Oh. Where I live in Texas, it gets hot. We have 90% humidity. Sounds like Houston area. That's where I went. "40 minutes south of Cancun." Peter, is that home sweet home for you? Or are you on vacay or work? Nice job. If work, are you hiring? Are there any available spots? Sounds amazing. Although I'm scared to death of going to Mexico. The cartels worry me. Frosty in New Zealand this morning. Frosty. Oh, I wish. I don't have a warrant out with the cartels. I'm just worried that as a lately the cartels have been targeting social media people, and I'm worried that we did a case where we might have said something and somebody got upset. So can't go there. Can't think of any off the top of my head, but it concerns me. Carol, I'm hiring, but the pay is terrible. Almost non-existent. Yes, I've been here since September after I left my awful life in Maui. Oh, so you left one vacation spot to go to another. Upgraded from Maui to... from Hawaii to Cancun. Peter, I'm jealous. I'm jealous. Let's see. I have to work retail tomorrow. Taking 3 water bottles. Stay cool. No, we're still waiting. As a matter of fact, let me show you what we're waiting on. We're waiting on the court to do anything at this point. We haven't seen anything since this morning. 10 items in my Amazon cart so far. I should probably stop. No. Today is the best day to buy if you are going to. It always helps if you do use one of the links we share in chat, because then Amazon will give us just a little thank you kickback to the channel, which is much supported as an affiliate link. Maybe I can Google something for you and give you a link. Arkansas is at 74. Missouri's at 92. Northwest Arkansas. Are you like a Bentonville area, Daphne? That is beautiful weather for the summer. I will take that in July any day of the week. Bike shorts. Judy wants bike shorts. We're going to get bike shorts for Judy here. Just one second. Oh, wow. Oh, great. Great, Judy. Thanks. Now when Mrs. R.A. jumps online and Amazon says, hey, you've been shopping for this. Do you want to keep looking? She's going to see this with all the ladies and all the bike shorts. That's just great. Appreciate that. We'll get one for you. Prime Day deal. Oh, this is the one. Judy, I found them. This is exactly what you want. there you go. Judy, don't say I didn't ever do anything for you. I found you the bike shorts right here. They're the ones. I mean, what can I say? I have no clue. That's, the lawyers make me say that as an affiliate link. If you do click that, Amazon will give me a little kickback. What size Jackery? This one I can give you a recommendation on. I have the Jackery 1000, Explorer 1000. Let me give you the link to that one. It is a beautiful, beautiful machine, and it's 50% off today. So I bought mine at the wrong time, just for the record. There it is. There's the Jackery 1000. The thing I love about the Jackery is it has on screen, it will show you how much power it's using and how long the battery will last if you keep using all the things that are plugged in. It would literally tell you the remaining hours. You know, if you got 18 more hours of usage with the current things plugged in. You unplug something, it's like, oh, the hours go up. You plug more things in, it goes down. It's really useful that way. That way you can be confident that you have enough battery to last for as long as you need it. It's a good brand for shorts and pants. I told you, I've got great taste in, I guess, women's shorts as well. Women's purses. Let's see. Hubs needs bike shorts. You were raving. Please. Okay, I will tell you, I bought some. But I don't even want to show you the ones I bought. The picture is just terrible. I bought some men's padded bike shorts that were only $15. They are not comfortable to wear. It feels like I've got an undersized diaper in my shorts that I'm walking around with. I don't know what else to. It's terrible. The design is just terrible. I need something different. Now it's effective, but I walk like a cowboy when I'm wearing it. It's just the worst. If you want this experience, which sounds so enticing, I'm sure. If you want to walk the way I walk, worst bike shorts. There you go. Worst bike shorts right here. Those be the ones. And they are just as blue as they look in the picture. Ivan says, how about a link for 3 high-pressure sodium lights, huge planter buckets, fertilizer, and Cheetos? Ivan, you're going to get me busted. I'm going to have to pass on that one. Pass. Get the gel padded ones, highly recommend. I might have to do that. The pictures are only on the links, so I can't post pictures in chat. I didn't want to. If I post the pictures, I lose the timer. Now it's been going for 11 hours and 35 minutes with basically nothing happening, so it's not like we're going to miss something if the timer is off the screen for a little bit. But Ashley, they feel like it. They feel like it. Those shorts are bad. They are. They're super, super bad. Now, they work, okay? Like, once you put them on, but they want to, like, retreat once you've this is too much information. Once you've fully applied the shorts to the proper position, waist high and all, they want to retreat a little bit because of the over padding in the diaper area. All right, you don't have to finish the sentence. I'm done. I'm done. Somebody's calling, saying please stop.
16 Pro priced at $990.
Hello.
Your call got connected to the Amazon customer support. This is RC. How may I help you?
Yes, I just got a call saying I ordered something. Who was that? Like, how did I just randomly get a spam call about Amazon saying I had just ordered an iPhone? I've never had that call before in my life. Lots of scams for Amazon deals today. That's it. It's Prime Day. It's Prime Day. They're busy on Prime Day. Tasha, actually surprised they haven't asked to have any testimony reread. The phone is listening. The spammers are listening. The spammers. All right, thank you very much. Just looked at the likes on the channel, and we are at 993, which means we're just 7 short of our goal for the day of 1,000. Now 6 short. And now we're 32 over. Thank you. Thank you. That was really quick. That was very quick. Appreciate that. Okay. All right. How long until the cartel can start listening to your phone the way the Google, etc. can? Hopefully they can't. I hope they never get that ability. Oh, my order just arrived. My dongles just arrived. The jury is more hung than ours. Greeters! Greeters, you are flirting on the line there. Moved up to number 4, thank you. No questions today, Virginia. The only question they had was late last night, which the judge read this morning, saying we're hung on all the charges, and she sent them back to work. And Greener's got timed out for a minute. All right. Regina Crawford, ranked 39. That is awesome. Greeners will be back in just a couple minutes, or probably 30 seconds or so. How long to the end of court today? I was about to ask. We went till 5 o'clock, right? Was it 5 o'clock yesterday when we ended? What did Greeners do? Yeah, just Greeners stuff. He made the obvious joke. Court's usually over at 4:30 or 5 o'clock, which means we've got about half an hour before we expect the judge to do. I think they're going to be hung. I just realized, so you guys are seeing this video twice. Hang on. Let's turn off camera 1. There we go. If Greener gets timed out, does the internet stop working? No, just nobody answers the phone if you have a problem. Pantoufle says, can we get a buy Greeners a coffee link for the laughs? Greeners, do you have a link we need to share? And now Greeners is back. Yeah. There's got to be a way. There's got to be a way that you could do that. I'm not sure if this is a good business idea or not, but a way that users in chat could log in and each have their own links, and you guys could send things to each other. With Greeners taking like a cut off the top. Did Greeners get timed out for flirting with the line? I think he flirted, but he was on the wrong side of the line. Timeout was worth it. Amber Fox says, saw a video on YouTube of a pre-trial hearing for the RV case we're watching right here. And families were yelling at each other at the courthouse. Yes. Strong, lots of tensions, lots of feelings in this one. What just happened? Do we just have a blackout? Free Greeners. I think Greeners is playing with the internet switch. What's happening? That's the most movement we've seen all day. That could be an indicator. And I say that only because having worked in the news industry, live streams like this, live camera shots of something, sometimes the cameraman, to signal back to the studio that something's happening, will do a card in front of the camera type thing to, or flash the screen to get attention, saying something might happen. So let me jump over onto the Twitterverse. Let's see what is on X regarding this. Let's see if there's anything updates. Did you see? I posted on Twitter. I forwarded a link that came from. Let's see. Superior Court of Los Angeles County launches a new remote court reporter pilot program. It lets the court reporter be in another location. This is the first in a long. This is the first I've seen anywhere where they're starting to move positions like that outside of the courthouse. Let's see. Not seen anything from this trial. Just seeing if I can move up from number 5 in points. Kim, I don't know how quickly the points are tabulated, like if it's every 10 minutes or every minute or if it's live. If you find out, do let me know. Greener's jokes are always low-hanging fruit. Hope all goes well for the gig this weekend. May your batteries stay dry. Can we at least get a snippet when you get back? Possibly. I might show you some of the drone footage if I take some. Doesn't identify people. Oh, look who's back. Give me just 1 second. Looks like Judge Boyd is back.
That is.
Jury selection looks like it's finished for the day.
Oh, it's so what's the difference? Yes. I want to guarantee it. The difference. We have the difference.
Either tomorrow or Thursday because this is available. All right, so.
Judge's mic is off right now. Give her just a second.
It's like,
I was just so happy to receive that email that he has a place to stay.
Kim, it looks like it's working. Like you're moving up.
Thank you.
So you We move up
All
to
right,
4.
if there's anyone who's ready, let me know.
I'm ready. I have Johnny De La Rosa, the trial case judge.
All right, so can you pull the file on De La Rosa?
That's not.
Kaylee Sheldon, welcome. Good to have you here.
And where is your client?
We're still court hopping while we wait for the jury to reach a conclusion, a verdict, preferably. Kim.
All right, Mr. De La Rosa.
I don't know how many
Currently
how
in
many
a jury
points you are
trial.
behind.
Yes, sir. So we can't do two trials at once. The one time we did do that, but people were not very happy. Robert, he sounds like he wants to do it.
He's very enthusiastic. Yeah.
All right, so you were late today. Don't be late again. You understand? Yes. Because other judges will put you in jail. All right, so.
It was an accident, just to let you know.
Okay.
Good. Just stop talking.
Just stop talking.
All right. This is what we're going to do. They're currently in trial, so they can't really look at their docket to find out when a good trial date would be. So when are you coming back for your other case? Was it towards the
August 28th?
Well, that's a little bit too late. Are you here the last week in July?
Yeah.
All right. Norma, can you set this for the last week of July? And this would be for you to get your jury trial date.
Okay, so there'll be a docket conferring date. Okay.
Yes.
Perfect.
All right, Norma, what date? All right.
Perfect for me, Judge. I'll be here.
So we're going to bring you back on the 31st. Make sure you're on time. I'm going to notate that you were not on time. And then on that date, it's not your jury trial date. That is the date for them to confer on an actual trial date for you. We have a lot of capital murders and murders coming up, so it may be pooched, but.
Speaking on that,
Did you say it may be pooched?
Right.
That's how I see it. I'll bring you the studies.
Oh, okay.
Thank you.
You're welcome.
First of all, how'd you start it?
Okay. Who's your client? All right. Let me see if it's been pulled.
I want to know what trial she has coming up.
Oh, and Jason, if y'all want to do that in the jury room, you're more than welcome to go in the jury room. However y'all want to do it.
I mean, are y'all going to agree to any of them?
Yes.
Okay, tell me the ones you agree to.
Okay, good on 12.
Okay.
17.
No, I was joking. I said,
32.
Here.
Thank you.
I'll take Roger.
43.
All right, let's go.
73.
April Perez.
That's quite a few. Y'all. That would be fun.
There's more than that too.
Okay, y'all have more?
48, 49.
Okay.
57.
They're doing jury numbers.
That's it.
All right, we're currently in a jury trial, so therefore.
Let me know if you get okay, 5 is beyond reasonable doubt.
So I'm going to give you a date
Also,
to come back, and that date
she
is
said that
going
she
to be
cannot give
for us to get a trial date for you.
So agreed upon.
The persons who will be conferring with your attorney to decide on an agreed upon jury date. They're the people who are in jury. So
one could not.
Can we bring this back late July?
Or like bad, and then said that they could not.
Right, so we'll bring it back on July 31st on that date.
How they feel about
you'll get your trial date.
Also,
all right, once you sign the reset form.
Another follow-up question. You have such a negative view of law enforcement that you cannot be fair.
You said what date, Norma? Thank you.
Okay, I'll bring it up with the judge. And then 6 is the same thing. She said, I mean, can you not disregard this bias? And she said, no.
I thought it was you could. That's what I'm quibbling on, but I just don't think any of those were.
They're talking about eliminating jurors for cause.
15,
all right.
Problem. 15 cannot give the state a fair shake.
And Norma, for Robert Mauer's client, you said the 28th, correct? All right. On Robert Mauer's client as well?
The prosecutors are talking about juror numbers. This is great. We normally don't get to hear this.
Couldn't give the state.
Could I have De La Rosa back, please?
What was the?
Okay. So no,
Like, it was just like she would.
she said she would,
she
and
would
it has a
just-
bias, yeah. I mean, that's,
That's fine,
the
that's
question,
fine.
the question is like
Fine.
a few different ways.
Yeah,
So which one?
15 and 30. Oh, that's agreed.
Agreed, 15 and 30, okay.
Left with that.
I guess I'll go down the list here. So 33, what I have for 33? Oh, religious or moral reasons.
Same thing. Wow, that was weird because the judge asked that.
I mean, I don't care, but I mean, I'm just saying that the judge would probably, I mean, I don't care. But 33, because look, guys, these are for us and y'all.
No, I get-
So I just want to make sure you understand that. This is
No, I
just
have
for us. 34,
All right,
I
let's start
have
with
for
Mr. Prince.
such a negative view, but you said you're not going to agree to that.
On this case, Your Honor, I was just appointed
That was
today.
34,
I haven't seen
37.
discovery. I did confer very briefly with the state before they had to start picking the jury trial. So I'd like to reset so I can get.
Yeah,
time.
religious morals, so y'all don't want to. Okay, the 40,
Sir.
same thing. 45.
Kim.
Norma, I need a 30-day date for discovery.
45 was the
She's buying her way up.
such a negative thing, but y'all don't agree to that. 59.
First week in August.
Yes.
I'm got a vacation notice out there, Judge, for that week. Can we do it maybe August 11th?
This is a
right,
GoPro
let's
charger
let's
and
take time.
batteries.
Y'all want?
Are you able to do it
59?
August 11th?
I'll
No.
keep 59.
All right, it's August
Monday
11th.
back
59.
after that.
I mean,
Right.
That's
All right.
No,
for y'all.
right, that guy, dude. I remember that
It's
guy.
a
Long
for
time
call.
for now.
For y'all.
Yeah, yeah.
You're
So
in.
y'all want 59?
No,
August
just
59.
He has long pain.
All righty.
Alrighty.
Yeah, so I'm,
Yeah, the go would be.
Right.
This
Yeah,
is super
thank you.
confusing, but I love
For,
hearing the
being
audio.
on time. This is going to be your new
59 agreed
attorney.
to?
So make sure he has your contact information. They're going to give you a reset form, so you'll know when to be back, okay?
63 is a
Have any
negative.
questions about anything?
Outlook
Batteries
said
are
All right,
cannot
thank you.
disregard it. It
Kim.
said on this one and this one.
Kim, thank you
So
so
y'all
much.
don't agree to that?
Pretty
Okay, this was the Bear County, you have to, such a low view of the law enforcement of Bear
He just
County.
rated him low.
Right, but then it was rated low here and then said, not disregard, and then it has such a negative thing that I can't put it out.
That's
Yes, yes.
Okay,
unless
so
you
y'all
have,
don't-
unless you have him for something.
But there's someone that's
just
in front of
for
you.
things, and that's
Yes.
60 or 74.
What's with everybody
You'll
having a
have
negative
them
view in
pull
law
the
of
file.
law
For the fair
enforcement
shake.
and getting
All
dentist
right.
appointments?
Yeah, we're agreed.
Gilbert Salinas.
74. Okay, all right. But really, we're only gonna have to go up to 46 anyway. So, okay, all right, we're ready to approach from y'all are, okay? Y'all don't have, well, I'm sorry, y'all didn't have any other ones that y'all want, did you? Probably covered-
You included a lot of ours
Yeah,
on there.
yeah, so I usually get them all, so. All right, guys, full push. Judge, we're ready when you are.
All right. Mr. Pelt,
Yes, Your Honor.
could you give me 5 minutes?
That's right, Mr. Salinas, have a seat again.
They don't know.
So now she goes off the record to for jury selection, but we got to hear a little bit about why they were choosing. A lot of people were being struck for a negative view of law enforcement, and that was quite interesting. Hey, hey, hey!
You may be seated.
What is going on here?
Counsel, as you are aware, we did receive a note indicating that the jury would like to hear Valle's testimony concerning if he knew Tyler DeSilva was on the street when he returned from the Honda Pilot and they crossed paths. Did he recognize that it was Tyler? The video shows they crossed. Well, that was at 2:52. We have spent some time trying to pinpoint the testimony both in direct as well as cross-examination. It's my understanding that we have an agreement relative to the portion of the testimony that would satisfy, we believe, the jury's inquiry, although it seems to be a little bit unclear, but we've done our best to provide a limited amount of testimony, but broad enough to satisfy what we believe to be their concerns. I'll hear from counsel if you have any questions or concerns relative to the testimony that we're about to provide.
The state has no concerns at this time.
The defense has no concerns on it based on the discussions we had.
Okay, very good. So my intention is to bring them in, acknowledge the note, and then let them know that we are going to play a portion of testimony first, which was a testimony clip from direct examination, to be followed by a clip of testimony from cross-examination. All right, so if we could please bring them in.
They're playing video? Okay, so the jury asked for playback of Raul Valle's testimony regarding his knowledge as to, was it Jimmy McGrath? Where he was on the street at the time. We'll have to see exactly what this is. I think the judge will read it one more time. I was expecting a hung jury note, but they're going to town. They're working on this, arguing some of the finer points. I'm going to pause the deliberation timer at 11 hours 57 minutes as the jury is now walking back into court.
So counsel, please stipulate to the presence of all of our jurors.
State will stipulate, Your Honor.
Right, thank you so much. Which exhibit number is this? This will be number 9. Number 9. All right. Thank you. Ladies and gentlemen of the jury, thank you for your continued deliberations with respect to this matter. As I indicated earlier, you do have the opportunity to have parts or portions of testimony played back to you upon your request. I did receive a note which will be marked as Exhibit 9. The time 2:52. It did take us some time to locate the portion of the testimony that we believe satisfies your inquiry. So you're first going to hear a clip of Raul Valle's testimony that occurred during direct examination. And then thereafter, you will hear an additional clip of testimony that occurred during the cross-examination of Raul Valle. Okay? So it is going to be played. There are speakers here. I would ask you to please listen intently. I'd ask everyone else to please try to be silent.
It's going to sound terrible. It might be super loud. The jury's doing the right thing here. Asking for his own testimony. A lot of the decision they make is based on what his thoughts were at the time.
Could you see Tyler De Silva at that point?
At one point, when I was at the car, I looked over and I saw Tyler De Silva.
And what did you see Tyler De Silva doing?
He was also on the ground getting beat on.
Could you tell how many people were beating him while he was on the ground?
I can't give a number.
And do you recall how many people were around you when you got shoved into the car, as you described it?
As soon as I looked back, the first thing I was looking for was Tyler.
Okay. Did you see any of the people that had just been attacking you?
Yeah.
Where were they?
Right on the edge of the lawn on the curb, somewhere on the street going back.
Did you see Ryan Hines anywhere?
No.
Did you know Tommy Connery before this?
No.
Did you know Ryan Hines before this?
No.
Did you know Faison Teal before this?
No.
Did you know Jimmy McGrath before this?
No.
You say you remember getting shoved to the car. Did you make it to the car eventually?
Yeah.
What did you do when you were at the car?
As soon as I looked for Tyler, I saw him getting beat on.
What was Jack Snyder doing?
Nothing.
Did he say anything when you went to the car?
I didn't even open the car door all the way.
Why didn't you just get in that car and leave?
I saw my best friend. He saw me get hugged. Nobody was helping him.
How did you feel?
It's still terrifying. But I couldn't just let him be there alone. I felt like I had to see him.
Did you think that Jack Snyder was going to wait for you if you went back in there?
Objection as to what Jack Snyder was going to do.
Did you have any indication that Jack Snyder was going to wait for you?
No.
You didn't open that door at that point and take out that knife and then go back and stab those poor kids?
No.
You already had that knife when you'd been attacked on the lawn the first time?
Yeah.
Are you sure about that?
Positive.
You weren't upset that you had been attacked and went back to get that knife? Had you known about that knife being in the car prior to that evening?
No.
When you got back to that car, you didn't get back into the car, right? Why didn't you just go running off back down the street, back down Farmhouse Lane or down Laurel Glen towards Farmhouse?
I just couldn't leave it alone.
Why not?
He was my best friend. Looked at him like his brother. What kind of man would I to just leave him there?
What kind of man would I be to just leave my
What did
best
you worry
friend?
might happen to him if you left?
If he was in the same situation as me,
I'm going to object to calls for speculation. This is what would happen with Tyler.
What were you worried about if you left and ran down to the end of Laurel Glen Farmhouse?
that Tyler wouldn't be out of there.
That Tyler wouldn't be able to get out of there.
What happened next?
I found myself right on the edge of the grass on the curb.
Juries ask for a
How did you
readback,
get there?
and they get the audio.
I just remember being there. I think I ran over.
What did you see when you got there?
Just another wall of people.
Did you see Tyler DeSilva?
No.
Did you cross paths with Tyler DeSilva?
Yeah.
You say another wall of people. Did you see Mr. Hines, who had been on top of you before?
I think so.
All right, so that was the testimony of Mr. Valle on draft, and we're now going to play related testimony on police examination.
Jury
At
ask.
some point in time, you say you saw Tyler back on the lawn, right?
Yeah.
You still had the knife on you at that point, right? Knife was still out in your hand, right? And you come back into the fight, right?
Yeah.
Playing with the video.
Now, Tyler's being pushed into the street at this point, right? And you would agree with me that there are no Shelton kids to the right of you, right? There's a car. We can see a car right there, right?
And this looks like
There's kids in front of you, but there's no kids right to the right of you. There's a car. We can see the car. If there were, we wouldn't be able to see the car, right?
that's true.
Right. There's nobody to the right of you, right? There's a kid in front of you.
Yeah, there's a whole bunch of kids right
Right. There's a whole bunch of kids over here we can't see, but there's nobody to the right of you, right?
It's right next to
There's a kid here. But I'm saying, is this you right here? Yes. Right. To the right of you, do you see a kid or a car? It's the street. That's the street, and there's a car there, right? So there's nobody to the right of you, right? There's a car. There's nobody in the street. And there's nobody to the left of you other than Tyler DeSilva, right? Yeah. So when you're going back in, there's a wall, right? It's like this. Right. But you're not surrounded at that point, right? That point, not. No. But you go back in, Tyler's already pushed out into the street, right? But earlier, I'm on my way back, but Tyler is no longer engaged in the fight, right? I don't remember. You don't remember that. So you just blacked out and ran right back into the fold. That's your testimony today? Being on the guard. It was just like a shoe horse of people. A shoe horse, but not a circle. You were not encircled, right? But was there anybody behind me? Right. There's nobody behind you. I don't think so. Right. So you could have, if you chose to, you could have left. You could have retreated, right? So you could not have left because there were people around you? Yes. So you just said there was a semicircle of people on the yard. Now you're saying that you were surrounded. It's like this. So, semicircle, right? Yeah. Not a circle. A circle goes like this, right? Yeah, I wasn't going to turn my back to the many people. You weren't going to I move to strike as non-responsive here.
Nope. Allow it.
You indicated when you made it back to the car, you were still terrified, right? Yeah. You were still scared. You came back in anyway, right? With the knife. Then you ran over to the edge of the grass, right? And you passed Tyler, right? Yes. He passed you on your left, correct? Yes.
All right. So, ladies and gentlemen, the jury, I hope that others. Sorry. Are you sorry? Ladies and gentlemen, the jury, you've heard the portion of the testimony that the court believes was relevant to answer your question. If you go back into the deliberations room and you feel that there is additional testimony that you need to put any of that testimony into perspective, whatever it is you're deliberating on, please just send out another note and we will do our best to answer any questions with any playback concerning any other issues or matters. So, hey, thank you so much. Thank you for continuing to follow the court's proceedings and procedure relative to the jury charge and your duty as jurors. I appreciate it. Thank you. You can go back into your deliberation.
Sort of got lost in that. They're not following the court's proceedings. They should not be. Give them just a minute to exit. My thoughts on this, they're asking about initially I said Jimmy, but it was about Tyler, his best friend, Tyler DeSilva. As the door shuts, we will start the timer one more time.
Just for the record, any comments by counsel relative to the playback?
Nothing from the state, Your Honor. Nothing from the.
And it represents what each of you asked for and what we agreed upon would be played back to the jury with respect to Court's Exhibit 9.
Yes, Your Honor.
Thank you so much. Our court stands in recess.
Okay, so we go back to the waiting period. Let me tell you, the jury asked for the testimony that is relevant to one particular part of the defense of Raul Valle. And that is in the defense of others. They wanted to know if he saw Tyler DeSilva while he was out in the street. And he testified that he did. He looked back. That's the first thing he did. Looked back and saw him just getting beat on. That, to me, is a sign that somebody who feels that this was the action he took to pursue Tyler DeSilva's safety was defense of others. I don't know if this is the majority that's trying to prove the minority and prove it a point to the minority, or if it's the minority saying, you guys, it's right here, it's clear. He says he was trying to help Tyler De Silva. The thing that's going to hurt him, though, is in cross-examination, the state prosecutor comes in and describes that. He says, you're headed back from the car and you passed Tyler, right? And he says, yes. He passes Tyler to return to stab Jimmy McGrath. And now Tyler is free, and that defense of others defense is wavering quickly. So, wow, I think it's 11 not guilty to 1 guilty. Hey, Mrs. R.A. But I've never seen the playback quite like that before, where they just roll tape. I like this better. You get the inflection, you get the pauses, you get the delivery. I think it helps with recollection. If you were there the first time and you saw something and it stuck with you, hearing it again, I think it's better to hear it that way than to hear a court reporter. Great, they do a great job, but hear a court reporter read a transcript, a text version of what happened in a flat, monotone delivery. So. Great job there. This may budge the not guilty for Jimmy's death. It may. They have their own court audio system. They wouldn't pull from a video, from an outside video. Actually, the outside video gets it from the court audio system. So it's the courts first, and then it comes to the... But look at that. The timer just passed 12 hours of deliberations. The jury's still... They might have a question. Oh. Just knocked my little charger off the desk. Charged my little batteries for the GoPros. They might have a question about this and want a little bit more. Like, their question might not have been specific enough, and so they might ask for a little bit more. If so, that's probably not going to happen until tomorrow. If it took them 2 hours, I think she said we got your question around 2:30. That's what I heard. And it took them 2 hours to find the spot on the video and to come to agreements as to what to send in. If they need a little bit more, it's going to take, hours before we do this. So, well, that moves me a little bit from my decision as to what I think is going to happen here. I don't think we're going to be a hung jury tonight. I don't think we're going to get a report of a hung jury. I think the jury is, in fact, taking the charge quite seriously to go back and re-argue this, rethink this, re-look at the evidence, see if there's something you missed, rethink your position based on that evidence. But we'll see. I'm trying to understand the not guilty, but I can't. Nursey Dogma, a couple people have said, you look at the injuries. The only people who went to the hospital were, stabbed. The way self-defense works, and this is the law thing. It's not, like it or not. The law is that that if you are reasonably in fear of your life, you don't have to wait for the person to beat you close to death before you respond. Often, if you are reasonably in fear of your life, and the jury will determine if it's reasonable or not, you can use that self-defense much sooner than you'd expect. You don't need to have significant injuries to show that, yes, this was not just a high school fight. This was a real beating. You don't need that. You just need a jury to say, yes, you were reasonably in fear for your life, because it could be the situation. It could be the situation. It could be just the sheer numbers of people who wanted to do ill, with ill intent towards you, and the ability to do so, and you not being able to retreat. That may be enough to use lethal self-defense. It's not a scorecard where you compare injuries to see who is worse, although in this trial we sort of got to do that, to see the pictures back and forth. Connecticut does have a retreat law. You are required to retreat if you're able to do so. And that can be argued both ways as well, because initially when they showed up to fight, they did retreat. The car was attacked, they didn't get out, and they drove away. And the people from that address ran down after them, and even threw something at the car after them. So you could say they did retreat. Then after it calmed down, they went back, and by the accounts of the people who live at the property, stupid or not to go back, I think it was stupid, but by the count of the people who were at the property, they said they came back and none of them were fighting. They were asking to talk to people. That's not re-engaging the fight. And the people at the party said they threw the first punches there. I think you have to look at that and say self-defense could apply here. This is not, I mean, it was a stupid decision to go back just because everyone's drunk. But I can see this one. Oh, come on. Argue the other side for me. Let's. I'd love to hear it. I'd love to hear it. He was sprayed with WD-40, but they went back to talk it out, so it was not forgiven. Okay, the talk it out part, hear me out. The testimony that they went back to talk it out and they did not start the fight, they did not start throwing the punches. The testimony was from the state's witnesses. The prosecutor's witnesses testified that when they came back, they just wanted to talk. They were asking for Tyler, they were asking for Ayden King. That was from the state. That shows that they were not coming back trying to fight and just angry. I have to believe it. How was he in fear for his life when he went back? I don't think he was. I think he was going to talk it out. I think in his, well, let me say it this way. I think in his drunken state, he thought he was going to talk it out. I don't think he was in fear for his life until he was on the ground getting punched and kicked and stomped. Dimitri's testimony, the boy in the trunk. Artemis, here's what I'll give Dimitris. No deal, right? He had no deal. I don't know when he talked to the police, but he did not have a plea deal. There was nothing he did. His testimony, Dimitri's testimony, differs from the two that have plea deals. He said he had no idea they were going to a fight. He was surprised they took the wrong turn, the same as Raul. I think that was the same as Raul. He does remember somebody looking for the knife and scrambling to look for the knife, right? I have to go back and listen to that one. Artemis, which part of that sticks out to you? Because Demetrius counters the two people that testified against Raul in some ways. Jack said he gave Raul the knife without being asked for it. Raul says Jack gave him the knife without asking for it. It is a mess. It's terrible. I don't like the plea deals. I don't like the fact that people on both sides aren't being charged. I think Tyler Rich wanted to fight again because he was embarrassed. I don't have any testimony about that. I don't know. I have no doubt someone wanted to talk it out. Raul knows he had a deadly weapon. No one else had a weapon. It wasn't out. They all testified it wasn't out. The only person who saw him with a weapon in his hand before that was down at the car where he says it was handed to him by Jack, and he put it in his pocket. And he said he felt confused about it. That's the only time they say they saw a weapon, but it wasn't out then. And yes, it's 0.1 inches over the legal limit for someone his age to carry. So technically it's illegal. But aside from that, it's having the weapon isn't a problem. He's not charged with having the weapon. Let's see. I'm trying to. You guys have some great points here, and some of them might correct me in some things that I've said. So tag me in them if I'm missing something here. Joe, I'm not trying to convince you. I think that the way the law is written in Connecticut, leaves room for reasonable doubt as to whether this was self-defense. Let's see, Artemis, thank you. Dimitri said Raul was very angry about the damaged car and said he wanted to return. Also asked Jack for the knife. Dimitri refused to return because he knew they would all fight. Part of this doesn't stand up very well. Raul, first of all, Jack was not a close friend. He would be the driver whenever they were going to a party, but he wasn't a close friend. If Jack wasn't upset about the car, I don't know why Raul would be upset about the car. And if Raul was upset about the car, why did the kids back at the house when they went back say that Raul was, acting silly, had his shirt pulled over his head, is what they said. Raul said that didn't happen, and was asking for Ayden King, which was the only person he knew at the party. Why would the people at the house say that if Raul went back there just looking for vengeance? The story doesn't add up for me. I do believe that Dimitri wanted no part in the fight. Didn't Tyler say he wants to go back? Yes, he did. Tyler De Silva knew Tyler, who lived at the house. They were going to talk it over. Let's see. They went back down there for a fight. He took a weapon, which is okay, and he saw Tyler on the street. As he passed him, he went back in and stabbed people. The part that's a problem, seeing Tyler on the street, this is the Tyler he saw was the Tyler he was supposed to be in defense of. According to the law, I don't see a reason for Raul Valle to go back in that fight if what it sounds like he testified to on cross-examination, if he saw that the person who was getting beat, his good friend, they would know what sort of man would leave your friend like that. If he saw Tyler free of that engagement and headed out to the car, if he saw that, the grounds are gone. If that's what he's testifying to, and I'm a little confused on that front, but if that's what he's testifying to, then I don't think he has a standing for self-defense. The threat is eliminated to Tyler. There's no current threat to him. He is able to retreat in that moment. I just not sure. Raul wasn't even beat up. Doesn't matter. There are situations where you can kill someone in self-defense before you've been hit. That's the law. If you've got a reasonable person, and this varies from state to state, I'm not trying to give you advice on self-defense. Consult a qualified self-defense, attorney for that. But there are laws in most states where if a reasonable person is in fear for their life, they can use lethal force in self-defense. It doesn't have to be proportional. This is not England. We don't have to use a newspaper to fight off somebody with a newspaper, or a spoon to fight off somebody with a spoon. That's not the case here. Agree that 1 point I think can convict him, Artemis. If they come back and convict him for murder, and I can see this happening, I think it will be because he testified that Tyler, his friend Tyler De Silva, was on the street and he passed him going back into the fight. The only reason I'm confused about that is because literally like a second before in the video, when he's been shoved out to the car and the door opens a little bit and he looks back and the video pans over where he's looking. Tyler De Silva is on the ground getting beat at that time. That's why I have a hard time with the prosecutor saying, and you came back and past Tyler. Tyler was on the ground in the video. When it pans back around, Tyler has not walked by. So I think that it's self-defense. And not England. How very dare you? I'm just saying the laws are different in other countries, and in this one it's different. All right. He wouldn't have been in fear if he didn't put himself back on the lawn. He chose not to sit with everyone else and avoid a fight. His rationale, as stupid a decision as it is, was not illegal. It was stupid. But he went back to talk. And I have to believe him because he testified of that. Tyler De Silva testified to that. And the people who were at the house where he went back to testified to that. I've got to believe he went back not intending to fight because everyone agrees. Let's see. Tyler didn't take a weapon. Your fist is enough of a weapon. A single punch can kill people and has. It doesn't have to be a equal weapon for weapon. If he left Tyler to go back alone, Tyler would be dead right now. That I couldn't say. No one would know. That's a possible outcome. Arguably, if he didn't go back when Tyler was getting beat, that's an outcome. Hang on. Let me plug in the phone so this will work properly. Just 1 second. Got a call. Hello.
Hello.
Hey, how's it going?
So I had to call in to kind of
This is Amber,
talk
by the
this
way.
out because
If you don't know, this is
yes.
Amber.
Hello, everybody. So I understand what you're saying here. However, the first fight happened at the other house where Ryan was, who retreated to the Rich's house.
Okay.
So Ryan gets jumped at house number 1 and runs to house number 2. The rest of them that showed up in that vehicle were at house number 1 where Ryan got jumped. The problem here isn't necessarily murder. The problem is accountability. Without considering what anybody else did, you've got to think of just one person. One person's actions, not what everybody else did, because they're not on trial. I don't like the deals that were given at all, but I can't help that.
Right.
The deals don't factor into the accountability that the defendant has or doesn't have. Okay? And if y'all are arguing with me in chat, I'm sorry I can't see the screen, and I'm just thinking it out here.
We're getting a lot of
Ryan
agrees.
got jumped at house 1. Mm-hmm. Ryan gets jumped at house 1, runs to the Rich's house, and then here comes the same people that just jumped him come into the same house. Regardless if any of them had mutual friends at the second house, it's irrelevant. The kid retreated to the Rich's house. He already got jumped once.
So
we have kids, we have teenagers doing adult things like drinking alcohol and making bad decisions when drinking alcohol. There is some accountability here on Raul's part. It's not murder, in my opinion. I think there's something reckless here. How many people were told by their parent, and my mom is listening, and I'm pretty sure, you are who your friends are.
Hi, Mom. Yeah, go ahead.
You are who your friends are. And not everybody's going to be able to bail you out if you do something wrong. You've got to own your own mistakes. Yes, it was a stupid decision. Stupid decision. But play stupid games. You win stupid prizes. I'm sorry, not sorry, and I ain't sorry about that either. Y'all drank. Every one of them drank. Y'all got into a fight at one house and then decided to go to another. There was no objection by anybody other than Mackenzie, from what I remember. Correct me if I'm wrong. And potentially Dimitri in the back. Mm-hmm. And it's not a trunk, it's a hatchback. So
it's a trunk. They testified it was a trunk.
I know. The only two people that voiced or expressed an objection to any of this was Mackenzie and Dimitri in the back. Nobody else had any kind of objection. We're just going to go talk. Now, this is 16, 17, 18-year-old boys who are jocks, because we're just going to call them like we see them.
Right.
They're all jocks. They all play multiple sports in most of their cases. So you have a bunch of hotheads that have now drank and have gotten in one fight at one house and are now coming to the other house. What did we think was going to happen? Had a parent known what was going on, I would hope a parent would say, don't come to my house.
Yeah.
But we can't have the parents part of this either, because the parents aren't on trial. I have my opinions about that as well, but we won't go there. So
there have been some charges, and there are definitely some lawsuits.
There have been some charges. There have been some accountability that has been taken on other parts. However, we can't consider that when deciding what accountability Raul has. He pulled that knife out of his pocket. I don't care who gave it to him or when he had it. He knew he had it. He went back to a house where the one jumped victim retreated to, and then got into an argument. They took off, and then they came back again.
Oh, we've got court movement. Amber, we got to go.
Goodbye.
Okay, bye. Waiting for audio. We don't have audio yet. I'm with Amber on all that, except for, I believe, from a legal standpoint, each engagement is separate. So I think there are 3 engagements legally that took place in this story, and he's not charged with the first one. So Ryan Hines jumping Ryan Hines would not be considered the same fight. Can we get some audio here? Come on. Jury's coming in. Do we have any audio here? Nobody has audio. No one has audio. So we're going to have to read lips. Here we go. There we go.
Please stipulate to the return of return.
It will stipulate, Your Honor.
Thank you. Ladies and gentlemen, I do have to close the facility and get us out of here by 5 o'clock, so I'm going to go ahead and direct you to adjourn your deliberations for the day. I just want to remind you, obviously, follow and continue to follow the rules of juror conduct. And also remember that you can only discuss this matter with each other when all 12 of you are present in the jury room here in the courthouse, okay? Thank you very much for all the time you are giving to this matter. We all greatly appreciate it. Have a good evening, and we will see you back tomorrow. Thank you so much. Court stands adjourned.
All rise. Court's adjourned.
All right, Amber's calling back. She wants to finish us off here. Give us a second. Amber, hang on just 1 second, because I think they might just say something to the 2 sides here, but maybe not. Okay, I think we're adjourned for the day. I think we're done. I'll keep an eye on it.
I wanted to finish my thought.
Okay, finish your thought. Finish your thought.
Okay, so with what you said with regards to their separate incidents, yes, they are. Do I think he should be held accountable for all of them? Not necessarily, because it depends on where these instances happened in this fight. At some point, I do believe he feared for his life. However, when the threat stops, you don't just keep swinging your arms, right?
So
if there's
the 3 that were stabbed and not killed were during. He testified he was on the ground. We have a lot of lower body injuries. Faison, I think, testified he was stomping over him when he got injured. He was stomping on him. Didn't even feel the getting cut at the time.
For those asking, yes, I have been jumped.
Yeah, me too. It's not fun.
I have been. It's not fun. But you know what I didn't do? I didn't have anything on me. Well, at the time, I did have knives in on my person, but that wasn't something anybody knew and I could get in trouble for. So I ended up hightailing it out of there because I can run. So it's not, everybody's looking at this as but it wasn't his knife and he didn't willingly take a knife. It was given to, I understand all of that. When he's defending himself in the moments that he is defending himself or defending Tyler for that matter, fine. But Jimmy McGrath was an innocent bystander. When somebody is in a shootout and a bullet ends up going into a random house and kills a 9-year-old kid, this has been a case, they're charged with murdering that 9-year-old kid. It's their reckless decision to do what they did, regardless of the consequences, regardless of who else it could hurt, without thinking of the safety of anybody else, because they have a one-track mind to go do what they want to do. So at some point, you have to be accountable. So do I think it's murder? Absolutely not. But I do think it's reckless endangerment. I think he needs to be held accountable for reckless endangerment. You cannot go into a fight, pull out a knife, and just keep swinging until you feel like stopping. The threat stopped before that.
You also can't hit somebody who isn't threatening you.
Right.
And you can't stomp on them when they're on the ground. And you can't gang up on them and fight them. All of those, in that moment, he could have shot every person that, if he feared for his life, he could have shot and killed every person that was attacking him under the law. And if the jury finds he reasonably was in fear for his life. So
they are each separate instances. I do agree. Yeah. But again, Ryan was the one that got jumped at house 1 and the rest of them followed over. They ended up taking off when they were being run after and throwing stuff after the car.
Well, they followed after because they were invited to a group chat and told to pull up and said, "Hey, let's do this." But the group that they were told them to pull up, everyone was expecting them, and they knew it was going to be a beatdown. They were going to jump the 3 kids that jumped them. It was payback time. All right, let's go. Right.
And I'm not saying, there's some saying that they disagree. They think everybody should be held accountable. I don't disagree with that, but that's not who we have to hold accountable here. That's not who we are deciding accountability for right now. It's one case with one defendant. I can't control anything else that the state does or doesn't do.
Yeah.
That's any case. That's the point.
I hear you. There's a lot of accountability that should be passed around here, and I believe Raul has a measure of that.
A measure. I'm not saying the extent of murder.
Yep. Amber.
But I think there should be a reason. I'm sorry. I think there should be some accountability on his part. I just think it was reckless endangerment.
Yeah.
Which isn't nearly as bad as murder. And Amber, he may be able to do probation or something. A kid died.
Yeah.
Yep. And you're responsible for that.
Yep. Thank you very much, Amber. I've got somebody who's trying very hard to get through, so I'm gonna let you go.
No
Thank
problem.
you. Thank you very much. You're amazing, Maud.
Bye.
We love you. Bye. Hi, Amber's mom.
Love you.
Bye.
From
Melissa.
Here we go. Melissa, are you there?
Hey, man.
Hey, make sure you've got your volume turned down, or else I'll get really confused.
Let me turn this. I got you. I've agreed with Amber on pretty much 99% of what she said. But here I have a problem because I think about the Kentucky sheriff judge killing, holding...
Sheriff Steins or something?
Yeah, and a kid that age, when he is filled up with that emotion...
Or liquor.
Liquor, testosterone, who knows what else. I mean, he probably, by the point I mean, I know he stabbed a kid. I know he killed a kid, which is absolutely horrible. But is there not some type of law that comes into accountability for somebody not being able to control their emotions at that point?
Well, it's their actions that the law is going to address, and if you can't control your emotions and you lose control of your actions, and your actions end up taking someone's life, that's where the murder charge comes in.
Well, yeah, and I get that. It's just, I'm just thinking sometimes when emotion takes over, he saw his friend getting beaten up, he was beaten up, and things just got out of hand. I mean, I believe he should be accountable. Yeah. This is not murder. I don't believe this is murder.
Maybe a lesser included.
Yeah.
Excellent
possibly,
point.
Yeah.
Excellent point. Thank you very much, Melissa. Appreciate
You're quite welcome. Bye.
All right.
Bye.
Bye-bye. All right. Thank you, Melissa. Thank you, Amber. I know there's one more person who's been calling, trying to get through. Lily Balm, yeah, that would be interesting. On one side, Raul might tell you that that he might not be here today if there was no knife. On the other side, might say, could have had a couple bloody noses and broken eyes, bruised eyes or something, black eyes. Nobody knows, unfortunately. Maddie's trying to call. Tell him to call again. Maddie, the phone lines are free. Use the hotline number. Whole situation is very sad. More than Raul should be charged for something. I agree. But Raul is in the wrong. I'm not trying to defend this kid and think he's some sort of angel. It's not connecting. That was somebody with a 44 area code, so that was foreign. Let's see if it tries again.
Call from
Maddie.
There he is, Maddie. Maddie, how are you doing?
Hey, I'm good. Okay, my turn. I completely disagree with everybody that is called today. This kid is not guilty. If you look at the definition of self-defense, it is anybody that was in reasonable fear of bodily harm or injury that could lead to death. And if you look at it, 10 versus 1 is definitely that way. And you could add the duty to retreat. When you're on your back, you can't retreat. Yeah. That knocks that out there, right there. And when he's laying on his back or in the fetal position, he's got his arm out, he's swinging it around, and people got clipped.
I'm firmly with you on the 3 counts. I think those were all self-defense, clear as day.
Well, and then when he goes back in to save his buddy, when, as you see in the video, he's being jumped by a group of kids. He goes back in to get him, and he was defending his friend to get them both out.
The problem I have there is,
go ahead.
We got word, he knows that he got hit, or he thinks he got hit or something when he went back in and he swung. You can't just stab everybody in your way, like clear a path, I'm going to go save my friend, right? You can't just, I'll just chop down the field ahead of me to get to him.
But if there are, like you saw, there is a group of kids on top of him, and they had just pushed him out, too. They were still attacking him, so as he's going back in the heat of the moment, he's thinking, my friend, they just did this to me. My friend's on the ground. They're doing the same thing to him. I have to get to him by any means necessary. And look at Rittenhouse. You could take the fact that Rittenhouse was, running away from these people. He's on the ground, and they're still attacking him. So it's kind of the same idea, though.
Yeah, Rittenhouse is going to open up a can of worms for sure. That was a tough one.
Well, and you look at Rittenhouse's first kill. He shot the guy 4 times. and one was only the kill shot. And what was going on? They were all coming after him. It's kind of the same parallel. Or if you want, like I said before,
I can't argue Rittenhouse on this one. I've got to steer clear of that one.
Of course. Or like I've said before, the old man in the movie theater in Florida, where he was being attacked by a bigger guy. This was a frail old man in a movie theater, thought something was happened to him. He was being attacked by the guy sitting in front of him. He pulls his gun out and shoots him. And you could make the same argument.
Well, you've got to convince a jury that a reasonable person would be in fear for their life.
Well, if you put 10 people, I mean, the reasonable person would think 10 people are beating him up, and he
I think
has
that's a much
nowhere
easier
else to
argument than the popcorn guy in the
go.
theater.
Of course it is.
Yeah.
But the popcorn guy walked away with self-defense. Yeah. So this actually makes his argument even easier.
But it's a different state with different laws. Florida has, I think Florida is a stand your ground state, where Connecticut has duty to retreat.
But when you're on your back, you don't have the ability to retreat. You're stuck.
But I think that only applies to the first three. Even Raul's own testimony was that he was there was a semicircle around him before he stabbed Jimmy McGrath.
Well, it's one of those that it's kind of you've got a bunch of people attacking you, and yes, if he's laying on the ground still, that's kind of where the if has to lay is, does the jury feel that being, for lack of better terms, unable to stand up and walk play a factor into it? At least that's the way I see it.
Let me read something in the tea leaves here and give you a hot take on this. If the jury is deliberating still and they're still hung up on this one issue, and we know at one point they were hung on all 4 counts, but now they're back to the murder charge, and they want to hear about what Raul saw with Tyler De Silva while he was out at the car. Basically, what was in Raul's mind right as he went back into the fight. I think they've probably found not guilty on the first 3.
I would assume
those are
so,
self-defense.
I do too.
But this is a tougher one. This is a tougher one. I can see it argued both. I can argue both sides on this one. I can see.
So could I. And you know me. I usually argue both sides. But the way I look at it is that they have the in self-defense of others, and I think that's where the whole curveball to this is. It's not one way or the other, and it really sucks that the kid died. Unfortunately, it might have been him or Raul or Tyler De Silva. Yeah. I mean,
or Hines.
Now one life over the other doesn't.
It could have been Hines when the helmet, the headbutt.
It could have been.
Could have been enough.
Well, I mean, if once the helmet came off, if that laid out the kid, then this whole thing would have been over.
Yeah, crazy. Maddie, thanks
and
for. Sorry. Go ahead.
Real quick, and saying that they went to that for looking for a fight. They were antagonized over there.
I would agree.
They were and that right there really sticks in my craw is the fact that it's like, come to us. And, they were planning on messing with these kids when they got there.
Yep.
So, all right.
Thank you, Maddie. I appreciate it.
I heard Amber and Melissa saying that, and I'm like, no, I'm up on arms with this. My turn.
It's all right. We love all the opinions. Thank you very much, Maddie. Good talking to you. We'll see you.
Bye. Love you guys. Bye.
Love you. Bye. Sherry Max says, need to know, please, when Raul was on the ground on the back, were those stabbing movements he was making up and down with his arm? I need clarification, please. This was a point of the testimony I really struggled with because Raul testified that I was flailing my arm around. And those cuts are not flailing cuts. They were stab, 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 which means he could have been flailing his arm around like this and stabbing somebody, but yeah, not sure. Okay, we've got a overseas call.
Welsh lady.
Welsh lady. Laurie Ross. I'll get to yours in a minute because Welsh lady's calling long distance. How are you doing?
I'm calling. Hello, Scott. Hello, everybody. Hello, Pat. How are you? Are you okay?
We're doing great.
I'm going to tell you something.
Yeah.
Every time I get through to your answering machine, right, when you're on a call, it still charges me. I think you need refunds.
I listened to each of them.
Because I called 7 times.
Oh, no.
But I don't leave a message.
I
should start leaving you really long messages.
You should know how many times it rings now before you get the answer machine, and hang up before then so you don't get billed. Hang up early.
I don't know. I'm just waiting to say my name. I don't count. And then I think, oh, shoot. I'm not leaving a message. I'll ring back. And I'll give it a little more time.
We'll have to give you.
Times,
we'll have to give you like your own dedicated line that always gets through. So we'll treat you like a spam caller. Yeah. I answer all spam calls.
Treat me like a spam caller, or a lamb caller, right? And you can have my ringtone as a sheep. You know, so you know,
Welsh
like you can yeah, you know, so you'll be going, oh, it's a Welsh lady and answering no calls.
Well, Welsh lady, I'd hate to have you run up a huge bill and not get your point out. What would you like to share about this case?
Listen, my lovely, I'm only messing with the things about money. I don't give a monkeys about that.
Okay.
Don't worry about that at all. I'm just making a joke. I'm actually just wanted to talk. I love listening to all this because I think that Golly May. I don't know if that's how you say your name, but
that's how I say
your name. Golly May. Hey, Golly May. Yes. I love her. She's lovely. Sorry, I got distracted. So, yeah, I'm listen to everybody's call. And Amber, bless her. I love Amber as well. And I understand she's pointing out things don't need to listen to. It's not relevant. It's not about this. It's not about that. Sometimes it comes across, and I'm not saying that Amber came across this way, but sometimes it comes across as heartless. You have to be a little bit heartless at times and go, but that person does not the person who died. I'm not saying that, but the parents, that they don't matter right now. You know, it makes you sound a little bit heartless.
Yeah.
But you're not being heartless. But you have to, you know, to get to the law and what have you. Now, the judge came out when she came out and she said that they wanted a playback of the testimony. And I generally heard what he was saying on direct. Raul was saying about the whereabouts of Tyler and not wanting to leave Tyler there, and what kind of a man would I be if I left Tyler there.
Right.
And I remember watching that testimony when it was happening, and then you had the cross then, like you said, contradicted it a bit, you know. There's a little bit of
you painted the story very differently
when he said, yeah, but I'm going to have to throw something out there. It might be me, but you know, it might not be, and I don't know. So I need the help of others. So, like you said, it could be in the defense of others. But when the cross part came out, and he said, he saw Tyler and he walked past him. I remember watching this part as it was happening and listening to the prosecutor, and he kept going over the same old ground, the same.
Kept saying the same thing.
So you went. So Yes, he was saying, oh, you were at one point he was being stomped on, beaten, punched, everything else, and I truly believe that's self-defense. I truly do, and I do believe he wanted to go talk. I agree with you. The prosecution witnesses said the same thing, and instead he got a wallop across his head for it, and then beaten up. I would be terrified. All these people around me, and if I had something in my pocket, I was just even to scare them. Then I would use it, and that's the way that I think. Flailing your arms around, I don't know. You must have been terrified, right? If that's the case.
If that's the case, right? I have
Then he was
some
going
issues
back.
with Raul's
Then
testimony.
you go to the.
Yeah.
Oh.
Sorry, go ahead. Did I lose you, Welsh lady?
No, you said you had some issues with Raul's testimony.
Yes, particularly with the testimony about the video from the first fight, where he says he pushed him, and you can clearly see he winds up and throws a haymaker, and cold cocks the kid.
True, but like you said, he's not on trial for anything to do with the first fight. It's irrelevant.
But it goes to his credibility, though. Yes, you're right. It goes to his credibility, but we're at a separate incident. Yeah.
Right. So there's that one. Then we're driving, and I think we stopped somewhere in a car park with other people in a cars, and with group chats going on. We're being invited back to this place, going to the house on an invitation, allegedly, and to turn out to have the car basically pummeled with beer cans and everything else.
Yeah.
They retreat, like you said. They got chased.
Mm-hmm.
He got sprayed in the eye with WD-40. Right? You're attacked.
Now he can blink super fast. Oh, sorry. That joke's not very good. But.
Yeah, his eyelids are not squeaking anymore.
Yes. Yep. Yeah. I hear you.
But with the prosecutor, what I'm saying is with the prosecutor when he was talking to him about, so you're back, you're on the floor, blah, 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 and then he would talk about the horseshoe, and the prosecutor semicircle. There was nobody to the left of you, there's nobody to the right of you. But you could see on the picture, but he was saying there was.
Right.
But he kept saying the semicircle, and Raul was saying like it was a horseshoe shape. It wasn't a semicircle. It was a horseshoe shape. He felt that he surrounded, and then the prosecutor would go and start again, and I got lost in that. Yeah. I got completely lost in the prosecutor trying. I'm like, which part are you at in the garden story? Are we at the first fight where the knife is actually taken out?
Yeah.
Not the first fight, the second part where he's being beaten up on the floor and he takes a knife out and he stabs 3 people and
that was smart prosecutor work, honestly, because that's the weakest point in Raul's story.
It seemed like trickery.
Oh, it was.
It seemed like trickery.
It was,
to
and
me.
he would try to. He was so quick to object to anything that was not the answer he wanted, and he constantly tried to twist the words.
Confusing.
I think he was.
Yeah,
I think that was
he was confusing Raul on that stand. You could see it in his face. It was like almost like he was working out like what part. Yeah, I saw Tyler. Yeah, you could see he seemed like, and after what he said to the jury, well, I was just absolutely gobsmacked that he wasn't admonished by, that he should have been, because,
There's only going to be... It only happens when defense objects, and defense did not object. So
I know. Why? And that was my thing. Why didn't they object? I was going to object.
It's got to be trial strategy somewhere, but I just don't understand it.
My son, I think to my son, what if it was your son? What if it...
Yeah, that was wrong.
Of course, morally, to everyone, what if it was your son? What if, I've got a kid the same age, or if it was my son? What would I feel? What justice would I want? Of course.
The equivalent of that...
to sympathies.
The equivalent of that would be if the defense attorney got up and told the jury, how would you feel if you wake up every morning having to realize that you've locked a kid up for the rest of his life? How do you feel? How will you feel tomorrow when you realize you've locked a kid up and you might be wrong about it? How do you feel? You can't do that. You can't use emotion to make the decision. It has to be based on the facts of the law. So,
I just thought it was so inappropriate, and I'm really glad so you do think he was trickery at that time, that he was talking to him, because I think it was that time that they're referring to was when he was like getting confused.
I think it was deliberate.
This is
one of the things you face on why we say it's a bad idea to take the stand in self-defense, or it's a bad idea to take the stand in your own defense. The exception is self-defense, because oftentimes you have to do it. But
he needs to be accountable.
Yep. Well, Speedy, I've got to wrap things up because I've got somebody here that I'm doing a consultation for video. I'm so sorry.
You're not allowed. International call you 7 times.
Yes,
all right, my lovely.
I love you. Thank you very much. It's been a lovely 12 minutes. Thank you, Welsh Lady. We'll see you.
Bye, chat.
Bye. Love Welsh Lady Reads. She's on YouTube. Welsh Lady Reads as well. Yes, she is Welsh. That is her normal accent. She's softening it for us so we don't get the full effect. All right, I do have to wrap things up. I do have a thing going on tonight where I've got somebody here to talk cameras and stuff for their YouTube setup. So that'll be awesome. No verdict yet. The jury's deliberated for 12 hours, 21 minutes, and 21 seconds. That's 1, 2, 2, 1, 2, 1. That's a lot of ones and twos. So we'll be back at it tomorrow. I think we'll have a verdict or a hung jury by then. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning, same bat time, about 9:30, 9:45, right around there. And hopefully we'll have an answer from this jury as to where they stand and what the fate of Raul Valle is going to be. Thank you guys. Be really good. Maddie says, lies, all lies. Okay. Thank you, Maddie. Good talking to you. If I know there are a couple people that have been offended by something that's said in chat, reach out to me. I might have missed it. We like to make sure that chat is nice to everybody. But reach out to me on the burner phone if there's any problems. I'd love to sort it out personally if I can make it better. That said, have a wonderful night. We will see you tomorrow. Be good to each other. Bye-bye.
Shame on you, sir.
I don't like podiums, Your Honor.
There's nothing in the order that restrains you from talking to cats.